Court officer.
ಸರ್ ಆಡಿಬಲ್ ಇದೆ, ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ತಮ್ದು. ಲಿಸ್ಟ್ ಇಲ್ಲ ಲಿಸ್ಟ್ ನೀಟ ಲಿಸ್ಟ್ ಇಲ್ಲ ಇವ್ಯಾರು ನಿಮ್ಮ ಫೋಟೋ ಇಟ್ಕೊಂಡ ಗಿರೀಶ್ ಶೇಖರ್ ಫೋಟೋ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟ ಅಫಿಷಿಯಲ್ ಫೋಟೋ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟ ಟಿಪಿ ಬಂದ್ಬಿಡ್ತು ತೆಲಿನೂರು ಎಲ್ಲರಿಗೂ ಹಬ್ಬದ ಶುಭಾಶಯಗಳು.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Told fresh matter.
GMCP fresh matter, my lords.
End of fresh matter, election matter.
Madam.
Yes. Adjournments, page wise. Preliminary hearing, serial number 15.
Serial number?
Number 16 to 28. Number 29 to 34.
Actually, serial number 34, kindly tomorrow, my lord. It is misplaced, my kindly tomorrow, my lord.
Lord Counsel for the petition seeks time list on.
34.
With this 15.
7.
Serial number 32, my lord.
Yeah.
On behalf of Gaurish Kashampur, my lord, I am appearing. My lord, his uncle died, my lord, yesterday night. May be taken next week. My lord.
Lord Counsel for the
32.
respondents 2 and 3 seeks time list on.
Stand 21.
Yes.
Number 35 to 36.
Serial number 36, your worship, sir. Kindly have it on 22nd next week.
Mitesh Padial. Lord-
My lord, I have moved the matter, my lord. It is matter of 2017.
Huh?
All sweepers are there, my lord. There are 10 petitions.
ಯಾವತ್ತು ಬೇಕು ರವೀಂದ್ರ ರೆಡ್ಡಿ?
22nd.
Huh?
Next week, 22nd.
Lord Counsel for
All
the
are sweepers,
petition
my lord.
seeks time list on 22nd. Yes.
Yes.
Number 37 to 39. Number 40 to 45.
40, serial number 43, my lord. Gaurish
40?
Kashampur. 43.
Lord Counsel for the respond number 3 seeks time list on.
22.
Hmm.
21. Number 46 to 52.
51, my lord.
Hmm.
Next week. Gaurish Kashampur.
Lord Counsel for the respond number 3 seeks time list on.
51 and 53, my lord.
51, 53.
Please.
Serial number 49, my lord. Serial number 49,
Ah,
short date. 49.
you're for the petitioner.
Yes, my lord. 40.
Lord Counsel for the petition seeks time list on.
Stand 20 to 1.
Hmm.
There is an interim order.
Interim order granted election. Yes.
Number 54 to 56. Number 57 to 62.
61 to 64.
60?
61 to 64, my lord.
ನೀವ್ಯಾರಿಗೆ?
Taken up next week.
ನೀವ್ಯಾರಿಗೆ?
Petitioner.
ಶಿವಪುತ್ರ.
He's out of station.
Lord Counsel for the
Interim order. Granted early
61
election.
61 and 60.
Petitioner, my lord. Shivaputra Sanguli Narayana.
Already 61. Any objection? 61 to
My
64.
lord, small.
ಯಾಕೆ ಟೈಮ್ ಏನಕ್ಕೆ?
Or out of station. I guess.
Small submission.
Next week.
Counsel for the petition seeks time list on date.
Interim order.
20 to 1.
Interim order extended to the next date.
I am Sangoli Narayana, sir. I am at Tirupati. Next week it may please be taken over.
Hmm.
20 to 1. 65 to 70. 71 and 72.
My lord, serial number 69, I am for respondent number 5, my lord.
Ah,
Kindly next week, my lord. Recently I have had wakalat.
Lord Counsel for the respond number 5 seeks time list on.
20 to 1.
Yes. Correct.
List number 1. Orders on complaints of office application first time. Serial number 1. Shivkumar Malipati.
1 week time is granted to do the need.
Serial number 2. Amir.
Same.
4 times. Serial number 3. Lakshmi. G.
1 week time is granted to do the needful, failing which the petition shall stand dismissed without reference to.
Orders matter serial number 4. G.G. Chivishetty.
Shetty,
Waiting for the petitioner, my lordship. A week accommodation may be.
1 week time is granted to do the needful, failing which the petition shall stand dismissed. Yeah, IA for recall and reopening.
Recalling.
For real.
I have lost my file, my lordship. I will.
IA 2014, madam, ಏನಾಕಿದು?
File is misplaced, my lordship, so.
Huh?
File is misplaced.
IA two of 2015 is filed. 2015 ah? IA two of 2015 is filed for continuation of delay in filing the application to recall the order dismissing the petition for non-compliance.
Non-compliance.
Non-compliance of office objections. Though the cause shown is not justified yet, in order to provide an opportunity to the petitioner to contest the petition on merits, IA 1 of 2015 is allowed, notwithstanding the office objections raised thereon. IA 2 of 2015 is filed for recalling the order dated so and so. The cause shown for not complying the office objections is perused and the same is accepted. Since IA 2 of 2015 is condoned, is allowed, and the order dated so and so is recalled, the writ petition is restored to file. 1 week time is granted to comply the office objections, failing which the petition shall again stand dismissed. Ivatte ಕಳಿಸ್ಬಿಡಿ file. If office objections are complied, list for preliminary hearing on date put.
22-1.
22-1.
Number 5, Hitesh Padia.
I appear for the petitioner, my lord. Respondent number 6 is avoiding, my lords. I'll take out hand summons.
Yaar respond 6 yaar.
Private party, divisional controller. Divisional controller Ballari, my lord. Chandrasekhar S, divisional controller Ballari. Respond number 6 minutes.
Is it still the division controller?
Please, my lords.
The front counsel for the petitioner seeks hand summons to respondent number 6. Office is directed to issue hand summons to the respondent number 6. Still connected only 5.1 12 unclaimed. The notice issued to the respondent number 12 is not claimed. Hence notice to the said respondent is held sufficient. Office is directed to show his name in the cause list and also indicate that notice to him is held sufficient. Yes.
Oblige. It may be taken up on 29th.
First take out hand.
Please, oblige.
Number 6, Sangana Baswa Party.
Memo is filed to withdraw the writ petition. In view of the memo, the petition is dismissed as withdrawn.
Number 7, Ramchandra K.
Well, kindly grant week's time, my lord. We'll need
1 week time is granted to do the needful, failing which the petition shall stand dismissed against respondents 2 to 4.
please, my lord.
Number 8, RJ Busare.
Appearing for
The
petition.
memo is filed to withdraw the
Lord,
writ
I
petition.
have filed a memo, my lord, with seeking liberty to file fresh, my lord, because the department have assured that, my lord, they will take a decision, my lord, the promotion of the respondents.
Memo is filed by the learned counsel for the petitioner, which reads as follows. Copy memo. View of the memo. The petition is dismissed as withdrawn. However, liberty is reserved to the petitioner to file a writ petition in the event of the respondent number 2 failing to implement the communication dated 19/10/2024.
Please.
Number 9, Harshvardhan Mali Party.
Pass over.
Blood.
Comply ಮಾಡಿ. Office.
I have filed, my lord. Amendment cost title I have filed, my lord. Today I filed in the registry.
Amend the cost title.
I will carry.
Pass over.
Yes. Number 10, Satnash
This
Vivek
case,
Kumar.
my lords, Annexure D, my lords, is the calculation sheet produced, my lords, in some portion it was.
You know, what is a legible copy of annexure D?
Please, my lords. That is a calculation sheet, year, monthly,
In 33C na ಇದು.
yes, ma'am. 30. Application.
ನಾನು
annexure
ಕಾಣದೇ
sheet.
ಇಲ್ವಲ್ಲಪ್ಪ. Want to produce a legible copy, at least a typed copy. Typed copy ಹಾಕ್ಬಿಡಿ. ಬರ್ಕೊಳ್ಳಿ, counsel for the petition is directed to comply the office objection.
Two weeks, ಸ್ವಲ್ಪ ಅದಕ್ಕೆ tabulations ಜಾಸ್ತಿ.
ಹಾ?
2 weeks.
ಯಾವತ್ತು ಬೇಕಾದ್ರೂ ತಗೊಳ್ಳಿ. List after 2 weeks.
Please.
Serial number 11, Ravindra Reddy.
Ravindra Reddy.
Madam, note kindly pass it over,
Password.
please.
It's under Surface Act, my lord, as per my
I
instructions.
see no password.
Hearing interlocutor petition, serial number 12, Mahadev Patil.
It was,
A 1/24 is filed for condemnation of 425 days in filing the application to recall the order dated
for non,
29/2023 by which the petition was
dismissed for non-compliance of office objections.
for non-compliance of office objections under Rule 14(2) of Chapter 12 of the Karnataka High Court of Karnataka Amendment Rules 2022. The cause shown for the delay is produced and is accepted. Hence, IA 1/24 is allowed. Sorry, and the delay in filing the application is condoned. IA 2/24 is filed for recalling the order dated 29/2023. The cause shown for not complying the office objections is produced. So though the same is not acceptable, yet in order to give an opportunity to the petitioner, the same is allowed, subject to payment of cost of rupees 500 payable to
Advocate liability fund.
advocates liability fund.
Please.
Serial number 13, Biradar Sharanappa.
Biradar Sharanappa.
Statement of objections, sir.
Yeah. ಏನಿದು?
Service matter.
Query is pending or what?
My lord, we have taken a decision to dismiss him from service,
Huh?
which has been, management has taken a decision to dismiss him from service for unauthorized absence. Decision taken by management is referred to, my lord, government for approval.
But in the meanwhile, why can't you pass an order regarding provisional pension?
My lord, since we have taken a decision for dismissal of service, my lord, no question of,
That is yet to be decided.
it has to be approved by the government.
Government value provisional pension ಕೇಳ್ತಿದ್ದಾರೆ ಮಾಡಿ. Suppose if the government does not approve it, then again he has to come for provisional pension, is it?
Provisional pension, my lord, since it will be contradictory, my lord, our decision.
That
will be
contradicts.
Okay.
Provisional pension ಇದೆ ಅದಕ್ಕೆ.
Both proposal, my lord,
Provisional pension ಇರೋದೇ ಅದಕ್ಕೆ. Please read.
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಪ್ರೊವಿಷನಲ್ ಪೆನ್ಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಯಾವುದೇ ಅಭ್ಯಂತರ ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್.
Yes.
he has attained the age of superannuation.
ಅದಕ್ಕೆ provisional pension ಕೇಳ್ತಿರೋದು.
I look into that issue, my lord.
ಇದು last time ಬಂದಿತ್ತಲ್ವಾ ಪಾಟೀಲ್?
ಹೌದು, statement of objections ಸಲುವಾಗಿ ನಾನು time
Last time he was insisting for provisional pension.
I'll come,
ಇದು ಕೊಡ್ರಿ. ACS rules ಕೊಡ್ರಿ. It is a provision relating to provisional pension.
214 KCS 214A.
ಕೊಡಿ. ಇದು ಬರೀ petitioner ಇದ್ದಾಗ ಮಾತ್ರ ರೆಡಿ ಆಗಿ ಬರೋದಲ್ಲ. You should also be ready when you.
my
appeal for the
difficulty is, my lord, here management, my lord,
ACS rules
has
ಕೊಡಿ.
given the documents yesterday, my lord. ಅದಕ್ಕೆ ನಾನು ಸ್ವಲ್ಪ
No, no. When you are appearing for petitioner, you come ready.
I am sorry, my
When you
lord.
appear for respondent, you deliberately do not come.
ಇಲ್ಲ
ready.
ಇದರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ನಿನ್ನೆ ಸಾಯಂಕಾಲ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಬ್ಜೆಕ್ಷನ್.
That is not, that cannot be the answer.
Yes, it's
214?
A.
ಓದಿ.
In the case of a government servant who has retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are continued under sub-rule 2, a provisional pension as provided in rule 214A shall be sanctioned.
Where are you reading?
214 bracket 4.
142, page number 140.
ನಮ್ಮ book ಯಾವ್ದು?
ನಿಮ್ದೇ
ಬೇರೆ ಇದೆ. ಅಲ್ಲಿ
Two.
ಬೇರೆ. Page number. Section 214.
Yes, Mr. What do you say about this?
we will
IA 1/2024 is filed
Formally-
with the petitioner for grant of provisional pension.
formally it could be taken as objected.
Full stop. Next para. The petitioner contends that petitioner contends that a departmental proceedings is initiated against him for alleged misconduct. However, no formal orders passed by the disciplinary authority.
We have passed the order.
Huh?
We have passed the
Or
order
intimate money.
for dismissal, yes, my lord. It has
However,
been-
the order passed by the disciplinary authority, however, the order passed.
ಇಲ್ಲ
by the-
ಡಿಸ್ಮಿಸಲ್ ಮಾಡಿಲ್ಲ ಮೇಲೋಡ್ ಅಪಾಲಜಿ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿಲ್ಲ.
It has been dispatched through register post. Since from the day one, he is rejecting, my lord, refusing all, my lord, notices issued by the man.
However, the disciplinary authority has not communicated any decision.
ಇಲ್ಲಿ ಇವ್ರು 2 ಸಲ ಸೆಕೆಂಡ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೋಡ್.
has not
ಫಸ್ಟ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಉತ್ತರ ಕೊಟ್ಟಿದ್ದೀವಿ, ಮತ್ತೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ 2 ವರ್ಷದ ನಂತರ ಮೊನ್ನೆ ಸೆಕೆಂಡ್ ಶೋಕಾಸ್ ನೋಟಿಸ್
enclose ಮಾಡಿಲ್ವಾ?
ಮೇಲೋಡ್.
They have enclosed the report of the inquiry officer.
Yes, yes.
ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
However,
Dismissal.
the decision on the reply submitted by the petitioner to the show cause notice. Full stop. He therefore submits that in view of order section rule 214 bracket 4, 214 bracket 4 of the KCSR rules, comma, the petitioner is entitled for provisional pension as provided in Rule 214 capital A of the rules. Full stop. For contra, the learned counsel for the respondent number
4 and 5.
4 and 5 submits.
Alternative remedy under 130 and 131.
Disciplinary authority has already passed an order accepting the report of the inquiry officer. Has passed an order of dismissal.
Yes.
from
ಪಾಸ್
service.
ಮಾಡಿಲ್ಲ ಮೇಲೋಡ್ ಅಪಾಲಜಿ.
ಅವ್ರು ಹೇಳ್ತಿರೋದು sir, ಅವ್ರು
My
ಹೇಳ್ತಿರೋದು.
contention, ಅಷ್ಟೇ, my contention.
Full stop. He submits that the order of dismissal of the petitioner is placed before the state government for approval. Full stop. Next para.
There is an alternative remedy under
But,
section 130 and 131.
Since the respondents, since the alleged order passed by the respondents 4 and 5, terminating the services of the petitioner is yet to be approved by the state government, comma, the state government, comma, it is deemed that the petitioner, it is deemed that the departmental proceedings initiated against the petitioner has not come to an end. Full stop. In the meanwhile, since the petitioner has attained the age of superannuation, comma, the respondents 4 and 5 are bound to pass an order determining the provisional pension payable to the petitioner as provided in Rule 214 capital A of the Caste rules. In that view of the matter, IA 1 of 2024 filed by the petitioner is allowed, and the respondents 4 and 5 are directed to pass an order determining the provisional pension payable to the petitioner as provided under Rule 214A of the KCS rules. This shall be complied within a period of 1 month from today.
One more line may be
Very
kindly
much
added.
grateful to you, my lords.
There is an alternative remedy under section 130 and 130.
Not deciding.
Gross violation of natural
I
justice,
have
my
raised
lord.
that objection ಅಂತ ಅಷ್ಟೇ.
Without issuing a charge memo, they have conducted inquiry.
ಅದು objection ಬರ್ಲಿ.
Post retirement, it has been conducted.
Kindly request. Alternative remedy ಅಂತ.
They are not deciding the petition, mister.
What?
You are not deciding the petition.
ಇಲ್ಲ, ನನ್ನ contention ಅಲ್ಲಿ ಬರೀ ಅಂತ.
No, no. Next, correct. Mr. Manvendra Reddy.
I am for respondent not there. IA copy is not served. on.
Yeah, IA, you know, IA for
IA
state.
number
IA
1
for
and
state.
2,
Yes,
not served on.
What copy is not served? IA
IA copy.
IS.
I'll serve the copy.
There are 2 IS. No.
dispensation bidding namgu.
This will be allowed. IA 2, second my lord, IA for stay. That copy is also not served.
IA 2 of 24 is allowed by accepting the request by the learned counsel for the petitioner for dispensation of production of the certified copy of annexure H. Next, the learned counsel for the petitioner is directed to serve copy of IA 1 of 2025
Please.
to the learned counsel for the respondent number 5. List on.
120.
Hmm.
Please.
Reading, serial number 15, PG Chicken Argunda.
Mr. Chicken Gowder,
Chicken Argunda.
Yes, your lordships.
A&R departmental exam
Please, your lordships.
is entitled for an increment.
Please, your lordships. It is in fact not the covered by the decision of this honorable court.
File is not put up on this file. Go ahead.
Mr. He has completed some departmental examination in Kannada. He is entitled for one increment.
Please.
ಏನ್ ಮಾಡ್ತೀರಾ?
In fact, it is.
Pass over.
Password. Number 16. Sudarshana.
My lordship, I am appearing for the petitioner, my lord. KNNL has preferred this petition, my lord. The matter is of paying of a gratuity amount, my lord. We are sought for annexure C. Fact of the case is that, my lord, employer respondent number 3 herein was appointed as a daily wage worker, my lord. Later on, he was appointed, regular appointment was taken place. After issue of a circular dated so and so, my lord, the employee has filed application before the competent authority. That application was allowed, my lord. Being agreed by that order, my lord, petitioner herein was filed application before the first appellate authority. That is also confirmed by the controlling authority order, my lord. Being agreed by that order, my lord, we are before this court. Meanwhile, my lord, the same issues involved in the set of facts, my lord, that was pending before the apex court, my lord, as per annexure C. So we are meanwhile seeking for stay in similar matters, my lordship. We obtain the stay order, my lord. I am furnishing that article.
But it says the petitioner shall pay the entire amount which has been ordered in terms of the impugned judgment.
My lordship, we have deposited entire award amount before the first appellate authority, my lord,
You
to not
deposited.
release that amount, my lord. So far we have sought for stay, my lord.
But the Supreme Court says you should pay the entire amount.
Entire amount we have deposited
Pay.
because of that is pending before the Supreme Court. my lord.
Correct, Mr. The Supreme Court itself says you pay it.
Yeah.
So if you deposited, let the amount be released.
No, if the amount is released, my lordship, the
The
petition is
Supreme
not.
Court said you shall have to pay, not deposit.
My lordship,
Read Supreme Court order, page C, annexure C.
please, my lord, 43.
The petitioner will pay the entire amount which has been ordered in terms of the impugned judgment. Doesn't say deposit.
My lordship, in last para, further the notice will be issued subject to amount. My lordship may permit me to read.
Yeah,
Next page, that is the Supreme Court judgment.
that is litigation expense.
So,
So you also deposit the litigation expense.
the
Merkoli. Issue emergent notice to the respondent. Sorry,
respondents,
HCGP is granted to accept notice for
192.
response 1 and 2. Issue emergent notice to respondent number 3. Stop. Since it is stated by the learned counsel for the petitioners that the entire amount of gratuity as determined by the labor officer.
labor officer, please.
Labor officer. But as per annexure B is deposited before the
First appellate control,
first appellate authority, namely
Please.
the respondent number
respondent number
One.
1, my lordship.
comma, the respondent 1, comma, subject to the petitioners depositing a further sum of rupees 25,000 before the respondent, subject to the petitioners paying a sum of rupees 25,000 to the respondent number 3 towards litigation expenses, comma, the amount deposited by the petitioners before the respondent number 1 shall not be released to the respondent number 3. The deposit of rupees 25,000 shall be made within
3 weeks. my lord.
3 weeks.
Obliged.
Yes.
Next matter is also similar, my lordship.
Same order.
Please.
Respondent number 3, madam.
Uh,
Respondent number 3, madam. The same similar matter, not
That
reposited.
issue be decided.
Yes.
25,000 ರೂಪಾಯಿ ನೀವು ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ರಿ.
Yes, ma'am.
Obliged.
ಪ್ರಮೋದ್ ಕುಮಾರ್ ಪಾಟೀಲ್.
Number 18, Pramod Kumar Patil. Pramod Kumar Patil.
Yes, government advocate is directed to accept, notice for respondent number 1, 2, 4, 5, 6. Full stop. Issue emergent notice to respondent number 3 and 7.
Number 19. Jairaj Bukka.
Jairaj Bukka.
Lordship, the petitioner is working as a supervisor in the municipal council Bidar, the 6th respondent office, my lord. Since from 2016, my lord, the petitioners and other filed application before the authority for regularization.
When were you appointed? When were you taken on daily wages?
9/11/2016, my lord.
What is your right to seek regularization?
My lord, the at annexure page number 28, my lord, annexure H, my lord.
28.
My lord, the petitioner and others filed application before the authority for 26/3/2011, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿ ಅನುಸಾರ ಈ ಕಚೇರಿಗೆ ಪತ್ರದಲ್ಲಿ 11+2 14 ಜನ ನಿರ್ಮಲ ಸೂಪರ್ವೈಸರ್ಗಳನ್ನು ಹಾಗೂ 31 ವಾಹನ ಚಾಲಕರನ್ನು ಕಾಯಂಗೊಳಿಸುವಂತೆ ಪ್ರಸ್ತಾವನೆ ಈ ಕಚೇರಿಗೆ ಕಳಿಸಿರುತ್ತೀರಿ ಮತ್ತು ತಮ್ಮ ಕಚೇರಿಯ ಪತ್ರದ ಉಲ್ಲೇಖವೊಂದರಲ್ಲಿ ಮಾನ್ಯ ನಿರ್ದೇಶಕ ಪರೋಡಿತ ನಿರ್ದೇಶಕರ ಪತ್ರದ ಕುರಿತು ಉಲ್ಲೇಖಿಸಲಾಗಿದ್ದು ಸದರಿ ಪತ್ರದಲ್ಲಿ ನೌಕರರನ್ನು ಕಾಯಂಗೊಳಿಸುವ ಕುರಿತು ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ಹಾಗಿದ್ದಲ್ಲಿ ಸದರಿ ಪತ್ರದ ಪ್ರತಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ ಮತ್ತು ನಿರ್ಮಲ್ನ ಸೂಪರ್ವೈಸರ್ ವಾಹನ ಚಾಲನ ಕಾಯಂ ಮಾಡುವ ಕುರಿತು ತಮ್ಮ ನಿಖರವಾದ ವರದಿ ನೀಡಲು ಸೂಚಿಸಲಾಗಿದೆ ಹಾಗೂ ಇಂತಹ ಪ್ರಕರಣಗಳು ಬಂದಲ್ಲಿ ಈ ಕಚೇರಿಯ ಪತ್ರ ವ್ಯವಹಾರ ಮಾಡದೆ ತಮ್ಮ ಹಂತದಲ್ಲಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಲಾಗಿದೆ. Thereafter, my lord, the annexure L permission is obtained, my lord. 6th respondent.
Annexure
L, my lord, page number 31, my lord. 23/12/2021, my lord. ನಗರಸಭೆ ಕಚೇರಿಯಲ್ಲಿ ಆರೋಗ್ಯ ವಿಭಾಗದಲ್ಲಿ ನೈರ್ಮಲ್ಯ ಮೇಲ್ವಿಚಾರ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಕಾಯಂಗೊಳಿಸುವ ಕುರಿತು ಮಾನ್ಯ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಆಡಳಿತ ಪೌರಾಡಳಿತ ನಿರ್ದೇಶನಾಲಯ ಬೆಂಗಳೂರವರ ಪತ್ರ ಸಂಖ್ಯೆ ESTMDW and dated 16/11/2021 ತಮ್ಮ ಕಚೇರಿಯ ಪತ್ರ ಸಂಖ್ಯೆ 9/12/2021 ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಬೀದರ್ ನಗರಸಭೆ ಕಚೇರಿಯಲ್ಲಿ ಆರೋಗ್ಯ ವಿಭಾಗದಲ್ಲಿ 11 ಜನ ನಿರ್ಮಲ ಮೇಲ್ವಿಚಾರಕರು ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸಿಬ್ಬಂದಿಗಳನ್ನು ಕಾಯಂಗೊಳಿಸಲು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ 2ರಂತೆ ಸದರಿ ಸಿಬ್ಬಂದಿಗಳ ಪಟ್ಟಿಯನ್ನು ಸಿದ್ಧಪಡಿಸಿ ಕಾಯಂಗೊಳಿಸಲು ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸುತ್ತೀರಿ. ಅದರಂತೆ ಸಿಬ್ಬಂದಿ ಪಟ್ಟಿಯಲ್ಲಿ ಅವರ ಹೆಸರು, ಹುದ್ದೆ, ಜನ್ಮ ದಿನಾಂಕ, ಸೇವೆಗೆ ಸೇರಿದ ದಿನಾಂಕ, ಕಚೇರಿಗೆ ಹಾಜರಾದ ದಿನಾಂಕ ಮತ್ತು ವಿದ್ಯಾರ್ಥಿ ವಿವರ ಹಾಗೂ ಪ್ರತ್ಯೇಕ ದಾಖಲೆಯನ್ನು ಲಗತ್ತಿಸಿ ಕಾಯಂಗೊಳಿಸಲು ಶಿಫಾರಸು ಮಾಡಲಾಗಿದೆ. ಮಾಹಿತಿಯನ್ನು ಪತ್ರದಲ್ಲಿ ಲಗತ್ತಿಸಿ ತಮ್ಮ ದಯಪರ ಮಾಹಿತಿಗಾಗಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. My name is appear in the serial number 9, my lord, page number 33. ದೇವಿದಾಸ್ ತಂದೆ ಬಸಪ್ಪ, my lord.
But ಇದೆಲ್ಲ ಬ್ಯಾಕ್ ಡೋರ್ ಎಂಟ್ರಿ ಯಾವಾಗ ನಿಲ್ಲೋದು? When will this back door entry? There should be a stop somewhere.
My lord, the throughout state in the all the department, the government only contract basis is continually. His age is completed more than 35 years, my lord.
Correct, but then by this backdoor entry, others have been deprived of an opportunity.
My lord, the government is not as per requirement, as per government employees not permitted, my lord, and not appointment.
Then we say that let there be no recruitment.
My lord, in page 1, this honorable court passed the order dated 15th October.
Correct, but then let there be no recruitment. Let the government decide what should be done.
Only consider
some chief officer comes, he takes his own people.
My representation consider as P in accordance with the law, my lord. This honorable court passed the order 15th October 2024, my lord. Similar matter, madam.
Correct, Mr. Bukka.
ಅವರು ಡ್ರೈವರ್ ಇದ್ರು, ಇವರು ಸೂಪರ್ವೈಸರ್ ನಿರ್ಮಲ್ನ.
Correct ರೀ, ನಾನು ಹೇಳ್ತಿರೋದು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ.
Yes, my lord. Please,
every person in this country is entitled to apply for recruitment as a ನಿರ್ಮಲ್ಯ ಸೂಪರ್ವೈಸರ್. ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಅವಕಾಶ ಇದೆ.
ಇಲ್ಲ,
Just because you are close to some chief officer, or just because
ಈಗ ಅವ್ರು
chief
permanent ಸಂಬಳ
officer wants you.
ಅವ್ರು
then
ಪರ್ಮನೆಂಟ್ ಸಂಬಳ
ಅವ್ರು-
ಕೊಡಬಾರ್ದು ಅಂತ ಹೇಳಿ ಲೋ ಸಂಬಳದಾಗ ಅವರು ಕೆಲಸ ಮಾಡಿಸ್ಕೊತಾ ಇದ್ದಾರೆ.
So therefore, let
ಲಾಂಗ್
the
ಟೈಮ್
government decide. Let the government decide. ಆಯ್ತು ಇದು
ನಾಟ್
municipal
ಇನ್ ದಿಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್, ಆಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸ್ವಾಮಿ.
all departments only. Let the government decide what should be done. There should be regularity.
Yes,
Supreme
ma'am.
Court has said no
But
regularization.
in
We
connected,
do it, and the government also does it.
in connected
There
matter,
should be some full stop somewhere.
ಆಗ್ಬೇಕು ಸ್ವಾಮಿ ಅದು.
Huh.
In this honorable court passed at 15th October 2024 connected matter.
Anyway, but this is a very unfortunate thing.
Yes.
CMC ಯಾರಾದ್ರು? Municipal ಇದೆ.
HCGP is that to accept notice for response 1, 2, 3, 4. And
Gaurish Kashimpur, my lord, 6th.
5 ನೀವೇನಾ?
5 and 6, Gaurish Kasham.
Mr. Gaurish Kashampur for 5 and 6. Yes.
Number 20. Jairaj Bukka.
Lord, the petitioner appointed as a super cum attender, my lord, in the second respondent office in the 2000 on dated 13/5/2006, my lord, at Annexure G, page number 23, my lord. Thereafter, my lord, the sum of the colleagues employees approached this honorable court in at Annexure L, page number 30, lordship.
ನಿಮ್ದು ಯಾವಾಗ ನಿಮ್ನ ಇದ್ ಮಾಡಿದ್ದು? When did they take you?
13/5/2006.
2006.
ಈಗ some of the colleagues approached this honorable court at Annexure L.
HCGP for R1. Veterinary animals ಯಾರ್ರಿ?
KM Ghate, sir.
Ghate, KM Ghate.
KM Ghate for respondent number 2.
Please.
Number 21, Kadaluru Satya Narayana HR.
Kindly be passed over me.
CPC matter ಹೇಳಪ್ಪ ಏನು ಅಂತ.
My lord, petitioner is challenging the order, rejecting the application under order 21 rule 34 subclause 2, my lord. The judgment debtor put in appearance in the EP before cell deed was submitted to the honorable court. But the honorable court, after receipt of draft cell deed, has not served the copy upon the judgment debtor. And though the judgment debtor opposed it by way of memo and also filed application under order 21 rule 34 subclause 2, the executing court has rejected the application and has accepted the draft cell deed.
What is wrong with the order? Notice has been issued to you of the execution petition.
Yes, my lord.
You have appeared.
Yes, my lord. We have appeared by
What is-
filing advancement application much before
What is
submission of
wrong
sale.
with the draft sale deed?
My lord, it is a mandatory provision and
What is wrong in the draft sale deed? It is mandatory.
my lord, it is not at all served upon us.
What is wrong in the draft sale deed? Please point out. What is what purpose does it serve? You were called upon to execute a sale deed.
Yes,
You
my
did not do.
yes, my lord.
Draft sale deed is produced or furnished,
Yes,
correct? You participated in the execution.
my
What
lord.
is the objection to the draft sale deed? Purpose of issuing a notice to you is to call upon you to come and execute the sale deed.
Yes,
You did not do it. Draft sale deed,
my
what
lord.
is wrong in the draft?
Even in the original suit, the defendant could not prosecute his case.
That is different. Now we have a decree, right or wrong. What is the mistake in the draft sale deed? You please point out.
My lord, there is some objection regarding commissioner's.
Sum ಅಲ್ಲ, ಹೇಳ್ಬೇಕು ನೀವು ಏನು? What is that sum? Suit is filed in which year?
2019, my
Filed
lord. 2019.
2019.
Yes, my lord.
You have filed some REA also.
That is still pending before the appellate court, my lord.
Huh.
And even the judgment debtor has brought it to the notice of execution court also.
You should have got the execution proceeding stayed. Why did you not file an application for stay?
My lord, before some steps could be taken before the appellate court, the executing court has passed this
RA
temporary
is
order.
filed in 2023.
Yes, my lord.
We are in 2025. In 2 years, you have not taken any steps, either to get a stay before the appellate court or to file an application, execution petition for stay. You have not done anything. And you want to protract the proceedings so that RA could be decided. Ashte tane?
Yes, my lord.
That is the purpose.
No, not only that, my lord, there were some objections which the
Some, my lord,
judgment
please
debtor
point
wanted
out what
to
are the
raise it
some
before the.
objections. Pass over.
Number 22, Shivkumar Mali Patil.
Forgotten to file. Well, I said I have not filed, by mistake, I have not filed. File is not there. Only regarding initiation of DE there, sir. Since the criminal case is quashed, FIR is quashed by the honorable court.
The FIR is quashed.
Quashed.
So,
It is regarding printing of during election vehicle passes. Other many case, the FIR is quashed by this honorable court. Since they are not technically 188 is not directly cannot approach the file FIR. They have to approach by filing a complaint before the court. Quash, I think that has reached finality. Thereafter, now recently they have started DE now.
what is wrong?
My submission is I shall submit tomorrow at my conduct.
Learn counsel for the petition seeks time list on. Mr. DP Ambekar.
Number 23, DP Ambekar.
The petitioner, my lord, is working as a headmaster under the respond number 10 school. The respond number 10, that is Sri Shivanand Vidyavardhak Sangh, Mushibna. It was earlier registered as a public trust under the provisions of the erstwhile Bombay Public Trust Act. Thereafter, my lord, because the Trust Act was repealed in 2003, the same was converted into a society under the Karnataka Societies Registration Act. The same was challenged in a writ petition by the person claiming to be the president of the trust, secretary. Your lordship has passed a judgment at Annexure A, dismissing the claim that it is still a trust with a cost of rupees 50,000. And on page 48, my lords. Page 48. 48. In page 48, first line. In view of the fact that petitioner and respondent 6 have already reported compromise in WP number 1187 of 2008 between them, they cannot raise any dispute regarding conversion of the trust into the society. So now the trust is no longer existing. It has been changed into a trust. In fact, liberty was also given to approach the civil court to decide if trust has any issue. Nobody has approached till today. So that judgment has attained finality. Thereafter, my lords, a miscellaneous application was also filed before the district court by the trust as Annexure B, page 49. That was also dismissed by the district court by relying on the judgment passed by this honorable court at Annexure A. So now that matter is put to rest. And such being the facts, the respondents number 6 and 7, claiming to be the president and secretary of the trust, they, my lord, get a complaint filed against the petitioner herein, saying that though he is a government teacher, he has got married twice, bigamy. Actually, my lord, that is, even though assuming it is true, that is perfectly permissible under the education rules. If personal law permits here in this case. Accordingly, my lord, a unconcerned person, he files a complaint at Annexure C, alleging bigamy before the BU. In fact, BU has no jurisdiction. That is left to the management to conduct the inquiry. The BU mischievously, my lord, instead of forwarding the complaint to the society, he forwards it to a person. In fact, I have been informed that he has given it by hand to a person who claims to be the secretary of the erstwhile trust, who is no longer a member of the society. Erstwhile trust, he issues the Annexure D letter to the erstwhile trust. Thereafter, my lord, based on that direction of the BU, The erstwhile trust, my lord, it issues annexure E, show cause notice. It is pertinent to note, my lords, on the letterhead at annexure E, page number 126. Annexure on the left side, top corner, left corner, it is stated to be established in 1971. And on the right side, registration number E222 BJP. This is the number of the trust, not the society. Society is registered recently after it was repealed. After 2003, it was registered. Thereafter, my lord, I promptly replied to the same, raising the question of jurisdiction as per my reply at annexure E. Thereafter, my lords, again, not standing at this, it has proceeded further and issued a charge at annexure G. Same on the same letterhead, unconcerned person. Thereafter, my lord, for that also given my detailed reply at annexure H, page 155. And I have also marked a copy to the BO also.
Yes.
In spite of that, in spite of raising an objection, again they proceed further and they proceed to appoint an inquiry officer. I have made him as a respondent, my lord, inquiry officer. For that also, my lord, I have filed my objections. Inquiry officer. In fact, a managing committee member of the society also, he issues a letter to the inquiry officer saying you have no jurisdiction to inquire into our affairs.
So let's see. AG has director accept notice for response 1 to 5. ಬೇಕಾದ್ರು 1 to 5 ಬೇಕಾಗಿಲ್ವಲ್ಲ? Notice to response 1 to 5, is it necessary?
I have caused challenge the order passed by respondent 5.
5.
BO has issued the letter to them.
AGF for response 1 to 5. Issue emergent notice to respondent number 6, 7, 8, 9 and 10. ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿದ್ರು? ಜಾಗೀರ್ದಾರ್. ಯಾರು?
ಬಸವರಾಜ್ ರೆಡ್ಡಿ ಫಾರ್ ಟ್ರಸ್ಟ್. BB Patil and RJ Busare they were earlier.
ಬಸವರಾಜ್ ಕರೆಡ್ಡಿ.
He was appearing for this thing. Trust society earlier.
Trust ಯಾರು?
Trust was appearing RJ Busare.
Mr. RJ Busare. Correct?
Yes, RJ Busare. Page 18 allive.
Page
18, 18. Ningaya Sangai Chokimati was secretary of the trust, erstwhile trust. Representative BB Patil and RJ Busare.
Ningaya.
In individual capacity was there, but they had appeared for the secretary of the trust and claim.
So the Srishal is the secretary now.
Yes, ma'am. Now it has changed. They claim that Srishal is this.
I think issue emergent notice to respond number 6, 7, 8, 9 and 10.
Please.
List on short date. 20? 20.
Till then, my lords, further proceeding. He has now fixed the date on 17th and he has issued a peculiar letter. He is also going to inquire into constitution of the society.
Till the next date of hearing, further proceedings against the inquiry proceedings initiated against the petitioner. Please state, yes.
Please, publish.
Number 24, Ramachandra K.
My lord, we have challenged annexure D and F, my lord.
Next, sir.
Annexure D and F, my lord. The impugned orders passed by the respondent number 1 to 5 in respect of to take charge respondent number 6 as assistant director agricultural center Kalaburagi against their own seniority list as per annexure C, my lord. And we are further seeking directions to consider the respondents my representation as per annexure E, my lord. My lord, petitioner was appointed. Sorry, my lord.
Ramchandra.
Yes, my lord.
ನಿಮ್ಮ ಇದನ್ನ ವಿಡಿಯೋ ಕರೆಕ್ಟ್ ಇದು ಮಾಡಿ ಆಡಿಯೋ ಸರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಇಲ್ಲಾಂದ್ರೆ ಕೋರ್ಟ್ಗೆ ಬನ್ನಿ.
Please, my lord, please.
Either you get your audio report properly or you come to the court.
Due to ill health, my lord, I am taken VC today. So from tomorrow onwards, I'll be physical. My lord, petitioner was appointed as assistant at Krushi Vignana Kendra Raichur in the year 2009, my lord. He was promoted as a senior assistant at Kalaburagi in the year 2016, my lord. And on 31st.
The learned counsel for the petitioner has joined the proceedings through video conference. However, he is not audible. Hence, list on yavat bartiri.
Kindly tomorrow, my lord, tomorrow, please.
Tomorrow agala.
No, my lord, kindly have tomorrow, my lord. The matter is very urgent.
Service matters alla 22nd. Yes, list on 20,
22-1.
22-1, yes.
Number 25, Mahesh Patil.
Lord, appearing for the petitioner, no?
Yavag, when did you retire?
Lord, I retired, Lord, from the military service.
When did you retire?
Yes. Lord, 31-10-2005, page 25.
31-3-2015.
5, Lord, 5. 31-10-2005. That is at page 25.
Page?
Page 25.
When is the
Page,
claim made?
Lord, here, Lord, the petitioner, Lord, is an ex-serviceman. Lord, thereafter, Lord, he has joined the services of the police department. Lord, after joining the police department, Lord, the benefits, Lord, under 41C of the KCSR, Lord, was extended to him. Lord, which, Lord, provides for, Lord, the protection of his last basic pay, Lord, in the military services. Lord, thereafter, Lord, he was, Lord, granted arrears, and, Lord, his pay was accordingly fixed. But however, Lord, thereafter, Lord, again, Lord, that benefit was taken away by the, Lord, the state government, and, Lord, the petitioner, Lord, challenged before the, Lord, the KAT. Lord, the KAT, Lord, restored, Lord, his earlier, Lord, the benefit under 41C of KCSR. Now, Lord, what has happened, Lord? The state authorities, Lord, it appears, Lord, that they have prevailed upon the, Lord, the fifth respondent, that the pension authorities of the, Lord, the petitioner, Lord, in his earlier service, and, Lord, now, Lord, they have, Lord, all of a sudden, Lord, without there being any notice, or, Lord, all of a sudden, Lord, they have started recovering the entire DA amount, Lord, he has received since from his retirement, Lord, that is from 2005 to till date, Lord, which is apparent, Lord, at page 24, annexure D, page 24 ಅಲ್ಲಿ Lordship may kindly see, Lord, at the last, Lord, ಅದರಲ್ಲಿ 15,74,784 227 ಕಂತು ಮಾಡಿ, Lord, entire, Lord, my half of my, Lord, pension, Lord, has been, Lord, they have stopped, Lord, and start recovering. Lord, this entails civil consequences, and, Lord, they cannot, Lord, directly, Lord, without there being any notice, Lord, or without there being any reason and no order, Lord, they have started, Lord, recovering, Lord. And, Lord, this is, Lord, covered by the decision of the, Lord, the Honorable Supreme Court, Lord, in Rafiq Masaya case, Lord, and reiterated, Lord, in the Apex Court, Lord, in recent decision, Lord, in Thomas Daniel case also, which I have produced, Lord, at page 33, Lord, annexure G. In Lord, Lord, in identical matters, Lord, had come up, Lord, before this Honorable Court, Lord, where this Honorable Court had granted, Lord, interim order, Lord, which I produced, Lord, at annexure E also.
Local AG is directed accept notice for response 1 and 2, 1, 2 and 4, 1 to 4. Issue emergency notice to respondent number 5. Till the next date of hearing, comma, the respondent number 1 to 4.
Lord, it is the respondent number 5, Lord, who is, Lord, was affected these, Lord, recoveries. Respondent number 5.
Was it brought to the notice of the respondent number 5 that you are re-employed?
Yes, Lord, very much. And, Lord, only, Lord, there is an, Lord, website, Lord, of Sparsh, Lord, wherein, Lord,
where have you informed the respondent number 5 about your re-employment?
Lord, that is only, Lord, after that is in the Sparsh is meant for that, Lord, Lord, annexure, Lord, D series, page 24. Lord, the The Sparsh website is meant for the retired defense personnel, wherein they enter all those details of the present employment.
Where have you mentioned that after your retirement, you have informed the respondent number 5 about your employment with the state government?
Lordship, Lordship, may kindly see Annexure C, page 22. One of such circular, wherein at para 9, page 23, para 9. ಅದರಲ್ಲಿ ಹಾಗೂ ಕೇಂದ್ರ ಸರ್ಕಾರದ ನಿಯಮಗಳ ಪ್ರಕಾರ ಮಾಜಿ ಸೈನಿಕರು ಮೀಸಲಾತಿ ಅಡಿಯಲ್ಲಿ ನೇಮಕಾತಿ ಹೊಂದುವ ನೌಕರರನ್ನು ಸ್ಪರ್ಶ್ ಸಿಸ್ಟಮ್ ಫಾರ್ ಪೆನ್ಷನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ರಕ್ಷಾ ವೆಬ್ಸೈಟ್ ಮುಖಾಂತರವಾಗಿ ತಾನು ಹೊಸ ಹುದ್ದೆಯಲ್ಲಿ ನೇಮಕಾತಿಯಾಗಿರುವ ಮತ್ತು ಅವರಿಗೆ ನಿಗದಿಪಡಿಸಿರುವ ವೇತನದ ವಿವರಗಳನ್ನು ತನ್ನ ಲಾಗಿನ್ ಐಡಿ ಬಳಸಿ ಪಿಂಚಣಿ ವಿತರಣಾ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಒದಗಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಅದು ಮಾಡಿದ ಮೇಲೆನೆ ಇದು ರಿಕವರಿ ಶುರು ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿವರೆಗೂ ನನಗೆ ಇಷ್ಟು ವರ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ.
So therefore, you can't be re-employed, draw salary here and also draw pension there.
Yes, but very much. There is a provision.
Therefore, what is there to show that you informed Sparsh about your re-employment?
The Annexure D itself indicates as to since from 31/10/2005 to this particular June 24, uninterruptedly I have received my pension along with the DA of in military services. All of a sudden, when I make entries in the Sparsh, at the instance of the state government, this recovery is made of 15,14,000.
You have a re-employment
re-employment that is forthcoming from the very fixation order at page 19 on 16/2/2008. 16/2/2008.
2008.
Yes, sir. 16/2/2008, page 19.
ಯಾವಾಗ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರಿ ಸ್ಪರ್ಶ್ಗೆ?
ಸ್ಪರ್ಶ್ ಇಟ್ ಇಸ್ ಎನ್ ಈಗ ರೀಸೆಂಟ್ ಆಗಿ ಅದು ಆ ವೆಬ್ಸೈಟ್ ಎಲ್ಲ ಮಾಡಿರೋದು ಅವರು. And there is no prohibition to receive pension along with the DA in the military services also.
Sir, but your pay is protected. Whatever military service that you are doing,
yes, sir.
Your pay that you are drawing in military service is protected.
Yes, sir.
You can't draw pension there and also income salary here.
Yes, very much. This is the it is not the petitioner alone. It is permissible, and it is the entire the military services.
Take out notice. Then no stay. Please
take out. Here, there is a huge recovery every month.
And then you have to convince the court as to when you informed Sparsh. ಯಾವಾಗ ಮಾಡಿದ್ರಿ? ಸ್ಪರ್ಶ್ ಮುಂಚೆ ಏನೋ ಒಂದು ಇರ್ಬೇಕಲ್ಲ.
ಇಲ್ಲ, ಈಗ ನನಗೆ ವಾಟ್ LPC ಇಸ್ ದೇರ್ ಅಂಡ್ ಅವ್ರಿಗೆ LPC ಕೊಡ್ತಾರೆ. ಇವ್ರ ಮಿಲಿಟರಿ ಸರ್ವಿಸಸ್ ಅವರು LPC ಕೊಡ್ತಾರೆ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಗೆ. ಅದಾದ್ಮೇಲೆ ಬ್ರೇಕ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಗುತ್ತೆ. ಲಾರ್ಡ್ಶಿಪ್, yes, and that is very much forthcoming in the I will it is Lordship may kindly come to Annexure A, wherein Lordship may kindly see one of such page 15. ಇವ್ರು ಅವರೇ LPC ಕೊಡ್ತಾರೆ, ಇವರು ಮಿಲಿಟರಿ ಸರ್ವಿಸಸ್.
Please read rule 41C.
Please. Notwithstanding anything contained in any other rules, where a military officer of the rank of junior commissioned officer or below, who is discharged from the military service before superannuation, is appointed to a post in accordance with the rules regulating recruitment thereto, his pay in the time scale of the post in which he is so appointed shall be fixed as follows. Where the pay drawn in the military service is equal to stage in the time scale of the post to which he is appointed, it shall be fixed at that stage. Where the pay last drawn in the military services does not correspond to a stage in the time scale of the post to which he is appointed, it shall be fixed at the stage next below the difference being treated as personal pay absorbable in future increase in pay. Where pay last drawn in the military services is below the minimum of the time scale of the post to which he is appointed, it shall. My lord,
No,
Uh,
sorry.
my lord, here, my lord, it's a huge, my lord, the sum as to, my lord, in identical.
You have taken the huge sum, you have to return the huge sum only.
My lord, but my lord, in terms of the, my lord, the order of the Supreme Court, my lord, edition of, my lord, the Rafiq Pasai, which I have produced, my lord, which has a lordship may kindly say.
Rafiq Masi applies in a different context, not in this case.
Yes, my lord, very much, my lord, here, because
sorry.
My lord, here, it's a huge sum, my
You're
lord.
bound to inform your re-employment. Have you informed this, the military service about your re-employment?
Lordship may kindly say, page 15, my lord, page 15, for a moment.
1.5?
1.5 of the, my lord, the repetition. My lord, here, my lord, my lord, in the very same, my lord, in respect of the petitioner here in, my lord, the Honorable KTA, my lord, at Para 2 has observed, my lord, applicant's case is that, my lord, that they are working as police constables in Group C post at Kalaburagi under the second respondent authority. It is a case that they have rendered their services in army and after retirement from military services, they were recruited against ex-servicemen quota. After appointment as civil police constable, their initial basic pay was fixed at particular stage in the pay scale applicable to the police constables. It is the case that according to Rule 41C of KCSR, only the basic pay shall be taken into consideration and other allowances or pension equivalent PCRG shall be ignored. In this regard, they have produced their last pay certificate rendered in military services at Annexure A1 series. Their further case is that while they were working under a fourth respondent, the fourth respondent by communication dated so and so, as per had sought clarification from the second respondent with regard to the refixation of the pay and extending the benefit of Rule 41C to the applicants, and thereafter by a memo dated so and so, as per annexure so and so, the fourth respondent has asked the applicants to submit certain particulars to enable them to refix their pay in accordance with law with Rule 41C of KCSR. My lord, here, my lord, the lordship had, my lord, raised an query, my lord, with regard to, my lord, the whether I had, my lord, informed. My lord, it is that, my lord, it is forthcoming in para 2, my lord, my lord, that the last pay certificate, my lord, is issued by the military services, my lord, themselves. There is an authority, my lord,
That is not the ground, Mr. Could issue emergent note. HCGP, AG is there to accept notice for response 1 to 4. Sudhir Singh Bijapur is there to accept notice for response number 5. List on date could.
My lord, a short date may be given so that it could be disposed of.
22-1.
Yes, next. 22-1.
Shivshankar H.
Yes.
Manur.
Shankar Manur.
Now, Gram Panchayati motion of no confidence, my lord. As per annexure F, notice is issued. Date is fixed on this month, 19th, my lord.
18th.
18th, my lord. Date is fixed. In this case, my lord, as per annexure B, my lord, earlier, the same persons have given application before the AC. That is according to annexure B, my lord. This was pursuant to this note application, my lord, annexure C is issued, my lord, by the state commissioner.
Annexure C.
I have challenged these two notices before the before this honorable court in as per annexure D, my lord, in WP number 203487. So this honorable court held that the application filed by the members is not in accordance with the form. Therefore, this honorable court quashed the notice, my lord. And liberty is given to the members, my lord, to file a fresh representation. Without, there is a direction issued by this honorable court in the order, my lord, and they have even not waited for the order, my lord. Directly they have filed application, same format, my lord. As per annexure B, same printout they have taken and filed application with the presence of PDO, Panchayat Development Officer, with the presence of Panchayat Development Officer, they have submitted, my lord, and not read the entire order and not followed the direction. And very next same day, my lord, the state commissioner issued the notice in the same format, my lord. Annexure C nalli enide ade format alli issue ಮಾಡ್ತಾರೆ.
Format ಬಗ್ಗೆ please come to page 27.
Yes, my lord.
ಓದಿ para 4 ಓದಿ.
A schedule of the material on record will indicate that the issue involved in the present petition as regards affixing of signature, writing and seal by the respondent number 5 Panchayat Development Officer and his presence, participation and involvement in the representation Annex B dated 14/11/2024 alleged to have been submitted by the private respondent number 6 to 20 to the respondent number 3 Assistant Commissioner is directly and squarely covered by the judgment of this honorable court in the case of so and so wherein it is held, my lord. So same format, my lord, annexure B the lane.
Format already.
PDO, my lord, same PDO.
PDO,
Annexure, kindly see annexure
PDO
E, my lord.
ಕೊಟ್ಟಿದ್ದಾರೆ, PDO
Yes,
forward ಮಾಡಿದ್ದಾರೆ ಅಂತ.
Yes, my lord. Annexure E ನಲ್ಲಿ ಕೂಡ ಅದೇ ಮಾಡಿದ್ದಾರೆ, my lord.
ಶಿವಶಂಕರ್ Manor, let us be clear on facts.
Yes, my lord.
You said that the earlier writ petition was allowed on the ground that the representation was not in accordance with form number 1.
Yes, my lord.
But that is not the ground on which the earlier petition is allowed.
ಇಲ್ಲ, ಅದೇ
Earlier petition was allowed because the members gave representation to the Panchayat Development Officer, who in turn forwarded it to the Assistant Commissioner.
para 10 of the judgment, my lord,
ಓದಿ.
page 33, my lord.
ಓದಿ.
ಪ್ಯಾರ ಇದರಲ್ಲಿ ಪೇಜ್ 32 ದಲ್ಲಿ ಫಾರ್ಮೇಟ್ ಇದೆ ಮಿಲಾಡ್, ಪೇಜ್ 33 ದಲ್ಲಿ ಫೈಂಡಿಂಗ್ಸ್ ಇದೆ ಮಿಲಾಡ್. ದಿಸ್ ನಂಬರ್ ಕೋರ್ಟ್ a plain reading of rule 3(1) of the state rules of 1994 clearly indicates that report number 5 to 15 were entitled to submit the same only to the assistant commissioner and not to the PDO. Further,
What does it mean?
ಅಲ್ಲ, I will read, my lord.
ಓದಿ.
Participate, PDO participate ಮಾಡಬೇಡಂತೆ ಫೈಂಡಿಂಗ್ಸ್.
ಓದಿ, ಓದಿ.
Further, a conjoint reading of rule 1(3)(1) and form number 1 will also indicate that the same do not provide for any writing, signature or seal or anyone else other than the respondent number 5 to 15 who submitted the impugned representation or the assistant commissioner who issued the same from them. In other words, rule 3(1) read with form number 1 of the said rules of 1994 do not contemplate in any manner either in presence, involvement or participation of the PDO for the purpose of submission of the representation or at the time of its submission. Neither is there any other provision under the Karnataka Gram Swaraj and Panchayat Raj Act 1993 or the said rules of 1994, which permits the PDO to affix his writing, signature or seal on the representation in form number 1, submitted by the respondent number 5 to 15. It is therefore clear that as per the procedure prescribed in rule 3(1) rule read with form number 1 of the said rules of 1994, it is only the respondent number 5 to 15 and the assistant commissioner who are entitled to affix their signature, writing and seal on the representation, and there was no room for anyone else, much less the PDO, to either participate, involved or be present at the time of submission of the representation, not affix his signature, writing or signature on the representation, which is contrary to rule 3(1) read with form number 1 of the said rule.
ಅರ್ಥ ಏನು?
He shall not participate in the.
What did you say in the earlier, when you started the petition, when you opened the brief, ಏನಂತ ಹೇಳಿದ್ರಿ ನೀವು?
He participated, my lord.
You did not say that. You said that the representation was not in accordance with form number 1.
So, yes, my lord, that is not in accordance.
Ground on which the petition is allowed is not on that ground. The ground on which the petition is allowed is representation na PDO ಕೊಡಂಗಿಲ್ಲ.
ಇಲ್ಲ, ನನ್ನ submission, my lord, PDO participate ಮಾಡಬೇಡಂತೆ ಇದರಲ್ಲಿ
ಹೌದ್ರಿ, ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಬಾರ್ದು ಅಂತ ಇರೋದು.
Yes, my lord.
You said something else.
In this case also PDO participated, my lord.
Yes, now, yes, go to the next.
Annexure E, my lord. Annexure E ದಲ್ಲಿ ಇಲ್ಲಿ ವಿಜಯಪುರ ದಿನಾಂಕ PDO ನನ್ನ ಸಮಕ್ಷಮ PDO signed and the date is given, time is also affixed.
PDO signature or AC signature?
PDO, my lord.
Come to the AC signature and annexure F.
Yes, my lord. AC signature, annexure F.
Annexure F ಅಲ್ಲಿ signature ನೋಡಿ compare ಮಾಡಿ. PDO AC ಅದು.
Milord, it is a PDO signature, Milord. Annexure B ದಲ್ಲಿನೂ ಇದೆ, Milord.
Annexure F ಅಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಸಿಗ್ನೇಚರ್ ಇದೆ.
Annexure F ದಲ್ಲಿ ಇದೆ, Milord. ಇದ್ರಲ್ಲಿ E ದಲ್ಲಿ
Annexure
ಇರೋದು
F ಅಲ್ಲಿರೋ
PDO.
ಸಿಗ್ನೇಚರ್ Annexure E ಜೊತೆ ಕಂಪೇರ್ ಮಾಡಿ. ಯಾರ ಸಿಗ್ನೇಚರ್ ಅದು? ಯಾರ ಸಿಗ್ನೇಚರ್ ಅದು?
Annexure B ದಲ್ಲಿನೂ ಅದೇ ಇದೆ, Milord. PDO ಅಂತ.
Annexure E ಇರೋ ಸಿಗ್ನೇಚರ್ PDOದು ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ ಏನಿದೆ?
May I verify, Milord, kindly pass the minutes.
ಪಾಸ್ or ಇಲ್ಲ? Will dismiss the petition ಬರ್ಕೊಡು.
Milord, my submission, Milord, ಇನ್ನೊಂದು point, Milord.
ಹೇಳಿ.
Milord, in the annexure F, Milord, ಅದರಲ್ಲಿ
ಹ್ಮ್
format, Milord,
ಹ್ಮ್
same format they have used. Annexure C ದಲ್ಲಿ ಏನಿದೆ ಅದೇ ಫಾರ್ಮೆಟ್. ಇದರಲ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು ಫಾರ್ಮೆಟ್, Milord, they have not referred the judgment of this honorable court. ಈ ತರ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಅದನ್ನು ಕೂಡ they have not followed. And next point is, Milord, format is same, Milord. Annexure C and F both format 7. ಅದರಲ್ಲಿ ಇರೋ wordings also same. ಇದರಲ್ಲಿ ಉಲ್ಲೇಖ ಅಂತಿದೆ, Milord. ಶ್ರೀ ಸುರೇಶ್ ಹನುಮಂತಪ್ಪ ವಟಾರ್ ಹಾಗೂ ಇತರರು ಅಂತ ಇದೆ, Milord. ರೂಲ್ 3(1) says, Milord, ಅದರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇರ್ಬೇಕಾಗತ್ತೆ ಮತ್ ಪ್ರೆಸೆನ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, Milord. That is not reference in annexure F, Milord. ಇದರಲ್ಲಿ ರೂಲ್ ದಲ್ಲಿ, Milord, may I read the rule, Milord?
Strength of the panchayat? What is the strength of the panchayat?
16, Milord.
16. 1/3 ಎಷ್ಟಾಗುತ್ತೆ?
1/3, Milord, ಅದೇ 10. 1/3, 6, Milord.
6 ಹೆಂಗಾಗುತ್ತೆ? 1/3 ಎಷ್ಟ್ರಿ?
5. Milord, none point, Milord, the rule says, Milord, presence of the members before the assistant commissioner. There are two, in the rule 3, Milord, may I read the rule 3, Milord? There are two parts in the rule 3(1) dalli.
Yes.
Motion of no confidence. 1. A written notice of intention to move the motion under the proviso to subsection 3 of section 140 of the Act shall be in form number 1, signed by one half of the members of the total elected members together. Next, Milord. With a copy of proposed motion shall be delivered in person. Here there is no reference that there are two persons present in the before the assistant commissioner. Signature ಇದೆ, Milord. ಮತ್ತೇನ್ ಹೇಳ್ತಾರೆ, Milord? By any two of the members signing the notice to the deputy commissioner. There are two kinds, Milord. One is one half is required, so 1/4 or 1/3. Second point is, Milord, the two person must be present before the assistant commissioner. Mere signature of the parties is not.
The petitioner has challenged the notice of no confidence. Has challenged the notice dated 1/1/2025 issued by the respondent
My
number 3.
submission, Milord, there are two persons who are not present before the assistant commissioner.
Proposing to hold a meeting
There is a judgment, Your Lordship, sir.
on 18/1/2025 to consider the request of the members of the panchayat expressing no confidence in the petitioner. Next para. The petitioner was the president. The petitioner is the president of Mallaghan Panchayat. Full stop. Certain members of the panchayat had submitted a representation to the respondent number 3 on 14/11/2024, requesting him to convene a meeting to consider their lack of confidence in the petitioner. Accordingly, the respondent number 3 had issued a notice dated 25/11/2024, proposing to hold a meeting on 12/12/2024. Full stop. The petitioner had challenged the said notice in WP number 203487 of 2024 on the grounds that the representation of the members was not submitted to the respondent number 3 directly, but was submitted to the Panchayat Development Office of the Panchayat.
Your Lordship, so
Who forwarded it to,
it was submitted to the Assistant Commissioner, but there is a reference of PDO signature, Your Lordship. It is for that reason, Your Lordship.
who forwarded it to the respondent number 3. Full stop. Though it was the case of the members that the representation was submitted to the respondent number 3, but certain entries were made on the representation by the Panchayat Development Officer, this court in terms of the order dated 17/12/2024 allowed the writ petition and set aside the notice of the meeting, but granted liberty to the members of the Panchayat to take out fresh proceedings in accordance with Rule 3(1) of the Karnataka Panchayat Raj motion of no confidence against Adhyaksha and Upadhyaksha of Gram Panchayat bracket close rules 1994. Following this, 12 members of the Panchayat,
13
members of the Panchayat submitted a representation on 31/12/2024 before the respondent number 3 and requested him to convene a meeting. Accordingly, the respondent number 3 issued a notice on 1/1/2025 proposing to hold a meeting on 18/1/2025. Full stop. Being agreed with the said notice, the petition is before this court. Next, for the learned counsel for the petitioner contends that the present representation is also filed, is also submitted through the Panchayat Development Officer. He contended that 2 members of the Panchayat did not appear, who had signed the representation did not appear before the Assistant Commissioner and did not submit the representation, and they did not submit the representation. Therefore, he contends that there is a violation of the procedure prescribed under the rules 1994. Thus, he contends that the impugned notice of motion, notice proposing to hold the meeting to consider the no confidence motion is liable to be quashed. Per contra, the learned counsel for the respondents 6/2/20, to the respondent number 7, who has entered caveat, submits that the representation was submitted to the respondent number 3 by all the 13 members who had signed the representation. He submits that there is nothing on record to show that these 13 members did not appear before the respondent number 3. Full stop. He submits that there is also nothing to show that the representation of the members was submitted to the PDO or that the PDO had made any endorsement on the representation. He submits that the signature found on the representation dated 31/12/2024 was that of the Assistant Commissioner, which made it clear that it was submitted to the Assistant Commissioner by the members. Next, I consider
The judgment of this honorable court, Your Lordship, with
the learned counsel for the
One more
private
submission,
respondents.
Lord.
Full stop. Next
Annexure
para.
F ಅಲ್ಲಿ earlier judgment ಬಗ್ಗೆ reference ಇಲ್ಲ ಅಂತ.
He also submitted that the respondent number 3 did not refer to the judgment passed by a coordinate bench of this court in WP number 203487 of 2024. Next, I consider submissions made by the learned counsel for the petitioner and the learned counsel for the respondent number 3. Learned AGA.
We'll take 1, 2, 3.
Learned AGA appearing for response 1 to 3. Supported the contentions of the learned counsel for the respondent number 7. Next para. this court, a coordinate bench of this court in WP number so and so 203487 of 2024 took exception to the participation of the Panchayat Development Officer in the matters of moving a motion of no confidence by the members against the Panchayat, against the President of the Panchayat. Full stop. This court therefore held that the Panchayat Development Officer has no role to play in the matters of consideration of a motion of no confidence and consequently quashed the earlier representation submitted by the members who had moved the no confidence motion. This court had also reserved liberty to the members to file a fresh representation before the respondent number 3, strictly in accordance with rule form number 1. Full stop. Accordingly, the private respondents had submitted a representation before the respondent number 3. The endorsement on the representation shows that it was signed and received by the respondent number 3 and not by the Panchayat Development Officer. Full stop. Therefore, the prime contention of the petitioner that the members had submitted the representation which contained which showed that it was received by the Panchayat Development Officer, cannot be accepted. Insofar as the other contention that two members who submitted the representation did not present themselves before the respondent number 3, there is no material to support the contention. This apart, the claim of the petitioner that the respondent number 3 did not refer to the proceedings and the findings recorded by this court in WP number so and so is also liable to be rejected, as there was no need for the respondent number 3 to reflect upon the findings recorded by this court in WP number so and so while issuing a notice fixing the date of meeting to consider the motion of no confidence. Thus, on all grounds, all grounds raised by the learned counsel for the petition are liable to be rejected. Consequently, the writ petition stands dismissed.
Click. Number 27, Hema L. Kulkarni.
Petitioner has availed loan millets, 1 crore each in 2 accounts.
Uh-huh.
Petitioner has availed loan millets.
Petitioner?
Has availed loan millets with the respondents.
Ah.
They have issued now the attachment warrant millets for non-recovery. The 2 loan amounts millets, 1 crore each.
Well, you are a party before the proceedings or not?
Ex parte millets, ex parte. I do not deny the payment millets. I want some breathing time so that I can.
How much time? What is the total due? 32 lakhs.
No millets, crore, 1
1 crore 23 lakhs.
1 crore 23, one account, 1 crore 37, another account. There are 2 accounts millets. The principal amount is 1 crore millets. Now the demand amount is 1 crore 23 and 1 crore.
How
37.
the writ petition is not maintainable.
I do not deny I'll pay millets if some amount is
Yes, true.
time is.
But
20% of the amount if paid millets, if
Though
permitted to be paid.
this writ petition is not maintainable in view of an alternative and efficacious remedy is available. Since the learned counsel for the petitioner submits that the petitioner is willing to pay up the amount demanded, and that in the meanwhile, the respondents have
Attachment warrant.
issued an order of attachment of the assets of the petitioner, the impugned order is stayed only to enable the petitioner to
That is order on
Payment.
23rd December 2024. ಎತ್ತಿ ಅದು
ಆಯ್ತಾ?
ಆಗಿದೆಯೇನೋ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ ಆಗಿಲ್ಲ ಇನ್ನು ನಿನ್ನೆ ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ ನೋಟಿಸ್.
Payment. As undertaken before this court. Since the impugned order is stayed, subject to the petitioner depositing the amounts, subject to the petitioner depositing 50% of the demand.
50% would be 20% of the total amount.
Madam, I'll dismiss the petition.
50% ಅಂತ 1 crore ಇದೆ, I'll pay 25 and 25 each.
50% ಕೊಡಂಗಿದ್ರೆ I'll
8
take
weeks ಕೊಟ್ರೆ ಮತ್ತೆ ನಾನು I'll pay. If they
50%
give
if you're-
permission to sell the property without mortgage, I'll pay the entire amount.
Madam,
Therefore, my lords.
if you are willing to pay 50%, I'll consider granting stay. 25% and I'll dismiss you. Please go and file an appeal.
ಅಂದ್ರೆ 1 crore ಅಲ್ಲಿ ನನ್ಗೆ ಅದು ಆಗುತ್ತೆ. So if
When you have
some-
taken 1 crore, you have to pay 1 crore. Basic question of saying, no,
No, no, the one kind request is, I have already mortgaged my 4 properties. If they permit me, Lord, one of the property, I'm ready to sell and clear the amount. Therefore, if some breathing point, time is given, 25 lakhs, I'll pay, my lord, each. And then next date may be fixed, my lord, so that they can negotiate.
ಯಾವ
and pay.
ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡ್ತೀರಾ ಕೊಡಿ. Which property will you sell?
Please. Page number 17.
Page number?
17. There are 5 properties, my lords. One, my lords, that is 10 acre, 30 guntas is there, another 9 acre. 30
ಯಾವ್ದು
guntas.
ಸೇಲ್ ಮಾಡ್ತೀರಾ?
Even if survey, I'll ask, my lord, any of the property.
ನೀವ್ ಹೇಳಿ ಯಾವ ಸೇಲ್ ಮಾಡಿದ್ರೆ I'll permit this property to be sold.
If it could be passed over, I'll ask, my lords. Either 10 acres or 9 acres.
Very, reading B group, serial number 20, Nitish Padia.
Petitioner.
The outset, my lord. I am in embarrassing position to make submission, my lord. Two conflicting orders of KAT are there. One is in my favor, one is against me. And my lord, now the Caste Verification Committee says, my lord, that they reject my application on the ground that your lordship may kindly peruse. The facts are that, my lord, I have been appointed as assistant teacher way back in the year 1994, and after completing 16 years of service, they said that there is no Sindhutva certificate produced by me. On that count, I was discharged, dismissed from service. Along with me, 4 other persons were also dismissed. My lord, all 4 of us did approach the Karnataka Administrative Tribunal, my lord, and wherein they rejected my application as per Annexure B, Inc. page 16, my lords. And my lord, under similar circumstances, and the persons who were appointed, some persons who were appointed along with me, and who too were removed from service on the same ground that I have not produced Sindhutva certificate. They were allowed to be continued in service as per Annexure E, my lord, Inc. page 37. On the ground, my lord, your lordship may kindly peruse. Inc. page 42. Para 4, my lords. The contention of the applicant is that if the authorities have failed to obtain the verification of the caste certificates produced by them, they cannot be blamed and the authorities ought to have pursued the matter. It is admitted by the learned government pleader after verification that in these 4 cases, the authorities have yet to receive the caste verification certificate. Since it was the duty of the concerned authority to get the confirmation of the caste certificate produced by the applicant could not have been relieved of their duties, cancelling their appointments. These are the 2 conflicting decisions of tribunal itself.
What prevented you from challenging the order passed by the
No,
state?
that also I have challenged, my lord. That has been dismissed. That is also there, my lord. Now the question will be for your lordship's consideration.
Where have you challenged the order passed by the
one minute.
Karnataka Appellate Tribunal Administrative?
Challenge, my lord. I have challenged.
Illide.
ಬೇರೆ connected matter. ಬಂದೆ ಒಂದೇ ನಿಮಿಷ. It is at Annexure C, my lord.
That is not by you, it is by.
ಅಲ್ಲ sir, the petition number, applicant number 1 who was along with me.
Sir, have you challenged it?
ಇಲ್ಲ. I am submitting, my lord. That is what I will submit your lordship. In Annexure B, my lord, I was there along with the petitioner in writ petition number so and so as per Annexure C. My colleague had also challenged it as per Annexure B, my lord. So that was that came to be dismissed, and that was dismissal has been confirmed by this honorable court as per. There was no scope for me to prefer once again.
Did not challenge.
Yeah, house.
Other nearly.
I am
Why
fairly.
are you beating around the bush?
No, I am fairly conceding. I am not.
I should say that you are fair.
Yes, yes.
No, you don't accept that you are fair.
I agree. I fully agree.
Ah.
Now the question is, my lord, other similarly situated employees who are along with me, who are discharged, they have been reinstated on the ground of by following the order passed by administrative tribunal
Yes.
as per annexure E, my lord. Now the question is, my lord, when similarly situated employees have been reinstated, and the, my lord, the authority which was before the appellate authority, it submitted that it doesn't have any documents since the matters, the documents are pertaining to 20 years. My respectful submission before your lordship is the 20 years document, when they say that they don't have any documents, and at the time of employment, I have produced those documents. It is not their case, my lord, that I have not produced any documents, and without producing documents, I gain the employment. Now the question is, my lord, after more than 16 years of my service, and when other similarly situated employees have been regularized and reinstated as per annexure F, my lord, my respectful submission before your lordship that similar order may kindly be passed, as Article 14 will come into picture.
What Article 14?
Pardon, sir?
What Article 14?
No, my lord, there is discrimination. The persons who were... Please.
If I understood your case properly,
Yes, obliged.
you had filed an appeal.
House.
You had filed an appeal
House.
against some order
Yes, madam.
before the commissioner.
First before the KAT, my lord.
No. Annexure A, no.
That is impugned order.
ಸಿಂಧುತ್ವ ಪ್ರಮಾಣ ಪತ್ರದ
ಹೌದು
ಬಗ್ಗೆ
ಸರ್.
ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುವ ಕುರಿತು
ಹೌದು sir. That is the order
Filed an
passed by
appeal.
the appellate authority.
you filed an appeal under section 4C or whatever.
Please.
Your appeal was dismissed.
House.
Correct.
House.
You challenged it before the KT.
ಅಲ್ಲ ಸರ್, ಮೊದಲೇ ನಾನು ಅಗೇನ್ಸ್ಟ್ ಮೈ ಆರ್ಡರ್ ಆಫ್ ಡಿಸ್ಮಿಸಲ್ ಇದರಲ್ಲಿ ಪೇಜಿನೇಷನ್ ಈಸ್ ಫಸ್ಟ್ ಮೈ ಆರ್ಡರ್. Annexure A is the impugned order. Annexure B is the I have challenged the order of
So
my
therefore,
authority.
after your application before KT was dismissed,
Ah.
you filed an appeal before the appellate authority.
House.
That is dismissed.
House.
Correct.
House.
This writ petition was also, sorry, KT order was also, it was not challenged by you.
ಮಾಡಲಿಲ್ಲ.
It was not challenged by you. What did the appellate authority, sorry,
ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಸರ್, ಇಟ್ ಈಸ್ ಫಾರ್ ದಿ
what does the administrative the tribunal say in your case?
ಅದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಸರ್, ಪ್ಯಾರಾ 7 my lord, ink page 29 my lord. What it says, my lord, the rules framed under the act provides that every person claiming reservation either for the appointment or for admission to education institutions shall submit an application in form number 1 for verification of a caste or caste income, and verification of the same will be done under rule 6A. Validity certificate is issued under rule 7. If anybody is aggrieved by the order passed by so and so, he has a right of appeal under so and so. That is annexure 4D antars. By saying so, your lordship may kindly see the operative. However, the applicants ink page 31 my lords. However, if the applicant desire to challenge the respective conclusions of caste verification committee, they are at liberty to approach the appellate authority along with the application for condonation delay. This is the order that has been passed by KAT only, my lord. And subsequent order, that is earlier order, my lord. Subsequent order, sir. Incidentally, the problem is because, my lord.
ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ನಿಮ್ಮ ಜೂನಿಯರ್ಸ್ ಇದಾರಲ್ಲ, ಒಂದ್ ಸ್ಕೇಲ್ ತಗೊಳ್ಳಿ. ಸ್ಕೇಲ್ ತಗೊಂಡು ಕೈಗೆ ಸರಿಯಾಗಿ ಬಾರಿಸಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಹೇಳಿದೆ, ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ನೀವು ತಯಾರು ಮಾಡಕ್ ಬಂದಾಗ ಫಸ್ಟ್ ಡೇಟ್ ವೈಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ಜೋಡಿಸ್ಕೊಳ್ರಿ.
ಹೌದು. I fully consider that there is lapse.
Whoever is your junior who has done this job, ಒಂದ್ ಸ್ಕೇಲ್ ತಗೊಂಡು ಗೆಣ್ಣಗ್ ಇದು ಊತ ಬರಂಗ್ ಹೊಡಿಬೇಕು.
I will.
2009 ಫಸ್ಟ್ ಬಿ ಆಗ್ತೀರಾ, 2014 ಸಿ ಆಗ್ತೀರಾ, ಎಂತೆಂತ.
I will instruct. I may be pardoned.
This is what happens.
ಹೌದು.
You do not know what is your case.
It leads to confusion. Fairly confused.
Hmm.
Now the question will be, my lord, now the authority has submitted before the appellate authority that they do not have any documents. Whether I approach any other authority, the same defense they will be taking. Now
Yes.
my humble submission before your lordship is, your lordship may kindly peruse other similarly situated employees. Your lordship may kindly 47, ink page 47, my lord.
Hmm.
Lordship got it? Para.
ಹಾ.
ಈ ಮೇಲೆ ನಮೂದಿಸಿರುವ
ಹಾ.
ಈ ಮೇಲೆ ನಮೂದಿಸಿರುವ 4 ಅಭ್ಯರ್ಥಿಗಳ ಪೈಕಿ ಅಭ್ಯರ್ಥಿಗಳು ಉಲ್ಲೇಖ 8 ಅನ್ವಯ ಹೊರಡಿಸಲಾದ ಈ ಕಚೇರಿಯ ಆದೇಶದ ಅನ್ವಯ ಸೇವೆಯಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿದ ಸಮಯದಲ್ಲಿ ಗುಲ್ಬರ್ಗಾ ಜಿಲ್ಲೆ ವಿವಿಧ ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಈ ಮಧ್ಯೆ ಸದರಿ ಶಾಲೆಗಳಲ್ಲಿ ಅವರ ಬಿಡುಗಡೆಯಿಂದ ತೆರವಾದ ಹುದ್ದೆ ಭರ್ತಿಯಾಗಿದೆ. ಆಗಿದ್ದ ಪ್ರಯುಕ್ತ ಓರ್ವ ಶಿಕ್ಷಣ ಹೊರತುಪಡಿಸಿ ಉಳಿದ 2 ಶಿಕ್ಷಕರಿಗೆ ಅದೇ ಶಾಲೆಯಲ್ಲಿ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಮುಂದುವರೆದು ಇನ್ನೋರ್ವ ಅಭ್ಯರ್ಥಿಯಾದ ಶ್ರೀ ಲಕ್ಕಪ್ಪ ತಂದೆ ವಿಠಲ್ ಬಿಸಿನಾಳ್ ಇವರು ಜಿಲ್ಲೆಯಲ್ಲಿ ನೇಮಕಾತಿ ಹೊಂದಿ ತದನಂತರ ವಿಜಯಪುರ ಜಿಲ್ಲೆ ವರ್ಗಾವಣೆ ಪಡೆದುಕೊಂಡಿದ್ದು 8 ಅನ್ವಯ ಹೊರಡಿಸಲಾದ ಆದೇಶದಂತೆ ಸರ್ಕಾರಿ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಬಬಲೇಶ್ವರ ತಾಲೂಕು ಸಿಂದಗಿ ಜಿಲ್ಲಾ ಬಿಜಾಪುರ ಈ ಶಾಲೆಗೆ ಬಿಡುಗಡೆ ಹೊಂದಿದ್ದು ಪ್ರಸಕ್ತವಾಗಿ ಈ ಶಾಲೆಗೆ ನಿಯುಕ್ತಿಗೊಳಿಸಲು ಈ ಕಚೇರಿಗೆ ಅಧಿಕಾರ ಇರೋದಿಲ್ಲ. ಮುಂದುವರೆದು ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮಂಡಳಿ ಆದೇಶದಂತೆ ಸದರಿ ಅಭ್ಯರ್ಥಿಗಳ ಜಾತಿ ಪ್ರಮಾಣ ಸಿಂಧುತ್ವವಾಗಿ ಈ ಕಚೇರಿಯಿಂದಲೇ ಪಡೆಯುವ ಅನಿವಾರ್ಯತೆ ಇರುವುದರಿಂದ ಸದರಿ ಅಭ್ಯರ್ಥಿಗೆ ಇದೇ ಜಿಲ್ಲೆಯಲ್ಲಿ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸುವ ಅವಶ್ಯಕತೆ ಇರುವುದರಿಂದ 11 ಅನ್ವಯ ನಡೆಸಲಾದ ಕೌನ್ಸಿಲಿಂಗ್ ಹಾಜರಾದ ಈ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಸ್ಥಳ ನಿಯುಕ್ತಿಗಾಗಿ ಆಯ್ಕೆಗೊಂಡಿರುವ ಶಾಲೆಗಳಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಸೂಚಿಸಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮಂಡಳಿ 9 ಅನ್ವಯ ನೀಡಿದ ಆದೇಶವನ್ನು ಅನುಷ್ಠಾನಕ್ಕೆ ನಡೆಸುವ ಕುರಿತು ಈ ಕೆಳಗಿನಂತ ಆದೇಶ ಕೊಡ್ತಾರೆ ಸರ್. And the order, as per the order of the Honorable Tribunal, my lord, that is at serial number 12, which I have produced at Annexure E, my lord, they have implemented. It seems, my lord, it may not be fair on my part to say anything, comment anything against the order of tribunal, my lord, but it is factually. It is for that reason I am before your lordship.
So that reason before this court, you lost it by your own.
True, my lord. What I am submitting, my only my submission is that, my lord, by following that judgment of KAT, there has been order of reinstatement for no fault on my part, my lord. They say, my lord, that documents are not there with them. And the law says, my lord, that it is for the competent authority or appointing authority to get it verified immediately at the time of appointment, my lord. After appointing, after declaring probationary period, everything, after 16 years, my lord, they asked me to bring it, which is not factually.
But you have to prove that you belong to this caste.
Allah, sir, my submission, when I have submitted, now they say, my lord, that they are required to get it verified from the caste verification committee. It is for the authority. They have not done it. On earlier occasion, one occasion, the Honorable Tribunal says, my lord, that it is the duty of the applicant. In another occasion, same authority, my lord, incidentally, the author of both the orders are the same Honorable, I have high regards, my lord, I am not making.
Right.
There may be, but one order has been followed by the government, my lord, department, and they have ordered for reinstatement.
To challenge the order passed by the tribunal. See, the tribunal in your case.
I am not disputing, my lord, I am not disputing.
Let us see what the tribunal has said in your case. What does the tribunal say?
Page number 14, my lord, page
Page
para
number
3.
31. However, if the applicants desire to challenge respective conclusions of the caste and income verification committee, they are at liberty to approach the appellate authority along with application for continuation of delay. This was the finding.
No, my lord, it's for that reason I have made the submission that it is embarrassing me to make a submission, my lord. My prelude was that 2 judgment orders are there from the KAT, my lord. My humble submission would be, my lord, I am a lady, I am hailing from a lower strata of society, and for no fault, my lord, my humble submission, I have submitted at the time of my appointment. Now the tribunal itself says, my lord, that it is for the competent authority to get it verified immediately after my employment. There cannot be the declaration of probation, my lord.
Yes.
My humble submission. And without backways also, my lord, she is at the, now she is more than 55, my lord, as on date. My lord, I will be put to, for no fault on my part, I am going to, and my lord, your lordship may also kindly take into consideration. The authority has submitted before the appellate authority that they do not have any documents. Wherever I go, the same submission will be there, my lord. No, my lord,
You missed
my humble submission, it needs human consideration, my lord. And under 226, your lordship may pass any orders. My lord, it is not their case, my lord, that I am inefficient, and not a single charge sheet has been issued, and it is no fault on my part, my lord. I will be losing.
It's not the question of
No, no,
inefficiency.
16 years of service I have put in.
Question is, you have taken a post which is reserved for one community.
Obliged, my lord.
Correct.
Yes.
Now the authority says you do not belong to that.
Illa, andilla, sir.
The challenge madadini nenu.
No. What they have said is that produce the Sindhutva certificate.
Houdu.
Sindhutva certificate, it is for them to get it verified. They did not do it.
Correct. So you lost the litigation before the KAT.
Hello, sir. I am not, I have not suppressed anything. I have fairly submitted before this honorable court. This is the position, my lord, under which, under peculiar circumstances, without making it as a precedent, my lord, your lordship, without backways, my lord, with continued service, if I am reinstated, for the service which I have rendered, unblemished service of 16 years, that will also go, my lord. That will also go.
Barcode.
Your lordship may kindly consider my humble submission, my lord. There is no any allegation of any fraud or misrepresentation or any cheating or otherwise. She is the victim of circumstances, my lord, under which she has been placed.
1990 Act code.
Para numbers.
1990 Act code, SC, ST.
SC, ST.
Hmm.
And the authority has submitted, my lord, that they do not have any documents.
Barcode. The petitioner has challenged the order dated 12/7/2017, order bearing number so-and-so dated 12/7/2017, passed by the respondent number 2, rejecting an appeal filed by her under section 4D,
4D, madam.
Section 4D of
Yes.
the Karnataka Scheduled Caste, Scheduled Tribes and other backward classes, bracket reservation of appointment, etc., Act 1990. She has also sought for a consequential relief to reinstate her into service with full back wages, continuity of service, etc. Continuity of service with all other benefits. Next para. The facts as stated by the petitioner in the writ petition are that she was appointed as an assistant teacher in the year 1994 against which was reserved for Group B. 1994, full stop. The petitioner claimed the benefit of a Group B candidate. Full stop. She had furnished her caste and income certificate issued by the jurisdictional Tahsildar. Full stop. She contends that the respondent number 2 was bound to get the caste and income certificate verified from the Caste Verification Committee, Income and Caste Verification Committee. However, the petitioner and similarly situated assistant teachers were terminated on the ground that they did not produce the validity certificate. Full stop. The petitioner challenged the said order before the Karnataka Administrative Tribunal in application number 2213 of 2010. Full stop.
Along with others.
The tribunal by order dated 17/6/2013 dismissed the petition, dismissed the application, but reserved liberty to the petitioner to challenge to obtain a validity certificate. Full stop. Accordingly, the petitioner approached the appellate authority under section 4D of the Karnataka Scheduled Caste Act of 1990. Full stop. Respond 4. She contends that she had also approached the respondent number 4, hoping to obtain a validity certificate. However, the respondent number 4 issued an endorsement that the documents were more than 20 years old, and therefore he was not in a position to issue a validity certificate. Full stop. ನೋಡಿ ಹೆಂಗೆ ಇದೆ, this is what is.
Pardon?
ಏನ್ ಮಾಡಮಾಯ್ತು? Full stop. Next paragraph. The petitioner contends that the secretary to the government of Karnataka, by letter dated 16/9/1995, had directed the respondents not to terminate the services of employees whose validity certificate was rejected by the Income and Caste Verification Committee till further orders. She contends that the Director of Primary Education did not pass any orders She contends that under similar circumstances, 4 similarly situated assistant teachers who are also appointed along with the petitioner and who are also discharged on the same ground of not producing the caste and income validity certificate had approached the Karnataka Administrative Tribunal in application number 2219/2010, 2237/2010, 2238/2010, and 2240/2010, which were disposed of by the tribunal in terms of the order dated 24/7/2012, wherein it was stated that it was the duty of the department to obtain the verification/validity. Full stop. She therefore contends that on the basis of the directions issued by the tribunal, the respondent number 5, by order dated 20th of January 2014, had reinstated and extended all consequential benefits to the petitioners therein. The petitioner is therefore before this court seeking for a direction, challenging the order passed by the respondent number 2 and seeks for a further direction to the respondent number 5 to reinstate her into service. Next paragraph. The learned senior counsel representing the petitioner contends that the Karnataka Administrative Tribunal, in the case of the petitioner and others, had directed the petitioner to approach the appellate authority and obtain a validity certificate, while in similar circumstances, the same tribunal had held that it is a responsibility, it is a duty of the employer to obtain the caste and income validity certificate. He submits that based on the later order passed by the tribunal, employees who were, the assistant teachers who were similarly situated as the petitioner were reinstated into service. He therefore contends that the petitioner is also entitled to be treated alike, and her service is also to be reinstated, restored. Full stop. Per contra, the learned AGA submits that the petitioner did not challenge the order passed by the tribunal, by this administrative tribunal, but allowed it to become final. He submits that following the order passed by the tribunal, the petitioner filed an appeal before the respondent number 2, which passed the impugned order, holding that holding that the respondent number 4 had issued an endorsement that there were no documents available, as it was more than 20 years old.
20 years.
Full stop. He therefore submits that the petitioner cannot now assail the order passed by the Karnataka State Administrative Tribunal or attempt to dilute the order passed by the tribunal by contending that the tribunal had in similar circumstances taken a different view. Full stop. Thus, he contends that the petitioner is not entitled to any remedy in this writ petition. Next, consider the submissions of the learned senior counsel for the petitioner and the learned AGA for the respondents. Next para. It is not in dispute that the services of the petitioner was terminated on the ground that
Hindutva certificate Kotila.
on the ground that when the caste certificates were sent for verification, when the caste certificate of the petitioner was sent for verification, the Caste and Income Verification Committee was of the opinion that the petitioner did not belong to the caste claimed by her. Full stop. Therefore, the appointment of the petitioner was cancelled. Full stop. This order of termination of the service of the petitioner was challenged by petitioner and similarly situated persons in application number 2213 of 2010 and other applications. Full stop. The Karnataka State Administrative Tribunal held that an appeal is provided under Section 4D of the Act of 1990 against an order passed by the Caste and Income Verification Committee, and therefore the petitioner is bound to file an appeal before the appropriate authority. Full stop. Following this order, the petitioner has challenged the order passed by the district caste
Pardon?
district
Page number.
Caste verification committee.
District Caste Verification Committee before the appellate authority under 4D of the Act 1990. The appellate authority, taking into consideration the findings recorded by the district committee that there are no documents available with it, and also having regard to the fact that the petitioner had challenged the order passed after nearly 30 after nearly after the limitation prescribed under the Act, rejected the appeal. Full stop. The petitioner has now challenged the said order before this court in this writ petition. Full stop. The case of the petitioner is that in respect of similarly situated person, the tribunal had passed an order holding that the duty to obtain the caste and verification report, duty to obtain a validity certificate was upon the employer and not the employee. And therefore, the order terminating the employees on the ground that they had not obtained the validity certificate was set at naught. And they were ordered to be reinstated. Full stop. If the petitioner was not, if the petitioner is unable to establish that she belonged to a particular caste or that her income was well below the limit prescribed, and therefore she was entitled to claim the benefit of Group B, the petitioner cannot now draw a parallel and contend that similarly situated teachers were extended the benefit. Full stop. If the petitioner was aggrieved by the order passed by the full stop, if the full stop under rule 5 ಏನದು 5
5.
proof ಏನೋ ಇದೆಯಲ್ಲ
ಅಲ್ಲ, challenging the order passed on 4D is.
It is also relevant to note that under section 4A5 of the Act of 1990, the burden of proving that a person or his parent or guardian belongs to scheduled caste, scheduled tribes or other backward classes shall be on the applicant. Full stop. It was therefore incumbent upon the petitioner to have produced documents before the appellate authority to establish that she belonged to Kabaliga caste and that her income was well below the limit prescribed for a Group B category. Full stop. In that way of the matter, the petitioner is not entitled to any relief in this writ petition. Once the petition lacks merit and is dismissed.
At least liberty may be reserved
ಏನಕ್ಕೆ
to challenge that order of
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ
annexure A.
ಅನಕ್ಷರೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಇದು ಪಿಟಿಷನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಮಾಡಿದೀವಿ ಸರ್.
ನೋಡಿ
Jurisdiction ಇಲ್ಲ, annexure A I have challenged.
annexure A is the order passed by the appellate authority.
No, tribunal I can go, my lord. Appellate tribunal ಅಂತಿದೆ. ಅಲ್ಲಿ I can under
ಎಲ್ಲಿದೆ ಯಾವ
subsection 5 ಇರಬೇಕು.
ಕೊಡಿ ಇದು ಯಾವ
Liberty is reserved, he can avail as per law.
ಯಾವ ಸೆಕ್ಷನ್ 5
ಒಂದಿದೆ, I am sure.
ಯಾವ ಸೆಕ್ಷನ್ 5 ಅಲ್ಲಿ
Against the order of
4D ಆದ್ಮೇಲೆ ಯಾವ್ದಿದೆ ರಿವಿಷನ್ ಇದೆ ಅಷ್ಟೇ.
she is at liberty to avail as per law.
However, if the petitioner is entitled to file up any revision under section 4F of the Act of 1990, she is at liberty to do so.
Obliged.
Number 29.
ನೋಡಿ ಇದೆಲ್ಲ ರಾಂಗ್ ಅಡ್ವೈಸ್ ರಾಂಗ್ ಇದು ಇವಾಗ DC ಮುಂದೆ ಹೋಗ್ತೀರಿ.
The problem was I was in fix, my lord, your lordship.
Fix ಅಲ್ಲ sir.
Beginning of
no, against an order passed under section 4D, you have to go before the deputy commissioner.
ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರೆ, they don't have any documents at all.
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ವಾ ಅಲ್ಲಿ ಇಲ್ಲಿಗೆ ಬಂದು ಇಲ್ಲಿ ಎಷ್ಟನೇ ಇಸ್ವಿಯಿಂದ ಇಲ್ಲಿದ್ದೀರಾ? From 2017, 18 ಇಂದ ಇಲ್ಲಿದ್ದೀರಿ. 6 ವರ್ಷ ಹೋಯ್ತು ಇಲ್ಲಿ.
She is very poor, my lord.
Sir, what?
ಮಂದಿ ಮನೆ she
is poor, but what about the lawyer? Lawyer is not illiterate. Lawyer is literate.
In spite of that,
no.
There are certain things, my lord, which we not be in a position to.
Wrong advice, sir.
No, there wasn't any wrong advice, my lord. It is for that reason I sought your lordship's pardon that because I am in a fix.
Very wrong advice. DC ಮುಂದೆ ಹಾಕಿಯೋ ಇವಾಗ 6 ವರ್ಷ ಆಯ್ತು.
ಇಲ್ಲ, ಡಿಸಿನ ಮಾಡಿದ್ದು ಆರ್ಡರ್ ಸರ್, ಇದು ಕಾಸ್ಟ್ ವೆರಿಫಿಕೇಶನ್ ಕಮಿಟಿದವರೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದು.
4D ಅಪೀಲ್ ಹಾಕಿರೋದು 4D ನಲ್ಲಿ.
4D ಅದೇ ರೀ ಸರ್.
4D ಆದ್ಮೇಲೆ 4F ಅಲ್ಲಿ ಇದೆ ರಿವಿಷನ್ ಹೋಗ್ಬಿಟ್ಟು ನೀವು ಹೈಕೋರ್ಟ್ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಅದೇ ರಿವಿಷನ್ ಬೆಂಗಳೂರು ಇದೆ.
ಬೆಂಗಳೂರ ಬಾಂಬೆನೋ ಎಲ್ಲ ಒಟ್ಟು ರಿವಿಷನ್ ಇದೆ. You should have gone there. 6 years have gone by. Whose time? Litigation ಕೋರ್ಟ್ಗೆ ಬಂದಿರೋರಿಗೆ ಪಾಪ ನ್ಯಾಯ ಸಿಕ್ಲಿಲ್ಲ.
Please, madam.
Yes, next.
29 AM Nagar.
I appear for the petitioners in this matter, my lord. My lords, the petitioners were appointed as temporary lecturers in in the late 1980s, my lord, and subsequently they were admitted to grant-in-aid, and their services were also regularized. Now the question, my lord, is that whether for the purpose of calculating the pay scale and pensionary benefits, should their services from the date of initial joining till the date of retirement, should that be considered, or from the date of entry of the college into grant-in-aid till the date of their retirement?
When did they enter service?
They entered service in their 1994, my lord. My lords, one submission. The same issues are now pending before the division bench, before this honorable court, and that is stated to be taken up today, my lord. Therefore, I pray, my lords, to have this matter after the disposal of the writ appeal, my lord.
Pending before the division bench.
They are entitled for at least pay and pension past service ತಗೊಳ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ ಇದು this annexure F is recovery of excess paid salary, not regarding
No, he
pension.
said it's regarding
No, my lord, it is in respect of,
counting of past service.
this is in respect of excess paid salary, wherein out of 29 persons, 23 have paid, only 5 have approached this honorable court.
He began the argument by saying that past service has to be counted. Is that?
That is the order under challenges annexure F, the memo.
My lords,
Please wait.
Based upon the objection raised by the government, my lord, audit, finance audit, we have given
Actually,
this
F,
annexure F, page 78.
page 78.
78, my lord.
78, writ petition
This is
order
the
ತಂಗಿದೆ.
memo, my lord.
Page 82.
In our case.
Excess paid salary of following faculty is to be recovered due to various reasons as per the audit report of the DTE. Will the audit report?
My lord, they are not produced. Government,
List this petition after disposal of writ appeal.
writ appeal number 2476 of 2015, my lord.
Also, next.
please.
Number 30,
Grateful, my lord.
EP Ambedkar.
The father of the petitioner, my lord, he was working under the Respondent Bank, the public sector bank. He died while in service, my lord. Therefore, the petitioner, my lord, she filed an application for compassionate appointment. The same was rejected only on ground that petitioner is a married daughter. That is the only ground.
The earlier judgment of this court is now set aside. Married daughter.
Hakbekadra that was there. I'll just go through any other judgments.
Nagaprasanna's judgment is.
I'll just
set
go
aside.
through the judgments because at the time of filing that was holding the field. I'll just go through and submit one date next week.
You want time?
I want time. I'll just go through. I also checked, my lords, it is now.
Learn counsel for the petition seeks time as a last chance list on date.
22,
Please.
number 31, Prashant BK,
Prashant BK,
Priya Kulkarni,
Prashant BK. Prashant BK.
Prashant BK,
Supriya Kulkarni, Sangeeta, Mohammed Ahmad. There is no representation for the petitioner. The last chance list on
22-1,
Mantesh Patil.
number 32, Arjun. Number 33, PV Vilas Kumar.
Please.
P. Vilas Kumar.
My name kindly in 32.
In
serial number 32.
32 ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ
ಗೌರೀಶ್ ಕಾಶಂಪುರ್ ಯಾರು?
state of hearing, my lords.
Somebody is dead in Gaurish Kashampur's family.
Sudarshan, sir, they have submitted that they will furnish the documents so that writ petition would be.
Lord, in fact, what I have submitted on last occasion, Lord, passed on to the Lord concerned officer. But Lord, what has been told, Lord, informed by the officer is, Lord, it's difficult to Lord ascertain the Lord said information. Anyhow, my lord, they are trying, my lord, their best. If any possible, they will, my lord, in between whatever the date is given now, my lord, by the time I will try my one more, my lord, best efforts, my lord, please.
Yes. List on date, other date ಕೊಟ್ಟಿದ್ದಾರೆ. Nitesh Vilas Kumar, yes, Nitesh.
Kindly, my lords, I appear for respond number 4. I received a NOC from the earlier council as he was taken on panel of the respond number 3, Panchayat. I need some instructions in this matter.
Learn counsel for the respondent.
29th, sir.
List on.
29.
My lord,
29.
name of P. Vilas Kumar may be deleted.
29
Office is directed to delete the name of
Please.
Mr. P. Vilas Kumar Marthan Rao as the counsel for the petitioner and continue the name of Nitesh Vilas Kumar as per order dated 24/11/21. ಯಾಕೆ ಇದು ಆಫೀಸ್ನವ್ರು ಯಾಕೆ ಮಾಡಿಲ್ಲ? ಕರ್ದು ಹೇಳ್ರಿ.
Ablash.
Number 34 urgent, number 35, K. Dheeraj Kumar.
ಕೆ ಧೀರಜ್ ಕುಮಾರ್, ಹೇಮಾ ಎಲ್.ಕೆ. ಸಂತೋಷ್ ಕುಮಾರ್ ಮರಡಿ. ಸಂತೋಷ್ ಕುಮಾರ್ ಮರಡಿ. Land is not acquired or compensation is not paid?
Utilized but not, compensation not paid.
Land utilized, compensation not
Yes,
paid.
yes. They say it is upgraded. Earlier it was state highway, later it was upgraded to national highway. That is what the government says, and the even on the
Was it
last
listed
occasion.
earlier?
My lords,
It was listed on 6/1.
last occasion also, because the respondent to council was not
Will-
present, it is adjourned to today.
ಸಂತೋಷ್ ಕುಮಾರ್ ಮರಡಿ. ಬಂದಿಲ್ವಾ?
Last occasion also.
ಬಂದಿದಾರಾ ಇಲ್ಲ?
Council earlier.
ಪಾಸ್ ಓವರ್.
Number 36 urgent. Number 37, K. M. Gate.
ಹ್ಮ್.
Here for the respondent, I think, the week's accommodation may not to file objection. I have informed the petition council.
ఇప్పుడు 2 ವರ್ಷದಿಂದ ಆಯ್ತಲ್ಲ.
By mistake, they have sent there was earlier round of litigation, my lord, the same, ಅದೇ statement ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ, I had to return it back. Earlier round of litigation was there, ಅದನ್ನೇ sign ಮಾಡ್ಬಿಟ್ಟು ಹಾಗೆ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Learn counsel for the respondent number 2 and 3. Seeks time as a last chance list on date.
27th, my lord, it would be
22-1.
27. No, I am seeking, my lord, 27th, my lord, it would
ಅದು ಯಾವತ್ತು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವತ್ತು?
29, please.
29-1.
Please.
Number 38, Sharanabasappa K. Babu Shetty.
Yes, my lord, the petitioner sought for writ of mandamus, my lord, the
For what?
annexure N is the order passed by the first respondent, my lord, the annexure N. On the basis of the order, my lord, I have to be continued with the panchayat as a bill collector, my lord, the, but the panchayat is not allowing me to, my lord.
Annexure N ಓದಿ.
Married.
Annexure N.
Operative portion I am ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಆಳಂದ್ ತಾಲೂಕಿನ ಜಡಗಾ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಶ್ರೀ ಬಂಗಾರಪ್ಪ ತಂದೆ ಕಾಮಣ್ಣ ಇವರನ್ನು ಕರವಸೂಲಿಗಾರ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದಕ್ಕೆ ಅನುಮೋದನೆ ನೀಡಿ ಆದೇಶವನ್ನು ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ತಡೆ ಹಿಡಿಯಲಾಗಿತ್ತು. ಆದ್ದರಿಂದ ಉಲ್ಲೇಖ 3ರ ದೂರಿನಲ್ಲಿನ ಅಂಶಗಳನ್ನು ಕುರಿತು ದಿನಾಂಕ 27/6/22 ಹಾಗೂ 4/7/22ರಂದು ವಿಚಾರಣೆ ನಡೆಸಿ ಸದರಿ ಕರವಸೂಲಿಗಾರ ಇವರ ತಡೆ ಹಿಡಿದ ಅನುಮೋದನೆ ಆದೇಶವನ್ನು ಹಿಂಪಡೆದು ಉಲ್ಲೇಖ 1-2ರಂತೆ ಮುಂದುವರಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಈ ಅನುಮೋದನೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸಲ್ಲಿಸಿರುವ ಮಾಹಿತಿ ವಿವರ ಹಾಗೂ ದಾಖಲೆಗಳ ಆಧರಿಸಿ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದೆ. ಯಾವುದೇ ಅನಧಿಕೃತ ತಪ್ಪು ಮಾಹಿತಿ ದಾಖಲಿಸಿದರೆ ಕಂಡು ಬಂದರೆ ತಕ್ಷಣ ಅನುಮೋದನೆಯನ್ನು ರದ್ದಾಗಬಹುದು.
Yes.
This is the, my lord, the order.
Yes, why you are not given effect to this?
My lord, now, my lord, the PDO has made a complaint to the Jilla Panchayat officer saying that his appointment itself is illegal. There is an insertion in the records. My lord, now the matter is before the Jilla, before the CEO Jilla Panchayat. My lord, direction may be given to CEO Jilla Panchayat to consider at the earliest and pass appropriate orders, my lord.
Barkul.
On 23/1/23.
Objection ಹಾಕಿದಿರಾ?
ಇಲ್ಲ, I am
The
producing the
petitioner
copy of the.
written in the nature of mandamus to direct the respondent number 4 to implement the order bearing number so and so dated so and so passed by the respondent number 2. Next para. The petitioner contends that he is appointed as a bill collector by the respondent number 4 on 24/1/2014. He reported to duty on 25/1/2014. And his service was confirmed. Full stop. He claimed that he was working ever since then as a bill collector with the respondent number 4. Full stop. When the when the respondent number 4 sent the appointment of the petition for approval to the respondent number 3, comma, the respondent number 3 forwarded it to the respondent number 2 in terms of a letter dated 24/8/2017. Full stop. The respondent number 4 thereafter addressed a communication dated 9/10/2020 to the respondent number 3, stating that the respondent number 4 has no objection for confirmation of the service of the petitioner. Full stop. The respondent number 3 then sent a proposal. Then sent the proposal submitted by the respondent number 4 to the respondent number 2 in terms of a letter dated 12/10/2020. Full stop. The respondent number 4 seems to have issued a confirmation certificate stating that it has no objection to confirm the services of the petitioner. Accordingly, the respondent number 2 confirmed the services of the petitioner by order dated 28/9/2021. Thereafter, on 30/9/2021, the respondent number 2 issued a correction stating that the petition in its order dated 28/9/2021, it had mentioned that the petitioner was promoted from the post of pump operator to bill collector, and that it must be read as directly selected to the post of bill collector. Full stop. It is alleged that on a complaint lodged by a person named Shivanand on 22/10/2021, the respondent number 2 state the order of confirmation of the service of the petitioner. Full stop. After conducting an in-house inquiry, the respondent number 2 withdrew the stay of confirmation and directed the respondent number 4 to take steps in accordance with the letter dated 28/9/2021 and the correction and the corrigendum dated 30th of September 2021 and ordered the continuation of the service of the petitioner. Full stop. The petitioner contends that accordingly he reported to duty on 14/7/2021 and signed the attendance register. However, he contends that the respondent number 4 and its Adhyaksha are not allowing the petitioner to work with the respondent number 4, and they are not allowing the petitioner to sign the attendance register. Next paragraph. The petitioner is therefore before this court seeking for a direction to the respondent number 4 to implement the order passed by the respondent number 2 referred supra. Next, the learned counsel for the petitioner reiterated the above contentions and claimed that the respondent number 4 is bound to implement the order passed by the respondent number 2. And since it is not done, an appropriate writ has to be issued to the respondent number 4. For contra, the learned counsel for the respondent number 4 contends that
a complaint has been given by the PDO to the CEO, my lord, saying that his appointment itself is illegal as there was an insertion in the.
contending that the respondent number 4 has now addressed a communication dated 23/1/2023 to the respondent number 2, stating that the petitioner has tampered
Yes, my lord.
his
The petitioner, the earlier Adhyaksha has tampered the resolutions of the Gram Panchayat.
ground that the earlier that the erstwhile Adhyaksha of the Panchayat had tampered the resolutions of the Panchayat
And is
had
inserted his appointment, my lord.
had inserted the name of the petitioner to seem as if he was appointed. Full stop. He therefore submits that steps would be taken soon after the respondent number 2 passes appropriate orders on the communication addressed by the respondent number 4. Next paragraph. Since the petitioner is appointed on 24/1/2014 and his services are approved by the respondent number 2 on 28/9/2021, the respondent number 4 is bound in law to fall in line and comply with the directive issued by the respondent number 2. Full stop. The claim of the respondent number 4 that the resolutions of the Panchayat are now tampered to insert the name of the petitioner and that a communication in that regard is addressed to the respondent number 2 by the respondent number 4, cannot make, cannot harm the respondent number 4 to stop the petitioner from working at the respondent number 4. Full stop. If the petitioner has to be removed from service or any steps have to be taken against the petitioner, the same should be done in accordance with law by conducting an inquiry as prescribed. Full stop. Therefore, notwithstanding the claim of the respondent number 4 that the erstwhile president of Adhyaksha of the Panchayat had tampered the resolution, the respondent number 4 is bound to comply the order passed by the respondent number 2 as stated above and allow the petitioner to work and sign the attendance register. Full stop. Since that is not done, a direction deserves to be issued to the respondent number 4 to comply the order passed by the respondent number 2, reserving liberty to the respondent number 4 to take whatever action that is available against a petitioner in accordance with law.
Please.
In that way of the matter, this petition is allowed. A direction is issued to the respondent number 4 to forthwith comply the order dated so and so passed by the respondent number 2 and allow the petitioner to work and sign the attendance register and also prepare the salary bills payable to the petitioner. Full stop. If however the respondent number 4 has come upon as if however the respondent number 4 has come to know of any misdeeds or misconducts or mistakes committed by the earlier Adhyaksha of the Panchayat, he shall take necessary action in accordance with law. It is needless to mention that such action shall be only after hearing the petitioner and complying the due process of law.
Please.
Number 39, Ravi B. Patil.
Hearing on the response. Yes, objections ಹಾಕಿದ್ದೀರಾ? Have filed. ಎಲ್ಲರೂ ಹಾಕಿದ್ದೀರಾ?
Fact, I am sailing with my department, respondent number 2. I am sailing with respondent number 2.
I am not challenging his promotion. What we are saying is, my lord,
The matter requires to be heard.
how?
Ah.
My lord, petitioner, my lord, was originally appointed as junior assistant.
The B group act will list it for final hearing someday.
I am on
Matter
the
is
verge
a
of my
promotion.
retirement, my lord. On the verge of my retirement. No, only, my lord, grievance is, my lord, respondent number 4, who was, my lord, 11 years junior to the petitioner, was considered for promotion. And thereafter, we are also given a promotion, but he is sitting above us, my lord, in the seniority. And therefore, my lord, we had made a request to the authority to consider our
You
seniority.
belong
in
to some
Parliament.
reserve. You belong to some reserve category.
He belongs to reserve category. That was a backlog post which was also vacant along with, my lord, other 18 posts which were vacant.
my lord,
Backlog post under the post when it was notified.
how, while considering all vacant posts, my lord, there was a direction by the higher authorities that all 18 posts requires to be filled up. However, my lord, the authority, my lord, has recommended only his name, giving away, my lord, the promotion, my lord, of other 16 candidates, including, my lord, the petitioner. And thereafter, my lord, our grievance was considered, and after 2 years, my lord, we are being given a promotion.
Really.
My lord, originally I was appointed as a junior assistant on 1/2/1988.
One to 98 or 88?
88, my lord.
Ah,
My lord, respondent number 5 was appointed on, my lord, 30/12/1997.
ah.
My lord, due to, my lord, the bifurcation of, my lord, the corporation,
Typist.
my lord,
He was appointed as a typist.
he was appointed as a typist.
Same cadre, huh?
Junior assistant and typist of the same
Are
cadre.
the same cadre.
Feeder cadre, both are.
30/12/1997 is his appointment.
Hmm.
My lord, due to bifurcation of, my lord, the corporation by divisional division agi 2003 and 4 there was a bifurcation. Therefore, my lord, there was a direction, my lord, by the authority. May I take your lordship to page number 90?
90. Ah.
Type copy at 91. ವಿಭಾಗೀಯ ನಿಯಂತ್ರಣಗಳಿಗೆ ಈ ಮೇಲ್ಕಂಡ ವಿಷಯದ ಪ್ರಕಾರ ತಮ್ಮ ಗಮನಕ್ಕೆ ತಿಳಿಸಿದಂತೆ ತಮ್ಮ ಅಧಿಕಾರ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಎಲ್ಲಾ ಸಿಬ್ಬಂದಿಯವರಿಗೆ ದಿನಾಂಕ 15/11/2003 ಮುಂಬಡ್ತಿ ನೀಡಿ ಕ್ರಮ ಕೈಗೊಂಡ ಬಗ್ಗೆ ಈ ಕಚೇರಿಗೆ ಮಾಹಿತಿ ಒದಗಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. This is in view of, my lord, bifurcation of, my lord, earlier KSRTC department in favor of, my lord, by divisional. Next page is, my lord, the total vacancies as on, my lord, 2004. There were total 18 posts vacant, 2 were occupied, 16 were vacant.
In SWV ಅಂದ್ರೆ ಏನು?
Yes, were sanctioned posts. W is working, V is vacant. My lord, however, my lord, the authorities, my lord, by virtue of order at, my lord, annexure G, page number 100. Page number 100. Consider the promotion of only 5th respondent, who is almost 11 years junior to, my lord, the petitioner. Though, my lord, there were 16 posts which are vacant and all of us were under seniority. And he was at serial much below, my lord, the petitioner. Therefore, my lord, we had approached, my lord, the authority. Then, my lord, on 29/9/2006 at page number 102, even our claim is also considered and we were also given a promotion. My name is at serial number 7. But respondent number 5 is promoted in 2004. That is 19/10/2004. We are being given promotion, my lord, on 29/9/2006.
Promotion to which post?
From assistant, junior assistant in the assistant court.
This is the promotion post.
How?
Junior assistant to typist or the feeder channel.
How? I have given, I have produced, my lord, the C&R rules, my lord, page number 52. 52, my lord, let's do, my lord, the post of assistant.
Hmm.
52, my lord, category of assistant. By promotion on the basis of a seniority cum merit. Lordships. At seal number 8. Must have rendered a service of not less than 3 years as a junior assistant / typist or junior assistant cum typist, junior assistant cum data entry operator. The requirement is 3 years of service.
Yes.
My lord, thereafter we were considered for the promotion. My lord, all 15 posts were filled under, my lord, this order, 2006 order.
Yes.
Then we made, all of, the aggrieved persons approached the higher authority, claiming that since he is junior to, all other 16 candidates, therefore they should also be considered, for, the effect of promotion from the date when, the respondent number 5 was given a promotion. That is at page number 106. A detailed representation was made. Then our grievance was recommended as per 114 annexure K. Our request could be considered para 1 ನಲ್ಲಿ last 3 lines. ತಮಗಿಂತ ಕಿರಿಯ ಸಿಬ್ಬಂದಿಗಳು ಸಹಾಯಕ ದರ್ಜೆಯ ವರಿಷ್ಠತೆಯಲ್ಲಿ ಹಿರಿಯರಾಗಿರುವುದರಿಂದ ತಮಗೆ ಅನ್ಯಾಯವಾಗಿರುವುದಾಗಿ ತಿಳಿಸಿ 2006ರಲ್ಲಿ ನೀಡಿರುವ ಬಡ್ತಿಯನ್ನು 2004ರಿಂದಲೇ ಪರಿಗಣಿಸಿ ನ್ಯಾಯ ಒದಗಿಸಿಕೊಳ್ಳಲು ಕೋರಿರುತ್ತಾರೆ. The said proposition has been referred to. Then may I take lordship to page number 107 annexure L. What was the reason for not recommending others, whereas is been explained in 117. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಬೀದರ್ ವಿಭಾಗೀಯ ಕಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಯಿಂದ ಮೇಲ್ದರ್ಜೆಗೆ ಹುದ್ದೆಗಳಿಗೆ 25/8/2006 ನೀಡಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಮುಂಬಡ್ತಿ ಪಡೆದ ಸಿಬ್ಬಂದಿಯವರು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಕೇಂದ್ರ ಕಚೇರಿಯಲ್ಲಿ ಹಾಗೂ ಗುಲ್ಬರ್ಗಾ ವಿಭಾಗದಲ್ಲಿ 2004ನೇ ಸಾಲಿನಲ್ಲಿ ಮುಂಬಡ್ತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಕೇಂದ್ರ ಕಚೇರಿಯ ನಿರ್ದೇಶನದಂತೆ 15/11/2003 ನೀಡಬೇಕಾಗಿತ್ತು. ಬೀದರ್ ವಿಭಾಗದಲ್ಲಿ ವಿಳಂಬವಾಗಿ ಬಡ್ತಿ ನೀಡಿರುವುದರಿಂದ ತಾವು ಕಿರಿಯ ಸಹಾಯಕ ಹುದ್ದೆಯಲ್ಲಿ ಹಿರಿಯರಿದ್ದರೂ ಸಹ ಪ್ರಸ್ತುತ ಮುಂಬಡ್ತಿ ಹುದ್ದೆಯ ವರಿಷ್ಠತೆಯಲ್ಲಿ ಇತರ ವಿಭಾಗದವರಿಗಿಂತ ಕಿರಿಯವರಾಗಿದ್ದು ತಮಗೆ ಅನ್ಯಾಯವಾಗಿರುತ್ತದೆಂದು ಹಾಗೂ ಮನವಿದಾರರಿಗೂ ಸಹ 2004ನೇ ಸಾಲಿನಿಂದಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಬಡ್ತಿಗಾಗಿ ಪರಿಗಣಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಪರಿಶೀಲನೆಯಾಗಿ ಸದರಿ ಹುದ್ದೆಗಳು ವಿಭಾಗ ಮಟ್ಟದ ಹುದ್ದೆಗಳಾಗಿರುತ್ತವೆ. ಆಡಳಿತಾತ್ಮಕ ಕಾರಣಗಳಿಂದ ಮುಂಬಡ್ತಿ ನೀಡಲು ವಿಳಂಬವಾಗಿರಬಹುದಿರುತ್ತದೆ. ಬೇರೆ ವಿಭಾಗ ಅಥವಾ ಕೇಂದ್ರ ಕಚೇರಿಯಲ್ಲಿ ಮುಂಬಡ್ತಿ ನೀಡಿರುವ ದಿನಾಂಕದಿಂದಲೇ ಅವರಿಗೂ ಪರಿಗಣಿಸುವಂತೆ ಕೋರಿರುವ ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಲು ನಿಯಮಾವಳಿಯಲ್ಲಿ ಅವಕಾಶಗಳಿರುವುದಿಲ್ಲವೆಂಬ ಮಾಹಿತಿಯನ್ನು ತಮ್ಮ ಗಮನಕ್ಕೆ ಹಾಗೂ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಸಲ್ಲಿಸಲಾಗಿದೆ. Respondent number 5 and petitioners belong to same division. Then again we made a detailed representation enclosing the copy of the orders passed by the several other divisions where promotions are being considered retrospectively. In view of order at annexure M. 9/12/2009 ಗೆ ನಮಗೆ ಆ ತರ ಪ್ರೊವಿಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. There is no provision available where retrospectively our claim could be considered.
Yes.
Therefore, we enclosed all the orders pertaining to other divisions where retrospectively the claim of employees were considered and they were given promotion with a retrospective effect.
Yes,
One page
the
number.
promotion is based on the date of entry into service or not? If he has
As per-
earlier, if he has entered earlier,
Yes.
and if he is also in the feeder channel, if he has
We-
put in 3 years, and if he is senior than the petitioner, how are you not considering his case?
The promotion made in the impugned order, what we have endorsement has been given is ST backlog was there. As on that date, my lord, the backlog for post of ST was vacant, my lord. And we have made fifth respondent given a promotion to that effect, my lord. And my lord, for the assistant post, my lord, the feeder cadre is for junior assistant, typist and junior assistant come data entry operator. My lord. As on that day, my lord, we practically what requirement was there and on as well as the backlog was considered. Since my lord,
Sorry, but if he is entitled for promotion,
not only he, my lord, subsequently in 2006, he has also been promoted.
so he has
The,
to be placed
the,
above.
the question with
He has to be placed above the respondent number 5 alva.
no, my lord, as on that day of, he, my lord, respondent number 5 belongs to ST.
Correct.
The petitioner belongs to SC category. as on that day of vacancy, ST backlog was pending. And my lord, we have to follow the roster of reservation as well. And for the provisions, my lord, for retrospective, though he is also been promoted now. The only question is before this honorable court is with respect to the retrospective promotion he is seeking, my lord.
Correct,
The-
he may not be, see, if a post is reserved for scheduled tribe,
Yes.
and if it's a backlog vacancy, then he is entitled to be promoted against that post, no dispute.
Yes.
But when he has to be promoted, in the gradation list, ಎಲ್ಲಿರ್ಬೇಕು ಅವರು? Should he be above respondent 5 or can the respondent 5 march over the petitioner?
Now what?
ಯಾವ್ದು ಬಡಪ್ಪನವರ ಅಂತ ಯಾವ judgment
No,
ತೆಗಿ?
my lord, no, I am also relying upon the judgment of the Supreme Court. Recent. The question is that, my lord, impugned order itself, my lord.
160 may be referred, my lord. Comparative service conditions of my lord petitioner, including fifth
But
respondent.
correct, do you accept that he came into service in the year 1988
Yes, yes.
and respondent 5 came in 1997?
I am not disputing his seniority, my lord.
So therefore, when he is being granted a promotion, where should he be fitted? Should he be fitted above you or below you?
It is, my
Appa
lord,
appane, maga magane.
it is based on, my lord, available vacancies.
So now
There
he is
must be
promoted.
vacancies, my lord.
Now he is promoted. If he is promoted, ಹಿಂಗಿದ್ಯಪ್ಪ,
Yes,
petitioner ಇಲ್ಲಿದ್ದಾರೆ, respondent ಇಲ್ಲಿದ್ದಾರೆ. Respondent scheduled tribe ಆಗಿರೋದ್ರಿಂದ ಬ್ಯಾಕ್ಲಾಗ್ ವೇಕೆನ್ಸಿ ಇದೆ, ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ.
yes.
ನಾವು petitioner ಪ್ರಮೋಷನ್ ಬಂತು. ಅವ್ರು ಇಲ್ಲಿರ್ಬೇಕಾ, ಇಲ್ಲಿರ್ಬೇಕಾ, ಅಥವಾ ಇಲ್ಲಿರ್ಬೇಕಾ?
Look, meaning, my lord, object of providing reservation is to, my lord, bring, my lord, some reserved candidate category on par with the, my lord, general category.
It
that
doesn't mean to
object
say
is-
you can't tamper with the seniority. Both of them are in the same cadre now.
Yes,
If both of them are in the same cadre, where should the petitioner be fitted? Should he be fitted below or above the respondent number 5? Common sense ಇದಕ್ಕೆ ನಾವು ಓದ್ಬೇಕಾಗಿಲ್ಲ. Seniority has to be maintained. If seniority has to be maintained, he has to be fitted above you.
My lord,
ಬಡಪ್ಪನವರಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ತೆಗೀರಿ.
no, my lord, the question is but with regard to the retrospective promotion. My
ಇಲ್ವಾ ಅದು? ತೆಗ್ಸಿ.
lord, I am relying upon the judgment.
Retrospective promotion ಇಲ್ಲ, correct. We are not on that. I'll accept your contention that if the promotion to the post of, what is this? Assistant.
Yes.
Was
Now, my
reserved
lord,
for
the question will come with regard to the seniority for the next stage of promotion. Now, there is, I think, my lord, he is verge of retirement and it is only 1 year. The next promotion is, my lord, for the assistant. From assistant, the question will come the seniority for the next promotion, my lord. On wages and there is no difference between the wages and increment. He is entitled, he is taking the same wages, my lord, as on that day. The question will come for the promotion, next stage of promotion.
Yes, is it a
Now
backlog
respondent
post?
number 5 is been given further promotion. Now he is sitting above me.
Correct. Next ನಿಮಗೆ ಪ್ರಮೋಷನ್ ಬಂದ
ಇದೆ
ನೀವು ಅವ್ರ ಮೇಲೆ ಹೋಗ್ತೀರಾ.
vacant ಇದೆ. There is a vacancy. Only we are
That will
required
be
to consider.
considered, my lord.
Let the
That will be
co-
considered.
Now he is, my lord, supervisor under whom, my lord, we are working.
Correct, is a DPC constituted.
No DPC. That is the reason, my lord, we had
DPC.
sought for, my lord, information under the RTI. There is no departmental promotion committee constituted. There is no roster available with the authority. They have given reply under the, my lord, RTI that there is no roster available.
But do you accept that respondent 5, promotion of respondent 5 was against a backlog vacancy?
Yes, my lord.
Then-
At the same time, there were 16 posts which were vacant.
Could be. It could be.
All, my lord, as per the guidelines of, my lord, the department, when there are vacancies available, when one post requires to be, my lord, considered under the backlog category, all other vacant posts also be considered at the same time. Antide. If there is a if they want to reject other promotions, they have to form a committee, departmental promotion
You
committee,
can't
then
get it
it
back.
has to be,
You
my lord,
can't get it back by retrospective. From the date the junior was appointed, you cannot get it.
my lord, at the same time, the posts
Seniority
were
will
up.
be fixed above him.
If there are no vacancy, I would understood, my lord, that there were no vacancy. There is only one backlog post which is required to be considered. When
did
there are 16 posts which were vacant,
ಅವಾಗ
only one
ಬರ್ಬೇಕಾಗಿ-
post is being taken into consideration.
No, you slept over your rights. Why did you
No,
not?
I have challenged, my lord, in the earlier round of litigation, I had approached this on court. For the first time, they took a contention in the contempt proceedings that this post is filled up against the backlog.
Hmm.
Earlier round, my lord, I had approached this on court, challenging his appointment, contending that he is the junior most candidate who has been promoted. Page number 149, my lord, in WP number 103720 of 2013.
Hmm.
Challenging the order passed by the authority, refusing to consider our claim. That was considered by the learned single, by this court.
Hmm.
And, my lord, the authority was directed to consider our grievance. Then, my lord, within time, they did not consider it. We approached, my lord, we initiated contempt proceedings. During pendency of the contempt proceedings, they come up with the stand that the appointment of respondent number 5 is against, my lord, backlog post. We sought for information under, my lord, the RTI. What was the roster followed as on the date of promotion considered for respondent number 5? They said they have given reply that roster is not available.
Hmm.
And, my lord, we also in.
What is there to show that it was against a backlog post?
My lords, Annexure G, my lord, in what my learned friend is arguing, after filing the contempt in, we have taken the contention, it's not true, my lord. In 2004 itself, my lord, in order itself,
Annexure?
Annexure G, page 100.
Hmm.
Lord, ಪ್ರಸ್ತುತ ಈ ವಿಭಾಗದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಜರ್ನಪ್ಪ ಬೇಳುಚುಕ್ಕೆದಾರರು ಶಿಸ್ತು ಶಾಖೆ ಬಿದರ್ ಇವರನ್ನು ವಿಭಾಗೀಯ ಪ್ರಸ್ತುತ ಖಾಲಿ ಇರುವ ಮೇಲ್ದರ್ಜೆ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆ ಸಹಾಯಕ. My learned friend is telling that, my lord, after filing the complaint, it's not so. In order itself, we have stated that, my lord, he had been promoted for the backlog post.
ತಾತ್ಕಾಲಿಕವಾಗಿ ಕಾರ್ಯನಿರ್ವಹಣೆ ಮಾಡಲು.
And, my lord, in page 160 also, in impugned annexure S, we have stated so. Specifically, we have given a endorsement to that effect.
Hmm.
Lord, ವಿಭಾಗೀಯ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಅಭ್ಯರ್ಥಿಯಾಗಿ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಯ it's not clear.
ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆ ಎಂದು ಮುಂದುವರೆಸಿಕೊಂಡು ಬರಲಾಗಿರುತ್ತದೆ.
ಈ ಹಿಂದೆ ಮುಂಬಡ್ತಿಗೆ ಪರಿಗಣಿಸಿದ ಕಿರಿಯ ಸಹಾಯಕರ ಪರಿಷ್ಕೃತ ಪಟ್ಟಿ
It's not clear here.
ಆಗಿರುತ್ತೆ. ಸದರಿ ಪರಿಷ್ಕೃತ ಪಟ್ಟಿಯಲ್ಲಿ ನೀವು 71ರಲ್ಲಿ ಸ್ಥಾನ ಪಡೆದಿದ್ದು ನೀವು ಪರಿಶಿಷ್ಟ ಜಾತಿಯ ವರ್ಗಕ್ಕೆ ಸೇರಿದ ಸಿಬ್ಬಂದಿಯವರಾಗಿರುತ್ತೀರಿ. ಹಾಗೂ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಕ್ರಮ ಸಂಖ್ಯೆ 149ರಲ್ಲಿ ಸ್ಥಾನವನ್ನು ಪಡೆದಿದ್ದು ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಸೇರಿದ ಸಿಬ್ಬಂದಿಯವರಾಗಿರುತ್ತಾರೆ. ಕಾರಣ ಸದರಿ ಕಿರಿಯ ಸಹಾಯಕರನ್ನು ದಿನಾಂಕ 19/10/2004ರಂದು ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಯಲ್ಲಿ ಪರಿಗಣಿಸಿ ಮುಂಬಡ್ತಿ ನೀಡಲಾಗಿದೆ. ಹಾಗೂ ಅಂದು ಇವರಿಗಿಂತ ಹಿರಿಯರಿರುವ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಸಿಬ್ಬಂದಿಯವರು ಯಾರು ಇರುವುದಿಲ್ಲ. ವರಿಷ್ಠತೆಯಲ್ಲಿ ನೀವು ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಹಿರಿಯರಾಗಿದ್ದರೂ ಸಹ ನೀವು ಪರಿಶಿಷ್ಟ ಪಂಗಡಕ್ಕೆ ಸೇರಿರುವ ಸಿಬ್ಬಂದಿ ಆಗಿರುವುದಿಲ್ಲ. ಕಾರಣ ಅಂದು ಅಂದರೆ ದಿನಾಂಕ 19/10/2004ರಂದು ನೀಡಲಾದ ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಬ್ಯಾಕ್ಲಾಗ್ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿಯನ್ನು ನಿಮ್ಮನ್ನು ಪರಿಗಣಿಸದೇ ಇರುವುದು ಸಮಂಜಸವಾಗಿರುತ್ತದೆ. ಹಾಗೂ ಈ ರೀತಿ ಕಾನೂನು ರೀತಿ ಕ್ರಮಬದ್ಧವಾಗಿದೆ. ಅದರಂತೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ.
This order is during pendency of the contempt proceedings.
How does it
162 notice. One page, only one. 162. We have specifically sought information. ಬೀದರ್ ವಿಭಾಗದಲ್ಲಿ ಕಿರಿಯ ಸಹಾಯಕರಿಂದ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಮುಂಬಡ್ತಿಗಾಗಿ ಸಿದ್ಧಪಡಿಸಿದ ರೋಸ್ಟರ್ ರಿಜಿಸ್ಟರ್ ಛಾಯಾಪ್ರತಿ ದೃಢೀಕರಿಸದೊಂದಿಗೆ ನೀಡುವುದು. ಸದರಿ ರೋಸ್ಟರ್ ರಿಜಿಸ್ಟರ್ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ. And, my lord, we had also sought for information at page number 148, my lord, information specifically with regard to respondent number 5. Page number 148. 2004ರಲ್ಲಿ ಶ್ರೀ ಜನಪ್ಪ ಕಿರಿಯ ಸಹಾಯಕ ಕಂ ಬೆಳಚುಗಾರ ರವರಿಗೆ ಮುಂಬಡ್ತಿಗಾಗಿ ಪರಿಗಣಿಸುವ ಸಮಯದಲ್ಲಿ ಸಂಸ್ಥೆಯಿಂದ ನಡೆಸಲಾದ ಇಲಾಖಾ ಬಡ್ತಿ ಸಮಿತಿ ಸಭೆಯ ನಡವಳಿಗಳನ್ನು ದೃಢೀಕರಣದೊಂದಿಗೆ ನೀಡುವುದು. ಸದರಿ ದಾಖಲೆಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ. They don't furnish anything. And my lord, they say.
Documents coded to show that this was a backlog vacancy.
My lord, as on 2004 itself, appointment, promotion of the fifth respondent itself, we have stated.
That is okay, but
I will produce the document.
I will produce under.
Lord, I have filed the statement, but as far as this document is concerned, my lord, I will produce the original file itself.
Please also go through the judgment.
I have produced the
Padapnawar has
latest.
been referred later. ಇನ್ನೊಂದು judgment ಇದೆ ನೋಡಿ. Padapnawar has been referred later in the later judgment.
Lord, in two.
One order, my lord, I have enclosed at page number 164 of the Apex Code, where if there is a delay in considering other vacant posts along with, my lord, the post which is considered under roster, my lord, the other vacant posts should be also considered along with.
Can't be given effective from that date. ಯಾರನ್ನು subsequent refer ಮಾಡಿದ್ದಾರೆ ನೋಡಿ ಬಡಪ್ಪ. ರೋಟಾ ಅಂತ ಒಂದು ಇದೆ ನೋಡಿ ಜಜ್ಮೆಂಟ್ ತೆಗೀರಿ. ರೋಟಾ ರೂಲ್ ಅಂತ ಒಂದು ಇರ್ಬೇಕು. ರೋಟಾ. ಇದು ಓದಿ. Give time.
So far as the general conditions are concerned, their seniority will be restored in accordance with Ajit Singh and Sabriwala in explain Ajit Singh, and they will get their promotions accordingly from the effective dates. They will get notional promotions, but will not be entitled to any arrears of salary on the promotional posts. However, for the purpose of retirement benefits, their position in the promoted post from the notional dates as per this judgment will be taken into account, and retirement benefits will be computed as if they were promoted to the post and withdrawn the salary and amendments of those posts from the notional dates. And that means we are satisfied even if.
Okay, notional date, we have to declare your notional date.
Lord, sir, I am relying upon the July 24, SCC 2000. May I take to para 28?
Produce the document.
Yes, I will.
Good. The learned counsel for the respondent number 1 to 3 is directed to produce documents to establish that the respondent number 5 established that the post of assistant to which the respondent number 5 was promoted was a backlog vacancy reserved for scheduled tribe. This list on yavat
29.
20. May I request on 30th?
Yes. Next. ಇಲ್ಲ ಅಂದ್ರೆ ಮುಂದೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ.
Please.
Iradar Sharanappa, Shankarappa.
Respondent. Case is posted for amicable settlement, my lord, during last hearing. And respondent 4 and 5 have.
Lump sum ಅಂತ ಏನೋ ಹೇಳುತ್ತಲ್ಲ last time.
But
Are
not,
you-
sir.
Do you want to settle it? You want to contest it?
But sir, if I want to bring true facts before your lordship, then it's entitled from the government only. Therefore, I am prepared the statement.
Right, Mad, heard.
Now, permission quota, I'll file objection.
Heard. You ready?
Yes,
Argue, Mad.
this is the statement of objection.
Third.
Yes, please.
It could have. Yes, please.
Yes.
My lords, after going through this objection, I will file my rejoinder and argue. Kindly.
Sir, this today it is listed for B group. Please argue and get a closure.
Okay, my lord. I'm ready, my lord.
Hmm.
My lords, this is a case of gross violation of natural justice by the respondent 4 and 5. They have thrown out the petitioner on the street without conducting inquiry, without issuing any notice, and made deprived of 11 years of service and salary. He then moved to the pillar to the post for 11 years and ultimately knocked the doors of this honorable court, my lords. On 30/10/2006, petitioner was kept out of the service, my lord, by respondent 4, without issuing notice, without conducting any inquiry. Simply, ನಾಳೆಯಿಂದ ಕಾಲೇಜಿಗೆ ಬರಬೇಡ, ನಿನ್ನ ಸಬ್ಜೆಕ್ಟ್ ನಲ್ಲಿ ಸ್ಟ್ರೆಂತ್ ಕಮ್ಮಿ ಆಗಿದೆ. ಸ್ಯಾಲರಿ ಹೆಲ್ಡಪ್ ಮಾಡಿದ್ರು, ಕಾಲೇಜಿಗೆ ಬರಲಿಕ್ಕೆ ಬಿಡಲಿಲ್ಲ. ಆಮೇಲೆ ಇವರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ 2, ರೆಸ್ಪಾಂಡೆಂಟ್ 3ಗೆ ರಿಕ್ವಿಷನ್ ಕೊಟ್ಟರು ಪೆಟಿಷನರ್. ಅವರು ಅಡಿಟ್ ಮಾಡಿದ್ರು. 2008 ನಲ್ಲಿ ಅಡಿಟ್ ಮಾಡಿದ್ರು, ಸ್ಟ್ರೆಂಗ್ತ್ ಇದೆಯಾ ಇಲ್ವಾ ಸಬ್ಜೆಕ್ಟ್ ನಲ್ಲಿ ಅಂತ. ಸ್ಟ್ರೆಂಗ್ತ್ ಇದೆ ಅನ್ನೋದನ್ನ ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ವರದಿಯಾಗಿದೆ, ಮೈ ಲಾರ್ಡ್ಸ್. ಕೈಂಡ್ಲಿ ಪೆರೂಸ್ ದಿ ಪೇಜ್ ನಂಬರ್ 41, 42, ಮೈ ಲಾರ್ಡ್ಸ್.
Yes.
ಮೈ ಲಾರ್ಡ್ಸ್, ಮರಾಠಿ ಸಬ್ಜೆಕ್ಟ್ ಅವ್ರದ್ದು. 3ನೇ ಕಾಲಮ್ ಅಲ್ಲಿ ಇದೆ. ಏಪ್ರಿಲ್ 2003 13 ಸ್ಟ್ರೆಂಗ್ತ್, ಉತ್ತೀರ್ಣರಾದವರು 11.
ನಿಮ್ಗೆ ಯಾವ ಬರಬೇಡಿ ಅಂತ ಹೇಳಿದ್ದು 2006 ಅಲ್ವಾ?
6 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
2006 5 6 ಎಲ್ಲಿದೆ?
6 ಇಲ್ಲಿದೆ ಮೈ ಲಾರ್ಡ್ಸ್. ಕೆಳಗಡೆ 4ನೇ ನಂಬರ್ ಅಲ್ಲಿ ಇದೆ. 2006 ನಲ್ಲಿ 14 ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. ಸೊ ಮಿನಿಮಮ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಈಸ್ 10, ಮೈ ಲಾರ್ಡ್ಸ್, ಲ್ಯಾಂಗ್ವೇಜ್ ನಲ್ಲಿ. ಸೊ 14 ಇರ್ಲಿಕ್ಕಾಗಿ ಅವರು ಇವರನ್ನ ಆ ಪ್ರಿಟೆಕ್ಸ್ಟ್ ಮೇಲೆ ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ. ಸೊ 2007 ನಲ್ಲಿ ಅವ್ರು ಇದ್ದಿಲ್ಲ, ಕಾಲೇಜಲ್ಲಿ ಇದ್ದಿಲ್ಲ. ಸೊ ಸ್ಟ್ರೆಂಗ್ತ್ ಇರ್ಲಿಕ್ಕಾಗಿ ಅವರನ್ನು ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ. ಹೊರಗೆ ಹಾಕಿದ್ದಲ್ದೇನೆ ಯಾವುದೇ ಎನ್ಕ್ವೈರಿ ಇಲ್ಲ, ಓರಲ್ ಆಗಿ ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ. ಸ್ಯಾಲರಿ ಸ್ಟಾಪ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಸ್ಯಾಲರಿ ಸ್ಟಾಪ್ ಆಯ್ತು. 11 ವರ್ಷಗಳ ಕಾಲ ಅವರು ಬೀದಿ ಮೇಲೆ ಓಡಾಡಿದ್ರು, ಮೈ ಲಾರ್ಡ್ಸ್. ಆಮೇಲೆ ಇವರು ಪೆಟಿಷನರ್ ರಿವಿಷನ್ EAT ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರು, ಮೈ ಲಾರ್ಡ್ಸ್. EAT ನಲ್ಲಿ 8 ವರ್ಷ ಹೋದ ನಂತರ ಒಂದೇ ಲೈನ್ ಆರ್ಡರ್ ಬಂತು, ಈ ಕೇಸ್ ಇಲ್ಲಿ ನಡೆಯೋದಿಲ್ಲ. 8 ವರ್ಷ ಕಾಲ EAT ನಲ್ಲಿ ಹೋಯ್ತು. ಆಮೇಲೆ ಅಪ್ರಾಪ್ರಿಯೇಟ್ ಫೋರಮಿಗೆ ಹೋಗ್ರಿ ಅಂದ್ರೆ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ನಲ್ಲಿ ನಾವು ಪೆಟಿಷನರ್ 131 ಸರ್ಕಾರದ ಹತ್ರ ಫೈಲ್ ಮಾಡಿದ್ರು ರಿವಿಷನ್ ಪೆಟಿಷನ್. ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ತು ಅಂದ್ರೆ, ಈ ಮಧ್ಯದಲ್ಲಿ ಡೈರೆಕ್ಟರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಮ್ಯಾನೇಜ್ಮೆಂಟೇ ಹೊಣೆ ಇದೆ, ಯಾವುದೇ ಎನ್ಕ್ವೈರಿ ಮಾಡಿಲ್ಲ, ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಯಾವುದೇ ರೂಲ್ಸ್ ಫಾಲೋ ಮಾಡಿಲ್ಲ. ಫಾಲೋ ಮಾಡ್ಲಾರ್ದೇನೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಪರ್ಮಿಷನ್, ಇದು ಅಪ್ರೂವ್ಡ್ ಪೋಸ್ಟ್ ಇದೆ ಮೇಲೆ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಫಾಲೋ ಮಾಡ್ಲಾರ್ದೇನೆ ನೀವು ತೆಗೆದುಹಾಕಿರೋದ್ರಿಂದ ನೀವೇ ಸ್ಯಾಲರಿ ಕೊಡ್ಲಿಕ್ಕೆ ಲಯಬಲ್ ಅನ್ನೋದನ್ನ 2 ಆದೇಶಗಳನ್ನ ಪಾಸ್ ಮಾಡಿದೆ. ಸೊ ಆ ಆದೇಶ ಈ ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಎತ್ತಿ ಹಿಡಿದಿದೆ, ಮ್ಯಾನೇಜ್ಮೆಂಟೇ ಸ್ಯಾಲರಿ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ. ಸೊ ಇವಾಗ ತಮ್ಮ ಸನ್ನಿಧಿಯಲ್ಲಿ ನಾವು ಬಂದಿದ್ದೇವೆ, ಮೈ ಲಾರ್ಡ್ಸ್. ನಮ್ಗೆ ತಮ್ಮಿಂದ ನ್ಯಾಯ ಸಿಗ್ತದೆ ಅನ್ನೋ ವಿಶ್ವಾಸ ಇದೆ. ದಯವಿಟ್ಟು ನಮ್ಗೆ ಸ್ಯಾಲರಿ ಕೊಡಿಸಿ, ಮೈ ಲಾರ್ಡ್ಸ್.
Not so. So far as appointment is concerned, there is no dispute. admittedly, he is appointed. And his post was approved by the government, admitted to salary brackets. That's in the year 2005, 6, 7. Because of his non-performance rate and non-giving good education to the students in Marathi subject, there is so student strength is reduced. For that, the petitioner management wrote a letter. That is Lordship kindly see, he has produced Annexure B, Annexure C. Annexure C, page number 22, that petitioner has produced that letter also.
Page number?
As per my records, page number 22. Annexure C anta ide. That is dated 30/10/2006.
Yes.
Please. So Sri Ramesh Rakshale Marathi Upanyaksharu Vetana ಹಿಡಿದಿರುವ ಬಗ್ಗೆ. That letter is written to the principal by the Adhyaksha, and that letter is communicated to Commissioner of Pre-Education Department and the DDP of Bidar Department of Education Department. In both that was informed to the
both.
Please. ಮೇಲಿನ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖನದ ಶ್ರೀ ರಮೇಶ್ ಅಕ್ಷಾಳೆ ಮರಾಠಿ ಉಪನ್ಯಾಸರು ತಮ್ಮ ವಿಷಯದ ಬಗ್ಗೆ ಕಾಳಜಿ ವಹಿಸದೆ ನಿಷ್ಕಾಳಜಿತನದ ತೊಂದರೆ ತೋರಿಸಿದ್ದರಿಂದ ವಿದ್ಯಾರ್ಥಿಗಳ ಮೇಲೆ ಮರಾಠಿ ವಿಷಯದ ಮೇಲೆ ಪರಿಣಾಮ ಬೀಳಲಿಲ್ಲ. ಕಾರಣ 2006-07ನೇ ಸಾಲಿನಲ್ಲಿ ಕೇವಲ ಪ್ರಥಮ PUCಯಲ್ಲಿ 4 ವಿದ್ಯಾರ್ಥಿಗಳು ಮತ್ತು ದ್ವಿತೀಯ PUCಯಲ್ಲಿ 8 ವಿದ್ಯಾರ್ಥಿಗಳು ಮಾತ್ರ ಪಡೆದಿರುತ್ತಾರೆ. ನಿಯಮಾನುಸಾರ 10 ವಿದ್ಯಾರ್ಥಿಗಳು ಇರಬೇಕಾಗಿರುತ್ತದೆ. ಇದರ ಕುರಿತು ಆಡಳಿತ ಮಂಡಳಿ ಇವರಿಗೆ ಅನೇಕ ಸಲ ವಿದ್ಯಾರ್ಥಿಗಳ ಸಂಖ್ಯೆ ಹೆಚ್ಚಿಸಿಕೊಂಡು ಸರಿಯಾಗಿ ನೌಕರಿ ಮಾಡಲು ತಿಳಿಸಿದರೂ ಕೂಡ ಇವರು ಸುಧಾರಿಸಿಕೊಳ್ಳದೆ ಆಡಳಿತ ಮಂಡಳಿ ಆದೇಶ ಉಲ್ಲಂಘಿಸಿ ಊರಿನ ಜನರ ಜೊತೆ ಸೇರಿ ಆಡಳಿತ ಮಂಡಳಿ ವಿರುದ್ಧ ಇಲ್ಲ ಸಲ್ಲದ ಆರೋಪ ಮಾಡುತ್ತಾ ಕಾಲ ಕಳೆಯುತ್ತಿದ್ದಾರೆ. ಒಳ್ಳೆಯ ಕಾಲೇಜಿಗೆ ಕೆಟ್ಟ ಹೆಸರು ತರುತ್ತಿದ್ದಾರೆ. ಇವರಿಗೆ ಸರ್ಕಾರದ ಪುಕ್ಕಟ್ಟೆ ಸಂಬಳ ನೀಡುವುದು ಸೂಕ್ತವಲ್ಲ. ಕಾರಣ ಆಡಳಿತ ಮಂಡಳಿ ಇವರ ಸಂಬಳವನ್ನು ತಡೆ ಹಿಡಿಯಲು ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶ ಮಾಡಲಾಗಿದೆ. ರಮೇಶ್ ರಕ್ಷಾಳೆ ಮರಾಠಿ ಉಪನ್ಯಾಸಕರು ಸಂಬಳವನ್ನು ಅಕ್ಟೋಬರ್ 2006ರಿಂದ ತಡೆ ಹಿಡಿಯಲು ಪ್ರಿನ್ಸಿಪಲ್ರಿಗೆ ಆದೇಶಿಸಲಾಗಿದೆ. ದಿಸ್ ವಾಸ್ ಕಮ್ಯುನಿಕೇಟೆಡ್ ಅಂಡ್ ಟು ದಿ ಕನ್ಸರ್ನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. And the petitioners also filed a representation before the government that was available in the order of this honorable court. He has filed a writ petition before this honorable court in the year 2011. That is page number
47.
No, it may be Annexure G, WP number.
Yes.
That in that WP, Lordship kindly see, this honorable court allowed the dispose of the petition, observing that petitioner was a teacher in the respondent college from the year 2006. The petitioner is discontinued from service on the ground that there are no requisite number of the students of Marathi language. Agreed by the petitioner gave a complaint 13/6/2007 to the respondent number 3 to the Deputy Director of Pre-University Education. Respondent number 3 in turn directed the 4th respondent college as per Annexure E dated 7/8/2007 to inquire into the complaint, take suitable action and to report to him. In the compliance of the direction of the respondent number 4 college submitted a report on 30/7/2003. The respondent education
3 ಹೆಂಗಾಗುತ್ತೆ?
may be that date is that was 2000. That is after the 2007.
Report ಎಲ್ಲಿದೆ?
That report is available in the government.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ?
ಇಲ್ಲ.
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇಟ್ಕೊಂಡಿಲ್ವಾ?
ಇಲ್ಲ.
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇರ್ಬೇಕಲ್ಲ.
I'll submit it to government.
Whether any inquiry was conducted against him.
Yes. That was accepted by the court, this honorable court.
Both.
Yes. The respondent education authority have not taken any further steps on the report submitted by the respondent number 4 college. In these circumstances, the respondent authority are hereby directed to consider the report submitted by the 4th respondent and to take further action Liberty is also reserved to the petitioner give representation to the respondent authority with all supporting documents. If such a representation is given by the petitioner, then respondent's authority shall consider the same in accordance with law. Then, my lords, he filed a representation. That representation, as per the orders, is not complied. He filed a contempt petition before this honorable court, not annexure G2, next page, my lords. The page number is contempt in CC 4011 of 2013. my lords. In contempt petition, my lords, he admitted the contempt petition filed complaining the disobedience of the order dated 19/7/2012 passed in WP number 81,436 of 2000. By the said order, this court directed to consider the report submitted by the respondent or college and to take further action. Liberty was given to the petitioner to give representation to the respondent authority with all supporting evidence. If such a representation given to the respondent authority shall consider the same in accordance with law. In a cause title of the complainant petition, the petitioner has categorically stated, Your Lordship, categorically stated that respondent number 4 and 5 have complied and not committed contempt, and therefore they are not necessary party to the proceedings. Therefore, they are not made parties. So the complaint is against the only respondent number 1. Today the respondent number 1, so Sayyid Raji so filed affidavit along with the copy of the order dated 2013. Considering the representation, the petitioner and order passed by thus. Thus, the direction issued by this court has been complied with. The petitioner liberty to work out his remedy, if any, either in terms of the order dated 2013 or challenge the said order in proper. Listen. Then, my lords, Your Lordship, kindly see.
Produce that report.
Report, sir.
ಅದೇ ಬೇಕಾಗಿರೋದು. And what does the revision authority say? 131 petition ಏನಂತ ಹೇಳಿ? What is the finding in the petition under 131?
131 ದಲ್ಲಿ ನನ್ನ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ ಸರ್. The college is not made a party, Mars. Mars, in fact, Mars, as per the rules, Mars, in the support of the case of the petitioner, Mars, the rules prakara, once they have informed the government is entitled from the government, Mars. As per rule, Mars, Your Lordship, kindly
He is
see.
entitled from the government, no dispute.
Please.
He is entitled from the government. You can remove him in accordance with law.
Yes.
No dispute. And then how can you stop the salary? ತೆಗೆದಾಕಿ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ, ಅದಕ್ಕೇನೋ ಒಂದು ಪ್ರೊಸೀಜರ್ ಇದೆ, ಅದು ಫಾಲೋ ಮಾಡಿದಿರಾ? If you not followed the procedure.
This petitioner has not terminated from the service. The only salary was stopped because of the increased. Because then at that stage, he is treated as an excess teacher. An excess teacher will transfer to another aided institute. That is the rule set.
Did you say that he is an excess teacher?
That
If you say that you are an excess teacher, the government would have transferred him.
that word will not come. I'll admit that word will not. Then let's say
ನಿಮ್ಮ ಅಲಿಗೇಷನ್ ಏನು?
strength.
ಕೆಲಸ ಸರಿಗ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ನಿರ್ಲಕ್ಷ್ಯತನ ತೋರಿಸ್ತಾ ಇದ್ದಾನೆ, ಸಂಘದ ವಿರುದ್ಧ ಎಲ್ಲೆಲ್ಲೋ ಮಾತಾಡ್ಕೊಂಡು ಏನೇನೋ ಕೆಲಸಗಳು ಮಾಡ್ಕೊಂಡು ತೊಂದರೆ ಕೊಡ್ತಿದ್ದಾನೆ, ಆದ್ರಿಂದ ಕೆಲಸದಿಂದ ನಾವು Can you do that is what I am asking you. ಮಾಡಿ ಅವ್ನ ಕೆಲಸದಿಂದ ತೆಗೆದಾಕಿ ಬೇಡ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
But that enquiry is required. Enquiry is required for taking. But instead of he removing the service from the service, he is stopped the salary that was informed that duty of the government to treat that teacher is excess teacher and transfer to another aided institution. That is the last. That is the last.
ನಿಮ್ದು ಯಾವ ಸ್ಕೂಲ್ ಇದು?
ಆ ಪಾಯಿಂಟ್ ಎಲ್ಲಿನೂ ಬಂದಿಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್ ಅವ್ರ ಆದೇಶದಲ್ಲಿ.
ಸ್ಕೂಲ್ ಯಾವ್ದಿದು? ಹೆಸರೇನು? ರೇಣುಕಾ?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ಚತುರೆ ಕಾಲೇಜ್
managed by the SC/ST management first.
ಚತುರೆ PU ಜನತಾ ಪ್ರವೀಣ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಚತುರೆ
They are providing pre-education also.
Now you have been transferred to that place.
Yes, no, another place transferred ಆಗಿದೆ.
ಮೈ ಲಾರ್ಡ್ಸ್ 4-5 ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೊನೆಗೆ ರೇಣುಕಾ ಕಾಲೇಜಿನಲ್ಲಿ ಜಾಯಿನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅವರೇನಾ?
ಇಲ್ಲ, ರೇಣುಕಾ ಕಾಲೇಜ್ ಬೇರೆ ಕಾಲೇಜ್ ಇದೆ.
Same management or different?
ಬೇರೆ
Now we are working somewhere.
Yes.
2013 ದಿಂದ ಇವರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. 6 to 13.
17 ಗೆ ಜಾಯಿನ್ ಆಗಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್ಸ್.
ಅದು that is department mistake. It is not department mistake of the college.
6 ಇಂದ
2017.
2017 ವರೆಗೂ.
No, 2013.
17
No,
ನಲ್ಲಿ
no,
join ಆಗಿದ್ದಾರೆ.
ಹೇಳ್ತೀನಿ. That is just. Your lordship kindly see NHR H minutes. NHR H. That is minutes, first minutes 5/10/2013 first transfer order minutes. That the department has transferred this man as a teacher, ex-teacher, along with other teachers minutes. Because minutes in this posting was given to Amareshwara Padavi Purva College, Bidar, Jille. In this place, minutes, there is no vacant place. That is a mistake of the department. Then again, minutes, department, once again, they have provided another school minutes. That is minutes, NHR. NHR J minutes. Sorry. one minute. Yes, minutes, NHR J. In that minutes, only Ramesh. Amareshwar Padavi Purva College, Aurad Bidar.
2015.
Yes. But then minutes, you will also kindly see NHR L minutes. This is made in 2017. 15/7/2017. NHR L minutes. NHR L,
Renuka.
yes, minutes.
So from 2006 to 2013.
13, if suppose minutes, you will, yes.
ಏನ್ ಮಾಡ್ತೀರಾ?
That minutes I have request to Lord, this honorable court minutes, that letter itself is treatments as per the rules, rule 20.
No, please point out that you've taken due process of law.
Yes.
To deprive him from employment. 2006 ಇಂದ 2013 ಏನ್ ಪ್ರೊಸೀಜರ್ ಮಾಡಿದ್ರಿ? If you have deprived him, then you will be liable to pay the salary.
Yes.
You want to pay the salary as per the grant-in-aid code, or you want to settle it with him is what I'm asking you.
Yes, for 2006 to 2000, Lordship kindly, it may be, I'll advise my client to settle the matter. Next, even date for tomorrow, I'll call them.
After hearing the learned counsel
Yes.
for the petitioner and the learned counsel for the respondent number
4 and 5.
4 and 5.
Yes.
List this petition on
That's
22,
28, 20.
28,
Yes. Please, 29.
29, on 29th, to explore a settlement between the parties.
For date matters, Lordship. Date is March 2006 to 13.
Then
Whatever.
2006 to 2013.
Even Lordship, I request Lordship to treat that letter and request of the petition letter. From 2007, he has given a letter to the government. Then Lordship, the government is liable to pay them.
No, why should the government pay? Why should the government pay?
Because Lordship, that letter itself is treated as excess teacher.
How can you do that? Have you said that he is an excess teacher? Deploy him elsewhere. You did not do it.
That letter is not a specific.
You simply said he's doing all kinds of activities, is not encouraging or is not
No.
controlling students.
In 2007, petitioner has given a letter to the government to transfer the another school. From that date, I am liable to pay 2006 to 7. But 2007 is entitled.
7 leave letter ಕೊಟ್ಟಿದ್ದೀರಾ?
Government, that will come in the orders passed by this honorable court. For 1 year, I am liable.
13, find out from 2006 to 13. You are the one who is responsible for all this. All of the matters are 230.
With your lordship permission, if your lordship permit me.
Next matter, have it on Monday, some.
ಯಾವುದು serial number? 41.
41.
Monday,
ಇವತ್ತೇ madam.
there is some.
ನಿಮ್ ಮನ್ಸಿಗೆ ಬಂದಾಗೆಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಲ್ಲ, ಅಲ್ಲೇನು ಇದೆ ನೋಡಿ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಅಂತೆಲ್ಲ ಕೇಳ್ಬಿಡ, ಅಲ್ಲಿ ಹಾಕಿದೆ ಲಿಸ್ಟ್, ಅಷ್ಟು ದೊಡ್ಡದಾಗಿ ಹಾಕಿದ್ದು ಕಾಣಲ್ವೇನ್ರಿ?
Wednesday.
ಯಾವತ್ ಬೇಕು
ಅಲ್ಲ 41 Wednesday, ನಾನು respondent ಇದ್ದೀನಿ.
matters are listed on a particular date.
Yes, in that matter, I am in the petition numbers. It may be taken on 29th also. Same, I'll have.
List on 29, serial number 41.
Yes.
Your lordship permit me, my lord. Lord, I want to make a mention of a matter in which, my lord, election, my lord, is scheduled tomorrow. Lord, Lord, I'm
We'll take it up at 2:30.
Yes, my lord, but the memo will be handed over just.
All is yaad.
Grateful, my lord.
Court officer? Court officer?
2:30 ಎಲ್ಲ ತಗೋತಾರೆ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್
ಸರಿ ಸರ್, ಸರಿ. ಈಗ serial number 40 ಬಂದಿದೆಯಲ್ಲ?
ತಗೋತಾರೆ 40ನಾ
ಅಲ್ಲಲ್ಲ, ಈಗ ಎಷ್ಟಕ್ಕೆ ಸ್ಟಾಪ್ ಆಗಿದೆ ಅಂತ?
ನಂಬರ್ 41 ಮುಗೀತು 42
ಸರಿ,
ಸ್ಟಾರ್ಟ್
ಥ್ಯಾಂಕ್ ಯು.
ಬೇಡ ಬಿಡ್ರಿ ಬೇಡ ಆರಾಮಿದೀವಿ ಬೇಡ.
ಇದ್ರಲ್ಲ ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್. ಸರ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಮಾಡಿ ಆರಾಮಾಗೈತಲ್ರಿ? ಆಯ್ಕದ ಹೇಳಿ ಸರ್, ಒಂದ್ ವಾರ ಓದ್ಕೊಳಕ್ ಸಿಗುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್
ಹೇಳ್ರಿ ಸರ.
ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಪಾಸ್ ಔಟ್ ಸರ್, ಚಿಕ್ಕನರ್ಗುಂದ ವಕೀಲರು.
ಗೊತ್ತಾಯ್ತು ನಾವ್ ಪಾಟೀಲ್ ಮಾತಾಡೋದ್ರಿ.
ಗೊತ್ತಾಯ್ತು ಪಾಟೀಲ್, ಗೊತ್ತಾಯ್ತು. ಪಾಸ್ ಔಟ್ ಕರ್ತಿರಲ್ಲ ಈಗ?
ಸಾಹೇಬ್ರ ಕೇಳ್ತೀನಿ, ಕರಿತೀವಿ.
ಸರ್
One submission, my lord. Serial number 68, my lord. I am for the respondent number 1, my lord. I informed the other side may be taken on 24th, my lord. CPC matter. Copy is not there. I will.
Suit is filed in which year?
Petition, copy is not there.
Arun Kumar.
I informed, my lord. We have taken 24. 24th it may be taken, my lord.
ಯಾವ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಆರ್ಡರ್ 8 Rule 10 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
Petition copy is not there, my lord. I will.
They can't be an automatic decree, mister. That is the law.
One date will fix, my lord.
Dismiss ಆಗುತ್ತೆ, ಯಾಕೆ ಟೈಮ್ ಕೇಳ್ತೀರಾ?
I'll collect the copy and.
Learn counsel for the respondent number 1 seeks time. List on date for ಯಾವತ್ತು ಬೇಕು?
There is interim order as well.
Interim order granted, we extended to it. Cost amendment ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದೀನಿ.
Counsel for the petition has amended the cost rate. Ready? 2024.
Lord, the additional list of appointments are, my lord, stalled by virtue of, Lord, I am the petitioner, then interim order in my favor. Lord, the issue is this, my lord, the issue is regarding equivalency of, my lord, the qualification, which is a requirement, my lord. Petitioner applied for, my lord, STC. Lord, the required qualification, my lord, was that he was supposed to have, my lord, PUC or, my lord, anything equivalent to PUC, my lord. He has completed 3 years diploma course, which is, my lord, considered as, my lord, equivalent. This clarification that, my lord, 3 years diploma is equivalent to, my lord, PUC was given on a subsequent date, my lord, before the, my lord, the final list was issued. Additional issue list is yet to be, my lord, issued. Earlier round, my lord, the court held that, my lord, by virtue of certain government orders, it is already held that 3 years diploma is equivalent to, my lord,
What was the subject?
Sorry, my lord, SDC, my lord, the appointment for SDC. The qualification, my lord, required qualification is on page 21, my lord.
Diploma language ಇದೆಯಾ?
Yes, English, my lord, he has completed, my lord, English, my lord, in diploma. My lord, there is no dispute that, my lord, both are equivalent. The question is, my lord, whether it, and my lord, there is also not in dispute that it is made retrospectively applicable. This clarification was given on a subsequent date. Based on that, my lord, they hold that PUC and, my lord, 3 years diploma are both equivalent and it should be given retrospective effect too. Here they contend that, my lord, since it will have a cascading effect, and appointment of, my lord, this person, my lord, treating them as, my lord, equivalent. my lord, that endorsement is given. Earlier, my lord, earlier round of litigation, court held that, my lord, since there are already government orders which hold that it is equivalent and that is to be given retrospective effect to, you are required to consider in view of, my lord, these government orders. They have, my lord, now issued annexure Q. My lord, this is the order, my lord, called in question, my lord, page 126, it starts the operative portion on page 129.
Yes. Yes.
Yes. The reasoning given is, my lord, it may have a cascading effect. One, my lord, this appointments, my lord, additional lists are yet to be issued. If I'm accommodated in that additional list, my lord, there will be, my lord, no such, my lord, effect on the.
Read the order.
Yes, my lord. Page 129. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಇವರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕರವಿಪೀಠ ಇಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಹೊರಡಿಸಲಾದ ಆದೇಶ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಆದೇಶಕ್ಕೆ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಆಯೋಗದ ಸಭೆಯಲ್ಲಿನ ನಿರ್ಣಯದಂತೆ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ರಂದು ಸರ್ಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆಯಲಾಗಿದೆ. ಅದರಂತೆ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಪತ್ರದಲ್ಲಿ ಆಯೋಗವು ದಿನಾಂಕ ರಂದು ಅಧಿಸೂಚಿಸಲಾಗಿದೆ ಲಾದ 575 ದ್ವಿತೀಯ ದರ್ಜೆ ಹುದ್ದೆಗಳಿಗೆ ದಿನಾಂಕರಂದು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆಯಂತೆ ಪಿಯುಸಿ ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿದ್ದು, ಸದರಿ ಸುತ್ತೋಲೆಗೆ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ರಂದು ಡಿಪ್ಲೊಮಾ ITI ಸೋ ಅಂಡ್ ಸೋ ಅಭ್ಯರ್ಥಿಗಳು NIOS ಎಂಬ ಸಂಸ್ಥೆಯು ದೂರ ಕಲಿಕೆ ಮಾದರಿಯಲ್ಲಿ ನಡೆಸುತ್ತಿರುವ ಹಲವು ಕೋರ್ಸ್ಗಳಲ್ಲಿ ಯಾವುದಾದರೂ ಒಂದು ಭಾಷಾ ಕೋರ್ಸ್ ಮತ್ತು ಒಂದು ಶೈಕ್ಷಣಿಕ ವಿಷಯದಲ್ಲಿ ಅಥವಾ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಮಂಡಳಿ ನಡೆಸುವ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಒಂದು ಭಾಷಾ ಮತ್ತು ಒಂದು ವಿಷಯದಲ್ಲಿ ಹೆಚ್ಚುವರಿಯಾಗಿ ಉತ್ತೀರ್ಣರಾಗಿದ್ದಲ್ಲಿ ಮಾತ್ರ ಪಿಯುಸಿಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ ಎಂದು ಸ್ಪಷ್ಟೀಕರಣ ನೀಡಲಾಗಿದ್ದು, ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ರಂದು ಮೂಲ ದಾಖಲೆ ಪರಿಶೀಲನೆ ನಡೆಸಿ ದಿನಾಂಕರಂದು ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಪ್ರಕಟಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತಿದೆ. ಆದರೆ ದಿನಾಂಕ 30/9/2021 ಆದೇಶವು ಜಾರಿಗೆ ಬರುವ ಪೂರ್ವದಲ್ಲಿಯೇ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರು ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಅನ್ವಯ ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ ಎಂದು ಸರ್ಕಾರ CIUE ಇಲಾಖೆ ತಿಳಿಸಿರುತ್ತದೆ. ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿಗಳ ಮನವಿ ಮೇರೆಗೆ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಡಿಪ್ಲೊಮಾ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಪಿಯುಸಿ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸುವ ಬಗ್ಗೆ ಹೊರಡಿಸಿರುವ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಆದೇಶವನ್ನು ಪರಿಗಣಿಸುವ ಬಗ್ಗೆ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಯಾವುದೇ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯ ದಾಖಲಾತಿ ಪರಿಶೀಲನೆ ಬಗ್ಗೆ ಬಾಕಿ ಇದ್ದಲ್ಲಿ ಡಿಪ್ಲೊಮಾ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ತತ್ಸಮಾನವಾಗಿ ಪರಿಗಣಿಸಬಹುದೆಂದು ನೀಡಿದ ಅಭಿಪ್ರಾಯದ ಮೇರೆಗೆ ಸರ್ಕಾರ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಪತ್ರದ ತತ್ಸಮಾನತೆಯನ್ನು ಅನ್ವಯಿಸಿಕೊಳ್ಳುವಂತೆ ನಿರ್ಧರಿಸಿದ್ದು, ಅದನ್ನು ದಾಖಲೆ ಪರಿಶೀಲನೆ ಪ್ರಕ್ರಿಯೆ ಚಾಲ್ತಿಯಲ್ಲಿದ್ದಲ್ಲಿ 2019 ನೇಮಕಾತಿಗೆ ಅನ್ವಯಿಸಿಕೊಳ್ಳಲಾಗಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶ್ರೀ ಬಸವರಾಜ್ ಇವರು ಸೋ ಅಂಡ್ ಸೋ ನೇಮಕಾತಿ ಅಭ್ಯರ್ಥಿಯಾಗಿದ್ದು 11/2/2019 ಅಧಿಸೂಚನೆ ಸೋ ಅಂಡ್ ಸೋ ಹುದ್ದೆಗಳಿಗೆ ದಿನಾಂಕ ರಂದೇ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಲಾಗಿರುತ್ತದೆ. ನಂತರ ಅರ್ಜಿ ಹಾಗೂ ಅಡಕಗಳನ್ನು ಸಂಬಂಧಿಸಿದ ಇಲಾಖೆಗಳಿಗೆ ರವಾನಿಸಲಾಗಿರುತ್ತದೆ ಹಾಗೂ ದಿನಾಂಕರ ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆ ಹಾಗೂ ಸದರಿ ಸುತ್ತೋಲೆಗೆ 2/11/2020 ಸರ್ಕಾರಿ ಸ್ಪಷ್ಟೀಕರಣದಂತೆ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿದ್ದಲ್ಲಿ ಯಾವುದೇ ಅಭ್ಯರ್ಥಿಯನ್ನು ಡಿಪ್ಲೊಮಾ ಸೋ ಅಂಡ್ ಸೋ ಸದರಿ ನೇಮಕಾತಿ ಪರಿಗಣಿಸದೆ ಅವರುಗಳ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಅರ್ಜಿದಾರರು ಡಿಪ್ಲೊಮಾ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಪರಿಗಣಿಸಿದ್ದಲ್ಲಿ ಈಗಾಗಲೇ ಪ್ರಕಟಿಸಲಾದ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಪರಿಷ್ಕರಿಸಬೇಕಾಗುತ್ತದೆ. ಇದರಿಂದಾಗಿ ಇಡೀ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಹಲವು ಬದಲಾವಣೆಗಳಾಗುವ ಕ್ಯಾಸ್ಕೇಡಿಂಗ್ ಎಫೆಕ್ಟ್ ಸಾಧ್ಯತೆಗಳಿದ್ದು.
Where is the recruitment notification?
Yes, it's at my lord annexure
B, page
B, my lord. It starts from page 16. The relevant, my lord, qualification is at page, my lord, 21. the bottom, my lord, on page 21, ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗಳಿಗೆ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಮಂಡಳಿ ನಡೆಸಿದ PUC ಅಥವಾ ತತ್ಸಮಾನ ವಿದ್ಯಾರ್ಥಿಗಳು CBSE ಮತ್ತು so and so ನಡೆಸುವ ಕ್ಲಾಸ್ so and so ಇತರೆ ರಾಜ್ಯಗಳಿಂದ ಪರಿಸ್ಥಿತಿ so and so will be relevant. 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ ಅಥವಾ 2 ವರ್ಷಗಳ ITI ಕೋರ್ಸ್ ಅಥವಾ 2 ವರ್ಷಗಳ ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ so and so ಅಭ್ಯರ್ಥಿಗಳು.
You have completed 3-year diploma.
Yes, my lord, I have completed, but there was a qualification that, my lord, persons who have completed diploma, they are supposed to take up, my lord, one language and, my lord, one subject examination to be conducted by, my lord, that distance education department or, my lord, the PU board. Those two departments did not conduct, my lord, any such examination, single examinations is not there. Subsequently, my lord, Annexure K came to be, my lord, issued. Page 82. So this was a clarification sought and government order at K1. I'll read, my lord, 82, my lord. I'll read from the second paragraph. my lord. ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ so and so ಆದೇಶಿಸಿದಂತೆ ದಿನಾಂಕ so and so ಈಗಾಗಲೇ ನೇಮಕಾತಿ ಹೊಂದಿರುವ ಆದೇಶ ನಿರೀಕ್ಷಣೆಯಲ್ಲಿರುವ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ JOCU PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸಲು, ಅಂತೆಯೇ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ so and so ರಂತೆ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ PUC ತತ್ಸಮಾನವಾಗುತ್ತದೆ ಮತ್ತು 2ನೇ ಅಂಶದಲ್ಲಿ ಸೂಚಿಸಿದಂತೆ 2015ಕ್ಕಿಂತ ಹಿಂದಿನ ವರ್ಷಗಳಲ್ಲಿ ಸದರಿ ಡಿಪ್ಲೊಮಾ ಪಡೆದವರಿಗೆ KPSC ವತಿಯಿಂದ ಇಲಾಖೆ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಕನ್ನಡ ಭಾಷೆ ತೇರ್ಗಡೆ ಹೊಂದಲು ಸೂಚಿಸಿರುವುದರಿಂದ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯಿಂದ ಪಡೆದ 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿಯನ್ನು 2015ಕ್ಕಿಂತ ಹಿಂದಿನಿಂದಲೂ ಪೂರ್ವಾನ್ವಯವಾಗುವಂತೆ PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ. Based on that, my lord, I'll read 83 as well. ಮುಂದುವರೆದು ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ JOC ಯನ್ನು 18, 19, 20 ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಹಾಗೂ 2015ಕ್ಕಿಂತ ಹಿಂದಿನಿಂದಲೂ ಪೂರ್ವಾನ್ವಯವಾಗುವಂತೆ PUC ತತ್ಸಮಾನತೆಯನ್ನು ಸರ್ಕಾರಿ ಆದೇಶ so and so ಆದೇಶದನ್ವಯ ನೀಡಬಹುದಾಗಿ ಅಭ್ಯರ್ಥಿಯ ಅಭಿಪ್ರಾಯ ವರದಿಯನ್ನು ತಮ್ಮ ಮುಂದಿನ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. Page 84, my lord, is the government order. Relevant portion on page 87.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 3 ವರ್ಷ ಡಿಪ್ಲೊಮಾ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು PUC ವಿದ್ಯಾರ್ಹತೆ ತತ್ಸಮಾನವೆಂದು ಈ ಕೆಳಕಂಡ ಅಂಶಗಳಿಗೆ ಮಾತ್ರ ಪರಿಗಣಿಸಿ ಆದೇಶಿಸಿದೆ. ನೇರ ನೇಮಕಾತಿ, ಅನುಕಂಪ ಆಧಾರದ ನೇಮಕಾತಿ ಹೊಂದಲು ಮತ್ತು ಉನ್ನತ ಶಿಕ್ಷಣ ಪಡೆಯಲು ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ ಶಿಕ್ಷಣವನ್ನು PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸುವುದು. 2015ಕ್ಕಿಂತ ಹಿಂದಿನ ವರ್ಷಗಳಲ್ಲಿ ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ 3 ವರ್ಷ ಡಿಪ್ಲೊಮಾ ಉತ್ತೀರ್ಣರಾದ ವಿದ್ಯಾರ್ಥಿಗಳು KPSCಯಿಂದ ನಡೆಸಿದ ಇಲಾಖೆ ಪರೀಕ್ಷೆ ಜೊತೆಗೆ ಕನ್ನಡ ಭಾಷಾ ಪರೀಕ್ಷೆಯನ್ನು ತೇರ್ಗಡೆ ಹೊಂದುವುದು. It's made, my lord, equivalent.
When did you complete? When did you complete? 2014.
16/6/2014. Lord, I qualify, my lord, under these my lord, categories. That, my lord, there is no dispute. This order of clarification is 30th/9/2021.
Yes.
Lord, you will also kindly see, my lord, annexure K2, my lord, page 82. They say that 89, my lord, sorry, 89. I'll read the second paragraph. A clarification was sought whether this order can be made, my lord, retrospectively applicable. Para 2, my lord. ಮುಂದುವರೆದು ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ JOC ಯನ್ನು 18, 19, 20 ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಹಾಗೂ 2015ಕ್ಕಿಂತ ಹಿಂದಿನಿಂದಲೂ ಪೂರ್ವಾನ್ವಯವಾಗುವಂತೆ PUC ತತ್ಸಮಾನತೆಯನ್ನು ಸರ್ಕಾರಿ ಆದೇಶದನ್ವಯ ನೀಡಬಹುದಾಗಿದೆ. So it's applicable for, my lord, candidates of 18, 19 and 20.
This was also found in the earlier communication.
Yes, my lord. And in fact, my lord, There is one communication. After that, my lord, they took one more, my lord.
19/4/21 annexure K ನಲ್ಲೂ ಇದೆಯಲ್ಲ.
ಹೌದು.
Yes.
Lord, based on this, my lord, I had filed a writ petition, my lord, on the earlier occasion, annexure P, page 101, my lord. The relevant portion would be, my lord. And in fact, my lord, they took one more clarification where they said that, my lord, an internal communication was earlier, my lord, an endorsement was given to me saying that you will not be eligible because there is an internal communication which says it will be applicable only in cases where verification is not yet complete. Lord, that was, my lord, their answer. That was negated by the court, my lord, and it was asked to be reconsidered. I'll read, my lord, the relevant para. It starts from page 101, para 12, my lord. It is to be page 111, paragraph number 12, bottom.
Yes.
It is to be noted that applying the aforementioned facts on record and the affidavit shown by so and so, that the government order dated so and so is prospective in nature and is made applicable for document verification of the candidate which is under progress, and this aspect of the matter cannot be accepted as the said affidavit is contrary to unofficial office memorandum dated so and so. So, my lord, the reasoning, now also, my lord, they reject me on the count that it is prospective, it cannot be applied to you. There might be cascading effect, therefore we don't want to. This is already negated, my lord, by the court saying that this you cannot take as a defense.
Anyway, the recruitment has not come to a.
No, my lord, that.
Completed.
Yes.
Not
Still
complete.
on.
My lord, non-HK additional list has been published, my lord. It is ready and it is published. And that, my lord, has been stayed by this honorable court, my lord. He applied, my lord, in HK quota. My lord, HK quota, there is no proposal from the department for publishing the additional list. Therefore, my lord, the additional list of HK, my lord, reason has not been prepared. Whereas, my lord, interim order is obtained, my lord, in respect of the list, additional list published for non-HK, my lord, wherein the several candidates have been.
But what about HK? He's claiming the HK quota.
HK quota.
What is the roster for HK quota?
Last, my lord, before that, my lord, may I submit?
ಅಷ್ಟೇ ಮುಗೀತು. Anything else?
Andre, my lord, the last candidate, my lord, he has also not, my lord, taken that, my lord, post. The person who is now implemented, my lord, as a respondent. He subsequently applied for FDA, my lord. He has secured. He has not joined, my lord.
HK category?
No, my lord. Under the general category also, my lord, there will be disturbance to only one candidate. He is, my lord, at respondent number 3 herein. He has, my lord, though he secured, my lord, he was appointed as STA. He did not join. And, my lord, he took up exams for, my lord, FDA. My lord, that post, my lord, is also vacant. And, my lord, additional list for HK quota. And so, my lord, even as per, my lord, the last ranking also, my lord, I'm still, my lord, eligible. B horse of, my lord, additional, my lord, list. If additional list is issued, my lord, I will be, my lord, on the top of the list.
Lord, the petitioner is relying mainly on annexure K, K1, K2. Lord, these are, my lord, the circulars, my lord, issued subsequent to publication of final selection list. The notification has been issued on 11/2/2019. Lord, the final selection list has been, my lord, published on 2/3/2021.
Yes.
As on the date of, my lord, the publication of, my lord, recruitment notification, the prevailing circular, my lord, which I have, my lord, produced at annexure R1, my lord, wherein, my lord, about the equivalence, my lord, it has been clearly mentioned. Lord, kindly see annexure R1. Dated 27/2/2018. ಅದರಲ್ಲಿ page number 9, my lord. Page number 9, second, my lord. Second ಇದರಲ್ಲಿ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4, 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ ಅಥವಾ 2 ವರ್ಷಗಳ ITI ಕೋರ್ಸ್ ಅಥವಾ 2 ವರ್ಷಗಳ ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿಗಳು NIOS ನ ವತಿಯಿಂದ ನಡೆಸುವ ಒಂದು ಭಾಷಾ ಕೋರ್ಸ್ ಮತ್ತು ಒಂದು ಶೈಕ್ಷಣಿಕ ಅಥವಾ ಪದವಿ ಪೂರ್ವ ಮಂಡಳಿಯು ನಡೆಸುವ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಒಂದು ಭಾಷೆ ಮತ್ತು ಒಂದು ವಿಷಯದಲ್ಲಿ ಉತ್ತೀರ್ಣರಾದಲ್ಲಿ ಮಾತ್ರ PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸಬಹುದು. Thereafter, my lord, the KPSC sought clarification, my lord, from the DPR as per annexure R2 dated 2/11/2020. Second paragraph. ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ 27/2/2018 SSLC, PUC ಹಾಗೂ ಪದವಿ ವಿದ್ಯಾರ್ಥಿಗಳ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಿಸಲಾಗಿದೆ. ಈ ವಿದ್ಯಾರ್ಥಿಗಳ ತತ್ಸಮಾನತೆಯ ಮಾನದಂಡವನ್ನು ಶಿಕ್ಷಣ ಇಲಾಖೆಯು ನೀಡಿರುವ ಅಭಿಪ್ರಾಯಗಳನ್ವಯ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಡಿಪ್ಲೊಮಾ, ITI, ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿಗಳು NIOS ಎಂಬ ಸಂಸ್ಥೆಯ ದೂರ ಕಲಿಕೆ ಮಾದರಿಯಲ್ಲಿ ನಡೆಸುತ್ತಿರುವ ಹಲವು ಕೋರ್ಸ್ಗಳಲ್ಲಿ ಯಾವುದಾದರೂ ಒಂದು ಭಾಷಾ ಕೋರ್ಸ್ ಮತ್ತು ಒಂದು ಶೈಕ್ಷಣಿಕ ವಿಷಯದಲ್ಲಿ ಅಥವಾ ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಮಂಡಳಿಯು ನಡೆಸುವ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಒಂದು ಭಾಷೆ ಮತ್ತು ಒಂದು ವಿಷಯದಲ್ಲಿ ಹೆಚ್ಚುವರಿಯಾಗಿ ಉತ್ತೀರ್ಣರಾಗಿದ್ದಲ್ಲಿ ಮಾತ್ರ PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ. NIOS ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 18/7/2016 ಪ್ರತಿ ಲಗತ್ತಿಸಲಾಗಿದೆ. ಇದನ್ನು ಹೊರತುಪಡಿಸಿ ಡಿಪ್ಲೊಮಾ, ITI, ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ ಕೋರ್ಸ್ನಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗಿರುವ ಭಾಷಾ ಅಥವಾ ಶೈಕ್ಷಣಿಕ ವಿಷಯವಾಗಲಿ ಅಥವಾ ಬೇರಾವುದೇ ಕೋರ್ಸ್ನಲ್ಲಿ ಉತ್ತೀರ್ಣರಾದ ಭಾಷಾ ಅಥವಾ ಶೈಕ್ಷಣಿಕ ವಿಷಯವನ್ನು ಪರಿಗಣಿಸುವಂತಿಲ್ಲ. ಆದರೆ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಯ ಪರೀಕ್ಷೆಯ ನಂತರ ಇದನ್ನು ಪಾಸ್ ಮಾಡಲು ಕಾಲಾವಕಾಶ ನೀಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಒಂದು ವೇಳೆ ಡಿಪ್ಲೊಮಾ, ITI, ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿಗಳು PUCಯನ್ನು ವ್ಯಾಸಂಗ ಮಾಡಿ ಅನುತ್ತೀರ್ಣರಾಗಿದ್ದು ಅದರಲ್ಲಿ ಒಂದು ಭಾಷೆ ಒಂದು ವಿಷಯವನ್ನು ಉತ್ತೀರ್ಣರಾಗಿದ್ದಲ್ಲಿ ಅಂತ ಅಭ್ಯರ್ಥಿಗಳಲ್ಲೂ ಸಹ ಡಿಪ್ಲೊಮಾ, ITI, ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ PUCಯ ತತ್ಸಮವೆಂದು ಪರಿಗಣಿಸಬಹುದಾಗಿದೆ. 27/2/2018 ಸುತ್ತೋಲೆಯಲ್ಲಿನ ಅಂಶಗಳು ಆ ದಿನಾಂಕದ ನಂತರ ಅಧಿಸೂಚಿಸುವ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಪ್ರಕರಣಗಳಿಗೆ ಅನ್ವಯವಾಗುತ್ತದೆ ಎಂದು ತಿಳಿಸಲು ನಿರ್ದೇಶಿಸಲ್ಪಟ್ಟಿದ್ದೇನೆ.
But this is dated 2/11/2020.
My lord, this is, my lord, sought clarification with regard to the annexure R1 dated 2027 to 2018, my lord. And for this particular recruitment notification, my lord, this clarification is sought, my lord. And my lord, on the basis of this clarification, my lord, the final selection list has been prepared. Thereafter, my lord, this annexure K, K1, K2, my lord, has been issued by the Department of Education. Lordship, kindly annexure K. This is, my lord, the internal, my lord, the communications, annexure K, the Department of Education. Page number 82.
Yes.
ಮುಂದುವರೆದು ಪೇಜ್ ನಂಬರ್ 83 ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್. ಮುಂದುವರೆದು ತಾಂತ್ರಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ 3 ವರ್ಷ ಡಿಪ್ಲೊಮಾ JOCಯನ್ನು 18, 19, 20 ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಹಾಗೂ 15ಕ್ಕಿಂತ ಹಿಂದಿನಿಂದಲೂ ಪೂರ್ವಾನ್ವಯವಾಗುವಂತೆ PUCಗೆ ತತ್ಸಮಾನವೆಂದು 6/8/2021 ಸರ್ಕಾರದ ದಿನಾಂಕ 39/20 ಆದೇಶಗಳನ್ನು ನೀಡಬಹುದಾಗಿ ಅಭಿಪ್ರಾಯ ವರದಿಯನ್ನು ತಮ್ಮ ಮುಂದಿನ ಆಹ್ವಾನಗಳಿಗೆ. This is the, my lord, the opinion has been sent. And my lord, once the final selection list has been published, if it is made retrospective effect, my lord, then, my lord, then the entire process will be, my lord, again will be, my lord, changed.
Because point out how many diploma candidates are there who are selected? Where are the diploma candidates? Or any PUC candidate or who will be displaced by the petitioner? Yaar idar? ಅಥವಾ ಇದೇ ತರ ಯಾರಾದ್ರು ಬೇಕಾದಷ್ಟು ಬೇರೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಇದಾರಾ?
ಇದೇ ತರ ಬೇರೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್, my lord, ಅವರು ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದು ಸುಮಾರು ಇದ್ದಾರೆ.
Correct, but see, if the entire, he says that one person was selected is not reported.
He will be the only person who will be disturbed, my lord. R3, my lord, is the only person who will be disturbed. And there are no other claims by any other diploma holder, my lord,
But, my lord,
on this count.
not, my lord, this is made applicable only to the case of the petitioner, my lord. If it is held that, my lord, these my lord, annexure K1 has to be made retrospective effect and made applicable to the present recruitment notification. Then, my lord, maybe, my lord, the additional list may, my lord, be published, my lord, in respect of HK reason. Then, my lord, the other candidates who, my lord, did not select, my lord, they may.
Correct, but you say, see, you also say in the notification,
Yeah.
annexure B ನಲ್ಲಿ, you say 3 ವರ್ಷಗಳ ಡಿಪ್ಲೊಮಾ ಅಥವಾ 2 ವರ್ಷಗಳ ITI ಕೋರ್ಸ್ ಅಥವಾ 2 ವರ್ಷಗಳ ವೃತ್ತಿ ಶಿಕ್ಷಣ ಡಿಪ್ಲೊಮಾ ಅಭ್ಯರ್ಥಿಗಳು.
Yes, ma'am.
You don't say the notification that NIOS ನವರು ಮಾಡಿರೋದು.
ಅಲ್ಲ, ಇದೆ next page ಅಲ್ಲಿ ಇದೆ, madam.
That will be for the purpose of declaring the probation, you can always impose a condition. For the purpose of declaring probation, period of probation or satisfactory completion of probation period, you can impose this condition within 2 years in NIOS in the ಒಂದು ಭಾಷಾ ಕೋರ್ಸು ಮತ್ತು ಒಂದು ಶೈಕ್ಷಣಿಕ ವಿಷಯದಲ್ಲಿ ಮಾಡಿ.
But then again, my lord, alteration of my lord, this conditions of notification.
Alteration ಹಿಂಗಾಗುತ್ತೆ.
ಇದರಲ್ಲಿ
You
ಏನ್ condition?
continue to insist. See, 2014 is obtained. 2014 is obtained some degree diploma. When he applied for the against this notification, he obviously could not have known that NIS one course ಮಾಡಬೇಕು ಅದು ಮಾಡಬೇಕು. He did not know. So therefore, you can make this as a condition precedent for declaring his period of probation. 2 ವರ್ಷದಲ್ಲಿ ನೀನು ಮುಗಿಸ್ಕೋಬೇಕು ಈ ಕೋರ್ಸ್. Subject to you completing 2 years this course. ಮಾಡ್ಬೋದಲ್ಲ?
ಅವ್ರು ಆ ತರ ಕೋರ್ಸ್ ಮಲೋಡ್ ದಿ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಈಸ್ ಮಲೋಡ್ ದಟ್ ದೀಸ್ ಟು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಮಲೋಡ್
Must have conducted.
ಅವ್ರು ಕಂಡಕ್ಟ್ ಮಾಡೋದಿಲ್ಲ. ದೇರ್ ಇಸ್ ನೋ ಸಿಂಗಲ್ ಪೇಪರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೈ ಬೋತ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್.
ಯಾರ ಅಪೇರ್ ಆಗ್ತದೆ NIOS ಗೆ? National Institute.
ಅಲ್ಲ, that is now given up. Considering all these things, my lord, they said that this.
Just understand, ಯಾರು NIOS ಗೆ ಯಾರು ಅಪೇರ್ ಆಗ್ತದೆ? Central government. Indira Gandhi Open University.
Central government, Mr. Sudhir Singh, he is the deputy solicitor.
You get information whether NIOS has conducted any course from 2014 to 2016, any discipline, subject or any language or any discipline.
Please.
If no course is conducted, where's the question of you saying that this can't be equivalent unless he obtains course from NIOS andre? How can you impose a condition which cannot be complied?
ಇವನ್ ಅನೆಕ್ಷರ್ K1 ಕೂಡ NIOS ಇಂದ ಬೇಕು ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ.
ಸರಿ, NIOS ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ. ಈ says that NIOS
ದೂರ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಬಟ್ ಮಿಷನ್ is important, but get to instruction.
whether NIOS is a party.
No, not a.
Barcode. The learned counsel for the petitioner is directed to implead NIOS. Again, what is the full form?
ಅಲ್ಲಿ National Institute of Open Schooling.
National Institute of Open Schooling as a respondent number 4 in this petition.
6 of them.
Learned Mr. Sudhir Singh R. Vijapur is directed to accept notice for respondent number 4. Counsel for the petition is directed to serve a copy of the writ petition to Shri Sudhir Singh R. Vijapur. Mr. Sudhir Singh R. Vijapur is directed to secure information whether NIOS is conducting any examination, is conducting any course, any language course,
ಹೌದು.
any language,
Single language course.
Kannada language course. Or ಇನ್ನೊಂದೇನು?
Or my lord, any single subject, my lord,
A
course.
single subject from the year 2014 till date, till 2020, 2019.
Yes.
Till the year 2019. Yes, list on yavat. Please amend the cost.
Yes. It's already amended, my lord. He will be respondent
Introduce
7.
ಮಾಡಿ, introduce. I permitted you to.
Yes, he will be respondent 7, my lord. There are
7,
other two respondents,
7.
6, sir. He will be 6, my lord, sorry.
Respondent number 6. Take whichever date is convenient.
The 27.
ಈ ಆರ್ಡರ್ ಕಾಪಿ ನಾವು ಸುಧೀರ್ ಸಿಂಗ್ ವಿಜಾಪುರ ಕಳಿಸ್ತೀವಿ.
I'll inform him and serve a copy.
Next. Ravindra Reddy.
Most respectful, my lord.
Huh?
Most respectful submits, my lord.
What motion?
I am in this writ petition respondent number 7, my lord.
Adalde,
My lord. Posting for memo, my lord.
please wait.
Okay.
Wait.
Okay.
Idರಲ್ಲಿ, your lordships,
Ah.
bank had made submission that the entire amount has been paid. All dues, due amount has been paid and account has been regularized.
Last date only that he has cleared the dues and he is paying the EMI regularly, man. That's a submission. That is a.
Immediately.
Yes,
How
yes.
You will not pursue the proceedings.
That date is also over, I think. Purpose on
That submission may be noted, my lord.
24 December, my lord.
The petitioner has sought for a writ in the nature of mandamus to consider the representation, consider their representation dated 26/7/2024 for settlement of the loan. They have also sought for a direction to the respondents not to take further action, take action further to the, not to take any action pursuant to the notice issued under section 13(2) of the Surface Act. Next slide.
As per Annexure C, reply was.
Petitioners contend that they had raised a loan of ₹70, they had raised a term loan of ₹70 lakhs from the respondent bank. And due to certain alleged defaults, the respondent had initiated proceedings under section 13(2) of the Surface Act. The petitioners contend that they are not able to pay a sum of ₹62 lakhs 4,599 by 11/7/2024. And therefore, they offer to settle the dispute, settle the amount if a one-time settlement is offered by the respondent. Full stop. The petitioners contend that despite their request for a one-time settlement, the bank did not take any steps.
My lord, one-time settlement, they offered only 15 lakhs.
Full stop. In that way of the matter, the full stop. The petitioners are therefore before this court seeking for a direction to consider the request for one-time settlement and also not to take any further action based on the notice under section 13(2) of the Surface Act. Next para. When this petition was listed listed in the orders list, when the petition was listed regarding maintainability of the writ petition, it was brought to the notice of the court by the learned counsel for the petitioner that the petitioner has paid up the amounts due and has regularized the account.
It is respondents their submission, Lord. They are making submission to them.
The learned counsel for the respondent accepts the aforesaid submission, submits that the petitioner has regularized the account and is paying the installments. Full stop. In view of the aforesaid submission by the learned counsel for the petitioner and the learned counsel for the respondent, there is no need to pass any orders to direct the respondent to consider the representation of the petitioner and also not and to restrain the respondents from taking any action under section 13(2). Hence, the writ petition stands disposed of. However, liberty is reserved to the respondent to proceed in accordance with law in case the petitioner again defaults of the balance money, balance loan amount. Balance and the loan.
The submission to offer, my lord, the request for the consideration of one-time settlement may also be kept open, my lord, because I am willing to settle the amount. Well, it is in the interest of bank, in the interest also, my lord, your lordship may consider.
Who are you? Ravindra Reddy, who is this man?
Yes, my lord. I am
appearing along
with
with me.
Ravindra Reddy, my lord. Sorry for the interference. Me and Reddy are together, my lord.
Appearing together, my Lord.
It is also open. It is also open for the petitioners to request the respondent for a one-time settlement of the dues.
Please, my lord. I'm grateful, my lord.
Chikka Naragund. There is no representation for the petitioner, though it is called twice in the day.
No, I am appeal petitioner, Your Lordship. Lord, in this case, Your Lordship, not the petitioner sought for grant of an additional increment for having passed the Kannada language examination, Your Lordship.
Yes, government.
In fact, it is covered by decision, Your Lordship. I produced the judgment along with the memo, Your Lordship.
Covered.
Covered, Your Lordship.
Huh? He says that he's passed some departmental examinations entitled for some increment.
Yes.
One additional increment. Which is a judgment?
Not the, I produced the note along with the memo, Your Lordship. On Monday, I filed the memo, Your Lordship. In this case, petitioners are not the teaching and non-teaching staff of the private aided educational institutions. They sought for grant of an additional increment having passed the Kannada language examination.
Yeah, no. Can I dispose it off in terms of this judgment? Nodidira? Nodidira, yes, anta yake ಹೇಳ್ತೀರಾ? Learned counsel, learned AGS seeks time, list on.
Date may be fixed, Your Lordship.
Yes. Next.
Lordship, date may be fixed, Your Lordship.
Mr. All cases, date will be fixed.
Please, Your Lordship.
ಯಾವ್ದು 230 ಯಾವ್ದು ಇತ್ತಲ್ರಿ ಯಾವ್ದ್ರಿ ಇದು ಕರೀರಿ ಪಾಸ್ವರ್ಡ್ ಎಲ್ಲ ಆಯ್ತಾ ಪಾಸ್ವರ್ಡ್ ಇದೆಯಾ ಯಾವ್ದು ಕರೀರಿ
My lord, I seek your attention at page number 46, my lord. The typed copy of the order sheet.
Yes.
May I read, my lord? Shri GS Advocate filed memo and furnished registered sale deed. Shri MM Advocate for DHR files memo stating that in view of the sale deed, the EP may be closed. My lord, as per Rule 32 of Order 21, it is mandatory under sub-rule 2 that the court commissioner should submit a draft sale deed to the executing court and the executing court should thereafter approve the draft sale deed.
Who was executed the sale deed?
The court commissioner, my lord. And the court commissioner has directly submitted the registered sale deed instead of submitting the draft sale deed to the executing court, and the executing court should have in turn given the notice to the judgment debtor, and after recording his objections, the court could have approved the draft sale deed and thereafter proceeded
Draft
to
sale deed
execute
is not furnished?
No, my lord. And directly the registered sale deed is furnished. My lord, I am relying upon decision of the Supreme Court, which says that rule under 32 cannot be diluted.
Yes.
My lord, in the morning hours, your lordship had also raised question regarding not pressing the issue before appellate court. My lord, the appellant is leading evidence on delay, and after 25/9/2024, no date is given in the appeal, my lord, as the matter stands transferred to different court.
Correct, but you did not urge this ground in the morning. You never said that the draft itself is not furnished. Have you gone through the order sheet?
Yes, my lord.
Draft Puttila, are you sure?
Yes, my lord. Yes. They have not only that, my lord, after 2 days, they have submitted application under order 21 rule 35 seeking possession also.
Possession they can seek, but what about draft say whether
No,
draft
my
is
lord.
given or not?
No, my lord. It is not submitted to the court and not even
Come to
submitted.
page 27. Call on for furnishing the draft sale deed and payment of the balance consideration. So and so for memo and filed a DD for rupees 5 lakhs bearing number so and so. In view of the balance, view of. To furnish copy of sale deed, column 16(7).
The judgment debtor only came to know about the passing of decree when surveyors entered the land to draw Lebanese sketch map, my lord. And thereafter, immediately on the next day, that is on 18/1/24, he filed an advancement application and filed wakalat. And on the next date of hearing, the court commissioner along with decree holder has
Please read
submitted
the
the
order
registered
dated
sale deed.
18/6/2022, page 27. For steps to call on. Shri so and so for files memo and 2 DD for rupees 5 lakhs. Bearing DD number so and so and sought to issue also in view of the deposit of balance consideration by the decree holder. Issue commission warrant to so and so Chikkalinge so and so to execute the referred sale deed in respect of social property. Draft sale deed kottilla anta henge ಹೇಳ್ತಿ?
My lord, it is not served upon us, my lord.
It is filed in the court.
They have submitted the registered sale deed itself, my lord.
That is why I asked you to read that order, page 27.
But there is no reference regarding submission of draft sale deed.
You are not reading, that is the problem. Read that document. Page 27 ಓದಪ್ಪ ಅಂತ ಹೇಳಿ ಓದ್ತಾ ಇಲ್ಲ. 16(7). It's not. Where is this memo? 18/6/2022 file ಮಾಡ್ರ memo copy ಇಲ್ಲಿ.
We have not produced that.
You please verify whether draft sale deed is, where have you mentioned in the writ petition whether draft sale deed is not furnished?
My lord, we have referred it in the petition.
ಎಲ್ಲಿ ಹೇಳಿದೆ? Where is that ground taken that the draft sale deed is not furnished? Then.
Para 17 and 18, my lord.
What?
It is submitted that even after petitioner judgment debtor appearing before the execution court on 18/10/2022 by filing an advancement application, serving copy to the learned counsel for the decree holder respondent.
Issue emergent notice to the respondent. In addition, the learned counsel for the petitioner is directed to serve the learned counsel for the respondent in EP number 45/21 pending consideration before the principal senior civil judge and CJM Bidar. Full stop. In view of the statement made in the writ petition that a copy of the draft sale deed was not furnished in EP number 45/2021, but the court had directed the court commissioner to file his report along with a copy of the sale deed comma, all further proceedings in EP number 45/2021 pending consideration before the principal senior civil judge and CJM Bidar deserves to be stayed. Accordingly, the said proceedings are stayed.
Obliged.
Hema Kulkarni. More. Yes. Which property, madam?
Two properties minutes, page number 17.
Page number
17.
17.
17.
Ah. 10 acres and 9 acres.
No minutes. There are two 30 guntas and one is second one minute that is 30 guntas
Ah.
and last serial number 5, 10 guntas.
Converted land or what?
Converted, both are any lands. And the petrol bunk is situated on the 10 guntas land. So let all other properties be with them, 10 acres and 30 guntas, 9 acres, 30 guntas. Let them have more charge over it.
Let the amount, whatever that is
Please.
going to be paid,
Please,
let it be routed through the bank.
please, minutes.
Madam, ಬರ್ಕೊಳ್ಳಿ issue. Even ಬೆಳಿಗ್ಗೆ ನಾನು ಹೇಳ್ತೀನಿ. Though this petition is not maintainable in view of an appeal remedy available to the petitioner against the attachment of the properties under the provisions of the Karnataka Cooperative Societies Act, yet since the learned counsel for the petitioner submits that the petitioner is desirous of settling off the dues to the respondents, the order of attachment bracket annexure
B19.
B,
Section B1.
B and
B1
B1.
and C1.
annexure B na, annexure B. Annexure B is only a notice.
B, next is, along with the notice, arbiter award is there. Page number 16, annexure B. And also annexure B1, page number 19. There are two loan accounts, there are two orders.
Annexure the enforcement of the award dated ten 6/2024. Awards, somebody enforcement of the awards dated 10/6/2024, bearing numbers, page number 16, numbers
4095 and 4096.
16 and 19, red pencil mark. The state. Liberty is reserved to the petitioner to encumber, transfer or sell item numbers 2 and item
Five.
numbers 5 mentioned in the award, subject to the condition that the sale consideration that may be realized shall be routed to the respondent number 2 na?
1.
To the respondent number 2.
2.
For adjustment against the outstanding. It is made clear that if the petitioner does not route the sale consideration realized to the respondent number 2, any alienation made by the petitioner will not bind the respondent number 2. Insofar as items 1, 3, and 4 mentioned in the awards, the attachment shall continue and no alienation shall be made in respect to those properties.
Great.
What about 25 lakhs? You said 25 lakhs you'll deposit.
25% of the sale.
In addition, the petition shall also deposit 25%,
ಮಾಡ್ತಾನೆ ಇದ್ದಾನೆ.
25% of the outstanding, 25% of the award amounts, of the amounts payable under the awards referred above within 3 weeks.
No, my lords,
4
8 weeks
weeks.
at least. 8 weeks.
No, within
weeks.
4 weeks. Yes.
ಅದು 25 lakhs ಅಂದ್ರೆ ಎರಡು ಅಕೌಂಟ್ ಸೇರಿದ್ರೆ ಮತ್ತೆ
25% ಎರಡರಲ್ಲೂ. ಎರಡು ಅವಾರ್ಡ್
ಸೇರ್ಸಿ.
ತಂದಿರೋದು.
25 ಆಗುತ್ತೆ ಮತ್ತೆ ಪ್ರಾಪರ್ಟಿನ ಸೇಲ್ ಮಾಡಿ.
ನೀವು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡ್ತಿರೋ ಏನ್ ಮಾಡ್ತಿರೋ ಅದು ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು.
That is, I have sought the permission to sell it and realize the entire
Permitted you to sell it,
Please.
provided all the amounts have to be routed through the bank.
out towards the outstanding amount.
ಹೌದು.
Hmm.
Yes, next.
Time period, my lords, 4 weeks at least, 25
Fix.
lakhs.
25%, 4 weeks.
Grateful. May I get the hand delivery? Appeal. This is utilization of land without giving compensation.
Yes, Santosh Kumar
Respondent.
Maradi. Santosh Kumar Maradi. ಯಾಕೆ ಬರಲ್ಲ ಇವರು? There is no representation for the respondent number 2, though it is called twice in the day.
State ಇದೆ.
As the last chance list on.
ಅಲ್ಲ ಸ್ಟೇಟ್ ಹೈವೇಗೆ ಅವ್ರು ಅಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ.
Huh?
ಸಂತೋಷ್
It
ಮರಡಿ
is not for state highway,
Petitioner.
NH.
NH.
ಇಲ್ಲ ಅಂದ್ರೆ ತಾವೇ ತಗೊಂತಿದ್ರೆ ತಾವೇ.
ಇಲ್ಲ, ಇಲ್ಲ,
ತಗೊಳ್ಳಿ.
ನಾವು
What he
NH
says, he doesn't appear for that ಅಂತ ಹೇಳ್ತಾನೆ.
ಅಲ್ಲ ಅವರೇ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಬಂದು ಹೇಳ್ಬೇಕಲ್ಲ ನಾನು ಇಲ್ಲ ಅಂತ.
Date,
ಪ್ರಾಸೆಸ್ ಮಾಡೋ ಉದ್ದೇಶ, ಇಶ್ಯೂ ಮಾಡೋ ಉದ್ದೇಶ ಏನು?
grateful.
Yes. Yes. ಆಯ್ತಾ ಪಾಸ್ ಅವರೆಲ್ಲ? ಯಾವ್ದು? ಸಂತೋಷ್ ಚನ್ನಗೌಡ ಅಣ್ಣರಾಯ. ಅಣ್ಣರಾಯ.
Lord, I appear for the petitioner, my lord.
Hmm.
Lord, in this, my lord, what we have challenged is, my lord, the notice issued under section 49 for of the Gram Panchayat Act
Hmm.
for no confidence, my lord. My lord, law requires that, my lord, the notice, there should be 15 days clear notice, my lord,
ಅಲ್ಲ,
under rule
this is-
3.
This is some cooperative society matter. Seal number 1.
I'm so sorry.
ಅಣ್ಣರಾಯ.
Yes, madam, this is no conference matter.
ಈ 1.1 ಯಾವ್ದು ಅಣ್ಣರಾಯ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮ್ಯಾಟರ್ ಹಾಕಿದ್ರಲ್ಲಪ್ಪ. ನೂರಾಜಾನ್ ಸಾಹೇಬ್ ಲಾಲ್ ನದಾಫ್.
It is not cooperative society, my lord.
Whatever is listed before me is a cooperative
It
matter.
is Panchayat.
ಪಂಚಾಯತ್ ಮ್ಯಾಟರ್ ಮೇಲೆ
ಯಾಕೆ ಹಿಂಗ್ ಮಾಡಿದಾರೆ ಇವರು?
Lord, it is
Yes, 203931. Yes, please.
petition number 203 and double.
Yes, please go on.
my lord, no confidence motion held and subsequently fresh notification issued for election of new president and vice president.
So ಹೇಳಿ ಅವ್ರು.
ಅದೇ
Sorry,
calendar
Lord.
of events issued, my lord.
Lord,
Yes,
now, Lord, what was challenged is, Lord, is at page 29. Lord, rule 3, my lord, of the
29 or 29 ಇಲ್ಲ ಇಲ್ಲಿ.
page 29.
There's no page 29 here. Which petition are you arguing?
Lord, 203-933, my lord.
933 report. Page 29.
Yes, my lord. This is the notice issued by the Assistant Commissioner Indi,
Ah,
convening a meeting for the no confidence. Lord, and the rule, my lord, which is rule 3 of the Karnataka Gram Swaraj and Panchayat Raj motion of no confidence against Adhyaksha and Upadhyaksha of the Gram Panchayat rules 1994. My lord, require 15 days clear notice, my lord.
yes.
Now, my lord, your lordship will see, we have produced,
But 2025 is already over.
Yes, my
That's correct. See, there is an order, my lord, of this court, which, my lord, protected me, saying that, my lord, any decision to be taken in the meeting to be held on, my lord, this is 31/12/2024 order.
Order sheet ಕೊಡ್ರಿ. Where is the order?
on 31/12, my lord.
May I read it?
31?
31/12/2024.
ಕೊಡ್ರಿ ಅದು.
But it says any decision to be taken in the meeting to be held on the
Yes,
it is subject to
15 days notice
the
ಇದೆಯಂತ ಹೇಳಿ.
petition.
Yes, my
No, my
lord.
lord.
Clear.
Clear 15 days notice.
No, I'll show you the lordship, my lord.
Notice was issued on, my lord.
No, the notice was prepared on 16th of December, but kindly see the copy of, my lord, I have produced along with additional documents on 26/12/2024. Your lordship sees those documents, the last document on that, in that bunch, my lord. Your lordship will see, my lord, it is dispatched only on 21/12. Your lordship sees the seal.
Last document says.
But this is a notice. But these,
What is the page number which you are referring?
Lord, this is produced as additional documents.
That is right, on 26/12 I got it.
Yes, my lord. Lord, it would be page 9.
4, 5, 6, 7, 8, 9. This is the cover.
Cover.
ತಿದ್ಬಿಟ್ಟಿದ್ರಲ್ಲ ಯಾರು?
Alala, that is, we have noted that it is served on 23/12, but it is dispatched only on 21/12, my lord.
Not dispatch, my lord. It is received by the Assistant Commissioner in the office of the Assistant Commissioner on 21/12 after serving of the notice. May I forward the, my lord,
Alri.
Panchnama report. Panchnama report, may I forward, my lord?
ಅನಿಲ್ ಕುಮಾರ್ ಯಾರು ಪಿಟಿಷನರಾ?
By petition number 2, my lord.
ಪಿಟಿಷನ್ ನಂಬರ್ 2. ಈ ಪೋಸ್ಟ್ ಯಾವಾಗ ಹೋಗಿರೋದು ಇವ್ರಿಗೆ?
Not post, my lord, by hand only, my lord.
Huh?
Not by post, my lord. By
What is this then? Dispatch clerk, assistant commissioner office.
ಸ್ವೀಕರಿಸಿದೆ ಅಂತಿರೋ ಸರ್.
ಡಿಸ್ಪ್ಯಾಚ್ ಕ್ಲರ್ಕ್ ಅಂದ್ರೆ ಸ್ವೀಕರಿಸಿದೆ. ಡಿಸ್ಪ್ಯಾಚ್ ಅಂದ್ರೆ ಏನು? ಕಳ್ಸೋದು ಅಂತ.
By not post, my lord. I have produced Panchnama, my lord. Since
Then what is this, Mr.?
What they refers to receive the notice, my lords, the official went.
Lord, what my friend is referring to is the notice received by, my lord, the assistant commissioner. Lord, once the assistant commissioner receives notice, then he has to give 15 days clear notice according to rule 3.
I am not able to understand. Is this the only cover that was received by you, or
Yes,
is there any other cover?
No, my lord, this is the only cover.
What about petition number 1?
Petition number 1 served, my lord, in time.
How they
I produced the Panchnama.
ನಾನೇನೋ ಹೇಳ್ತೀನಿ, ನೀವೇನೋ ಹೇಳ್ತೀರಪ್ಪ ನೀವು. The postal cover, it was sent through to the petition number 1 through post.
No, my lord.
by registered post.
ಇಲ್ಲಿದೆ. Petition number 1 ಬಂದ್ರೆ registered post cover ಇಲ್ಲಿದೆ.
This is petitioner number 2. Show me for petitioner number 1. No. Good. Just give me a minute. We're just trying to locate it. Lord, my instruction is that, my lord, it was received on 23rd, 24th, they have filed the writ petition, my lord.
They have taken, refused, my lord, Panchanama has done. On
Anil Kumar ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ?
This is Anil Kumar ಕೊಟ್ಟಿರೋದು. This Shahad. Shahan, Noorjan ಕೊಟ್ಟಿರೋದು ಇಲ್ಲ. ಇಲ್ಲ ನೀವು.
Same date ಕೊಟ್ಟಿದ್ದು.
1912, you asked the police to send one person to serve.
Yes, ma'am.
1912.
Since
1912,
on 16, 17, 18, they refute, my lord.
okay. What is the date of the notice?
16 months.
16. 15 days ಯಾವಾಗ expire ಆಗುತ್ತೆ?
No, from the date of issuance, my lord, it is not from the date of service. The judgment is there.
What do you mean by 15 days clear notice?
Is from the date of issuance. my lord.
No,
Clear notice ಅಂದ್ರೆ ಏನು?
It's clear notice. There should
ಯಾರಿಗೆ
be,
notice
there should be
ಯಾರಿಗೆ?
gap of 15 days between the date of issuance
Notice
and date
ಯಾರಿಗೆ
of the meeting.
ಕೊಡ್ಬೇಕ್ರಿ? 15 days clear notice ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು?
To the members.
To the members.
Members.
So ಅಂದ್ರೆ 15 ದಿನದ notice
Yes,
ಕೊಡ್ಬೇಕು.
yes, yes.
ಕರೆಕ್ಟ್ ಅಲ್ವಾ?
Yes.
ನೀವು ಇವತ್ತು ನೋಟಿಸ್ ಹಾಕ್ಬಿಟ್ಟು ಇನ್ನ 2ನೇ ತಾರೀಕು ಮೀಟಿಂಗ್ ಇದೆ, 1ನೇ ತಾರೀಕು ಶುರು ಮಾಡಿದ್ರೆ?
No, my lord, it's not the case that much.
So therefore now you see 16th is the notice date.
Yes, yes.
19th ಪೊಲೀಸಿಗೆ ಲೆಟರ್ ಬರೀತಾರೆ ಏನಂತ?
Since they have not refused.
4 ಜನ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರುಗಳಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲು ಹೋಗುತ್ತಿದ್ದು ಸದರಿ ತಮ್ಮ ಅಧೀನದಲ್ಲಿ ಬರುವ ಒಬ್ಬರು ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿಯನ್ನು ರಕ್ಷಣೆಗಾಗಿ ನಮ್ಮ ಜೊತೆ ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ಕಳುಹಿಸಿ ಕೊಡಬೇಕಾಗಿ ಮಾನ್ಯರಲ್ಲಿ ಗೌರವಗಳೊಂದಿಗೆ ವಿನಂತಿಸಿದೆ. 19ನೇ ತಾರೀಕು ಕಳಿಸಿದಿರಿ. So it is not served as on 19th.
Yes, my lord. And on the 19th, they refused, therefore they have drawn Panchanama.
19th ಆದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
19th means.
it will be less than 15 days.
If they
19th
consider from the date of receipt, my lords, it will be less than. If it is considered from the date of issuance, it is 15 clear days.
Please point to date of issuance ಅಂತ ಹೆಂಗೆ ಎಲ್ಲಿ, on what basis are you saying?
Yes, sir.
ಇದು ಬಿಡ್ರಿ, what is the basis ಕೊಡ್ರಿ, rules ಕೊಡ್ರಿ.
May I read rule 3, my lord?
Yes.
A written notice of intention to make a motion under proviso to section 49 shall be in form number 1, signed by not less than than specified in section 49(1) of the total members of the together with a copy of the proposed motion shall be delivered in person by any 2 or of the members signing the notice to the assistant commissioner. This is the first stage, my lord. Second stage is the assistant commissioner shall thereafter convene a meeting for consideration of the said motion at the office of the Gram Panchayat on the date appointed by him, which shall not be later than 30 days from the date on which the notice under sub-rule 1 was delivered to him. He shall give to the members a notice of not less than 15 clear days of such meeting in form number 2. Now your lordship may see 3 also, my lord. A notice in form number 2 shall be given to every member, including the Adhyaksha and Upadhyaksha, by delivering or tendering the said notice to such member. If such member is not found by leaving such notice at his last known place of residence, then C, by registered post. D, if none of the means of aforesaid is available, by affixing with such notice.
ಈಗ ಪುಟ್ಟಸ್ವಾಮಿ judgment.
It is there, my lord. Your lordship have passed the order, my lord, in a division bench, my lord,
There's a-
that this is mandatory.
This, how do you explain this, Mr.? Not to the members and notice of not less than 15 clear days. ಅಂದ್ರೆ ಅರ್ಥ ಏನು? ನೀವು ತಗೊಂಬಂದಿದ್ದೀರಾ? ರೂಲ್ 3(1) ತಂದಿದ್ದೀರಾ?
Yes,
ರೂಲ್ಸ್ ಇದೆಯಾ?
with them.
ಓದಿ.
Rule 3(2), my lord.
3(1) ಓದ್ರಿ ಫಸ್ಟ್.
One.
3(2) ಓದಿ.
3(2), please. 3(2). The assistant commissioner shall thereafter convene a meeting for the consideration of the said motion at the office of the Gram Panchayat on the date appointed by him, which shall not be later than 30 days from the date on which the notice under sub-rule 1 was delivered to him. He shall give the members a notice of not less than 15 clear days of such meeting in form number 2.
ಏನಂದ್ರೆ
Meeting should be conducted.
ಅರ್ಥ ಏನ್ ಹೇಳಿತ್ತು?
A clear 15 days notice should be given to the members.
After giving to the members,
15 clear days notice.
after giving
To the members.
to the members a notice of not less than 15 clear days of such meeting. ಏನಂಗಂದ್ರೆ ಅರ್ಥ?
After giving 15 clear days notice, he has to issue the, fix the date of meeting.
So he should ensure that before the expiry of 15 days, he must serve the notice.
That is taken into consideration, my lords, the notice will not be served within 30 days. The entire process will not be completed within 30 days.
Mister, he has to do it. That is why they say ನಾಲ್ಕು ತರ ವಿಧಾನ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
Yes,
Delivering or tendering the notice member. Number 2, by leaving such notice at his last known place of residence or business within the Gram Panchayat, or by giving or tendering the same to some adult member or servant of his family, sending by registered post. If none of the means aforesaid are available, by affixing such notice on some conspicuous part of the house, if any, in which the member is known to have last resided or carried on business within the Gram Panchayat. ಎಲ್ಲಿದೆ 15 ದಿನ ನೋಟಿಸ್?
If the refute, my lords, they have carried a Panchanama and submitted report. The petition number 1 has been served on 19/12, my lords. Petition number 1 has served on 19. Panchanama report.
19th ಆದ್ರೆ ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ? 15 ಡೇಸು. 19th ಆಯ್ತು, 15 ಡೇಸ್ ಎಲ್ಲ ಆಯ್ತು.
From the date of issuance, my lords.
ಏನ್ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಲ್ವಾ? ಅಥವಾ ಏನ್ ಬುಲೆಟ್ ಪ್ರೂಫ್ ಹೆಡ್ ಏನ್ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೇಬಾರ್ದು ಅಂತ ತೀರ್ಮಾನ ಮಾಡಿದ್ರು? ಮತ್ತೆ I read it 3 times. Still you are saying from the date of notice. What is the other petition?
Lord, it's the same thing, Lord. One is.
ಇನ್ನೊಂದು ಯಾವ petition?
931.
ಸಂತೋಷ್. ಇನ್ನೊಂದು petition ಏನಿದು?
I'm asking what is their status?
Same matter, man.
Same matter. Same matter.
Same matter ಅಂತೀರಾ? ಇಲ್ಲಾರೋ ಸಂತೋಷ್
This is-
ಚೆನ್ನಾಗೊಂಡ. Who is this ಸಂತೋಷ್ ಜಿ ಚೆನ್ನಾಗೊಂಡ?
I am a per-
He's the member.
I am for
ನೀವೇನಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ?
connected matter, my lords. In connected matter.
For what?
Respond numbers.
ಇಲ್ಲ ಈ ಕೇಸ್ ಅದಕ್ಕೆ ಅಂತ.
That is connected, my lords.
ಈಗ 14 ವಿಲೇಜ್
ಅಧ್ಯಕ್ಷರು.
But I'm sorry, he is Adhyaksha of Harnal Grand Panchayat, Lord.
This is a different panchayat.
This is a
Yes,
different panchayat. The other earlier one was Rampura Panchayat.
In connected matter, I am preparing for respondent. 203933.
ಇದ್ರಲ್ಲಿ what are the facts of this case?
Same, my lord. This, here the notice is at page 21. Issue, the date on the notice is 17/12/2024.
What is there to show it was served
Yes.
thereafter? When was this notice served?
Lord, please see page. ಏನು ಕಾಣೋದಿಲ್ಲ. 21/12, my lord. The
21/12 ವಾಪಸ್ ಬಂದಿರೋದು ಇದು.
It is returned back.
No, no, he's received it. It is not returned.
So find out
I will find out.
how it was served,
Yes, ma'am.
how it was served, and you again, what is the urgency?
Lord, tomorrow is they have, Lord, the fresh election is, Lord, notified for Adhyaksha and Upadhyaksha. Tomorrow is the election.
Then we'll stay the election, get information, but put. This court had, in terms of the order dated so and so, held that any order dated 31/12/2024 held that any decision to be taken at the meeting held on 3/1/2025 pursuant to the impugned notice dated 17/12/2024 shall be subject to the result of the writ petition. It is stated that on 3/1/2025, the no confidence motion was held against the petitioners successfully. And now an election is scheduled to the post of Adhyaksha and
Adhyaksha and
Upadhyaksha.
Upadhyaksha. Yes.
Adhyaksha and Upadhyaksha. In that view of the matter, the elections to the post of Adhyaksha and Upadhyaksha of Rampura Gram Panchayat, Sindhgi Taluk, Vijaypura district is stayed. The learned AGA is directed to secure information as to when exactly the notice of no confidence was served upon the petitioners. Same order in the other petition also.
Ordinarily, Harnal Gram Panchayat. That change has to be made.
This is 17/12/3/1/2024, same.
And Gram Panchayat name would change.
Gram Panchayat is Harnal.
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 Hand delivery may be for.
Date 23, month. Next,
South Bakery.
23.
23.
Lord, I'm told there is one more third petition also, Lord. 203171.
203171. Not listed today.
Not listed.
203944. Indian is
Already election is held, my lord, 30th/2024.
election is already held.
Yes, ma'am.
No confidence, huh?
Yes, ma'am.
Yes, ma'am.
There is no stay.
Purport. The petitioner is challenged. A notice dated 13/12/2024 issued by the respondent number 3, convening a meeting of the members of the Panchayat to consider a motion of no confidence on also 30th, huh?
Yes.
30th December 2024. Stop. It is stated by the learned AGA that the meeting was held on 30/12/2024 and the no confidence motion was passed against the petitioner. In that view of the matter, this writ petition has become infructuous.
Yes.
Huh? Annara yaru, neeven. Serial number 2.
3944.
ಅದ್ಯಾಕ್ರಿ ಕಣ್ ಬಿಡ್ತಿರಲ್ರಿ ನೀವೇ ಮೂವ್ ಮಾಡಿರೋದು. It has become infructuous, hence the petition is dismissed. ಯಾವ್ದೋ ಮೂವ್ ಮಾಡಕ್ ಹೋಗಿ ಇದನ್ನ ಮೂವ್ ಮಾಡಿದಿರ. 200105/2025.
Petitions of the members of Respondent Fire Society, the name of the petitions are entered in the ineligible voter list, my lord. Since they are not attending the 2 GB meetings.
The petitioner has sought for a declaration that section 20(2)(a) of the Karnataka Cooperative Societies Act 1959 as ultra wires lacks legislative competence. He is also sought for a declaration that the ineligible voters list published by the respondent number 2 and 5 relating to the petitioners is illegal. Full stop. We have sought for a direction to the respondents to conduct elections to the respondent number 5 society in accordance with the list of member societies without insisting for compliance of section 22A4 of the Act 1959. Next para. The petitioners contend that the elections to the managing committee of the respondent number
5, my lord.
5 is scheduled to be held on
19, my lord. 19, my lord.
19th January 2025. Contends that since the petitioners are shown as ineligible to vote and that the list of ineligible members was not finalized as per Rule 13D of the rules, comma, the petitioners are entitled to cast their votes at the elections scheduled to be held on 19th of January 2025, subject however to the following conditions. Number 1, the petitioners are permitted to only cast their votes at the election scheduled on 19th January 2025. They shall not be permitted to participate or contest. They should not be allowed to contest at the elections. Number 3, the votes cast by the petitioner shall be kept in a separate box and shall not be counted. Full stop. The results of the election shall be declared but shall be subject to the outcome of this writ petition. The votes cast by the petitioner shall be counted after appropriate orders are passed by the court.
Can deliver.
I will take notice for R1 to R3,
AG is directed to accept notice for respondent number
1 to 3, my lord.
1 to 3,
1 to 3 issue.
4
ML
and 5 notice.
Respondents. ಮೇಲ್ಗಡೆ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಯಾವ್ದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ ಸೀಲ್ ನಂಬರ್ 2 ನಲ್ಲಿ AG is permitted to file a memo of appearance within 10 days.
Can deliver, maybe.
Yes, correctly. Mr. KM Ghate.
Second time, my lord, the petitioner was retired Patwari. Ad hoc pension was considered. And for family pension, he was entitled, my lord. Service register was not properly sent by the respondent number 4 and 5, my lord.
Family pension, who is the petitioner?
Petitioner is the retired village accountant, my lord. That is Shano Bhoga. He is entitled for family pension, my lord. A service book was
Yes, government.
Direction,
Yes, to how many time? 1 month, 2 month?
2 weeks.
Objection ga. Dispose ಮಾಡ್ಬೋದಾ?
this is a second writ petition, my lord.
Second writ petition.
Huh?
It is second writ petition, my lord.
Can we dispose it off?
Yes.
ಏನಂತ?
This direction to the respondent number 4.
Where is the first writ petition? Where is the order passed in first writ petition?
Page number,
Annexure, my lord, page 36.
ಏನಂತ ಆಯ್ತು?
Directed to send the proper papers after this order, my lord. The Accountant General Office, they once again returned the papers as per Annexure D, page 40, my lord. The following deficiencies were to be looked into by the Tahsildar and Deputy Commissioner, my lord. So they are not attending it in spite of the government direction, my lord.
Therefore, the petitioner sought for it in the nature of mandamus to direct the
4th and 5th respondent.
in
the present writ
respondent 1 ಅಂತ ಬರ್ದಿದ್ದೀರಾ.
But
In the writ petition, you mentioned it as respondent number 1.
and the respondent number 1 has directed. Now matter is pending before the respondent number 4 and 5, my lord.
Sorry, ಕೊಡ್ರಿ ಅವ್ರು.
Yes, correct. It is correct, my lord. I
Yeah.
got corrected. It was wrongly typed as 4 and 5. 1 is correct. my lord.
The petitioner sought for it in the nature of mandamus.
Yes.
Direct the respondent number 1 to forward the pension papers of the petitioner for the purpose of settlement of family pension as per the representation dated 1/8/2022, and also as per the letter issued by the respondent number 3 dated 8/12/2020 and 30/12/2021. Next para. The petitioner contends that he was serving as the village Patwari / Sanuboga of Ballur village, Aura Taluk.
Ballur J, my lord.
Huh?
Ballur J, Aura Taluku.
Ballur D ಅಂತಿದೆ, ನೀವು J
J, my lord.
J ಅಂದ್ರೆ
Ballur, ಅಂದ್ರೆ ಬಲ್ಲೂರ್ ಜಾಗೀರ್ದಾರ್ ಅಂತ ವಿಲೇಜ್ ಸರ್. ಬಲ್ಲೂರ್ ಜಾಗೀರ್ ಅಂತ.
ಕೊಡ್ರಿ ಕೊಡ್ರಿ.
No. Typographical error.
ಯಾರ್ ತಪ್ಪಿದ್ ನಿಮ್ದ ಇದು? It is your mistake.
Yeah, my mistake. My mistake.
Ballur J, Aura Taluk, Bidar district. He contends that as per the directions of the respondent 1 and 2, he was granted ad hoc pension of ₹500, which is enhanced to ₹2,000 as per the order passed by the respondent number 3 dated 7/12/2000. The petitioner contends that he and other similarly situated persons were considered for the purpose of grant of family pension as per the order passed by this court in WP number 39634 of 2024. Accordingly, the petitioners sought sanction of family pension before the respondent number 3 and 4 and 4 and 5. 3 and 4, full stop. The respondents 4 and 5 prepared the service record of the petitioner as per the directions of the respondent number 1. The petitioner contends that he submitted a representation before the response 4 and 5. However, the same was not forwarded to the respondent number 3. Therefore, the petitioner filed WP number 203870/2018. And this honorable court directed that all records, pension papers of the petitioner be transmitted as sought for by the respondent number 3. The petitioner contends that the respondent number 3 pointed out several deficiencies in the maintenance of the service records of the petitioner, and he did not properly forward deficiencies in maintaining service record of the petitioner, and that the respondents 4 and 5 did not properly forward it. The respondent number 3 therefore returned the pension papers of the petitioner to the respondent number 4 on 8/12/2020 and 30/12/2021. The petitioner contends that in the meanwhile, the response 1 and 2 have issued a circular that all pension papers of ex-Patwari / Shanbogas are to be sent through the office of the respondents 1 and 2 to the office of the respondent number 3. The petitioner contends that he made several representations requesting the respondents 4 and 5 representations mentioning that the respondents 4 and 5 have not responded to the request of the respondent number 3 and the pension papers of the petitioner was not forwarded. After attending the objections raised by the respondent number 3, the petitioner then gave his representation to the Under Secretary, Government of Karnataka, Department of Revenue, and also to the respondent number 1. Since the said representation is not considered, the petition is before this court. The learned counsel for the petitioner contends that this court had categorically directed the respondents to forward the pension papers of the petitioner for settling the family pension. He submits that the respondents have not moved an inch, and therefore the petitioner is before this court seeking for a direction. The learned AGA submitted that the representation of the petitioner would be considered in accordance with law and in the light of the directions issued by this court in WP number
203870 of
203870 of 2018. In view of the aforesaid submission, this petition is allowed. The respondent number 1 is directed to forward the pension
Under
papers.
the papers, pension papers to the respondent number 3.
Directed to forward the pension papers of the petitioner to the respondent number
3.
3.
AGA. Accountant General.
As per the representation of the petitioner dated 1/8/2022, and also as per the letter dated 8/12/2020 and 30/12/2021 issued by the respondent number 3. This shall be complied within 3 months from the date of receipt of a copy of this order.
Much obliged.
Please, Padiyal. Be Wadi.
And it may be taken next week notes. If you want to file objection, objections are ready.
Direction to consider for promotion.
Yeah, FDA, my lord, both of us.
Mr. is given a representation, consider it in accordance with law.
Please.
My lord, the question involved is, my lord, the FDA and stenographers both were eligible for promotion, my lord, to the post of office manager.
Let him file his objections.
Up.
Sir. Lord, AJ seeks time, HCGP seeks time to file objections, huh?
Next week.
Objection,
Objection, statement.
based on it. Next matter, Vaishali Hegde.
Lordship.
This matter, I was directed to bring the original records regarding the inter-merit selection procedure adopted.
My lord. Just a moment.
Please.
Order sheet itself runs into several pages.
Just one moment.
Yes, please.
Lord, these are the records which your lordships had called for. This is the three lists which are prepared.
Just going through this notification,
Yes, and these are the.
now one thing which did not occur to my mind is, there is no subject-wise reservation.
It cannot be also.
Why?
Well, we cannot find a particular person. We cannot allocate for instance, dairy chemistry is one subject.
But we cannot say that out of the 4 candidates who should be recruited from category SC, they can be only given the dairy chemistry. If there is a person who is saying that there is veterinary other subject also who belongs to SC, then that will be depriving that other SC person. Otherwise, it would amount to
post reserve ಆಗಲ್ಲ.
assistant post reserve agide.
Post ಆಗಿದೆ. But you're not specified which is the.
It cannot be. That is the notification say that we cannot bifurcate.
The law.
The law is, my lords, we cannot, the entire posts can be reserved. Out of 59 posts which are available to be recruited, percentage wise, whatever the reservations have to be granted, that we can grant it. There cannot be a bifurcation in the posts. There cannot be a subclassification of the posts, my lords, for the purpose of reservation. That would be negation of Article 16 itself completely.
Negation ಹೆಂಗಾಗುತ್ತೆ? There's one judgment ಯಾವ್ದು? ಅಲಹಾಬಾದ್ ಇಂದ ಹೋಗಿದ್ದು ಯಾವ್ದು?
ಹೌದು, ಅಲಹಾಬಾದ್ ಇದೆ.
ತಿವಾರಿ.
ಅದರಲ್ಲಿ ಒಂದು GOI has also been passed by, circular has been issued by
Everything
University
start-
Grants
in
Commission.
Karnataka, my lords, there is a legislation now. Before that, my lords, there are notifications which I have pointed out to your lordships. And that principle is also in the case of R.K. Sabharwal. R.K. Sabharwal is again followed in several.
ತಿವಾರಿ ಅಂತ ಜಡ್ಜ್ ಮೇಡಮ್.
ಮೇಡಮ್.
ಆ ತಿವಾರಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ ಹೇಳಿ. ಟೇಬಲ್ ಮೇಲೆ ಇತ್ತಲ್ಲ. ವಿವೇಕಾನಂದ ತಿವಾರಿ. Just check that Vivekanand Tiwari, Allahabad High Court in the Supreme Court ಹೋಯ್ತಾರೆ.
There is one Anand Kumar Tiwari versus High Court of Madhya Pradesh, which is referring to again R.K.
It's Allahabad, I remember. It is Allahabad judgment. Vivekanand Tiwari, I think 2021 ಇರಬೇಕು. Yeah, 2021. That was confirmed by the Supreme Court. And there must be one full court judgment of this court also. Full bench judgment of this court.
No, even otherwise also, my lord, what my friend is submitting, even according to their own submission, my lord, I will be eligible for promotion. He is trying to pursue your lordship.
The case of promotion or direct recruitment?
Direct recruitment.
Direct recruitment. Your lordship, they themselves have produced, your lordship may kindly have a glance on the statement of objections and memo which they have filed on 29/1, my lord. They have filed it. 29/1/2024, my lord. Affidavit they have filed. Your lordship got it. Your lordship at ink page 29, my lord. By the statement of objections, no, sir, they have filed on affidavit.
It was along with separate affidavit, my lord, as directed by the.
It is dated 29/1, my lord. 24. Lordship got ink page 29, my lord. My lord, very first sentence, my lord, vertical reservation as per government order DPR SBC 95 dated 20th June 1995. On the basis of this, my lord, these roster points have been, 100 roster points have been made. And my lord, as per their own submission now, at ink page 36 of the same affidavit, my lord, they refer to same, that is 20th June 1995. My lord, my humble submission would be, as per ink page 29, my lord, the first, second, third, fourth, fifth, sixth, seventh, eighth, and ninth, it has to be followed. 9 SC women, 2 women, SC 2 women. No other person above me have been appointed in SC category in women. This has to be strictly followed, my lord. When I am available, when SC women are available, they cannot deviate from the SC women and they appoint some other person, that is the respondent number 3, my lord. 3B, my lord. 3B women, Kannada. Ink page 16, my lord. Under which provisions of law she has claimed 3B women category, Kannada. And she has been dairy chemistry. She has been given appointment in GM women, which runs contrary to roster points. Under which provisions of law, my lord, she has been treated as GM woman and she has been preferred to me. The submission of my friend, if it is taken as it is corrected, my lord, the entire reservation policy will be wiped out.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಹಿಂದೆ ಹೇಳತ್ತಲ್ಲ. Subject wise करता है कि
Vivekanand Tiwari is upheld by the Honorable Supreme Court in 2019, where the issue was university cannot be treated as one unit. If that is treated as one unit, then there will be several departments which may never get a reservation at all. But this is not the case here. This has been upheld by the Honorable Supreme Court. This is a case where university was treated to be one unit. Your Lordship will permit me to say this, read this one. There was no consideration as to why non-interchangeable posts were clubbed in for treating them as a unit. Direction contained in order of Ministry of Human Resource Development did not contain any direction to UGC to make blanket reservation or to treat university as unit. Clubbing of posts for same level treating university as unit found to be completely unworkable and impracticable. In fact, my lords, the Karnataka 2019 report again. In fact, my lords, the notification dated 9th of March 2011 of Karnataka government, that says that this notification is already produced. I will read that, my lords. It says, Karnataka Pashu Vaidyakiya Pashu Hagu Meenugarike Vidyanagala Vishwa. Yes, ready. Please. My lords wanted to have a look at the records, my lords. Your lordships can have it. Yes.
Lord, the undisputed facts, my lord, I belong to SC women category. Among SC women, I am in the top. And I had applied for dairy chemistry. And my lord, as per the notification, as per Annexure C, in page 28, there are 3 posts for SC women in the roster interest anta ತೋರಿಸಿದಾರಲ್ಲ sir, last column ಅಲ್ಲಿ. So that being the case, my lord, the respondent number 2 has been belonging to category 3B. Your lordship may kindly have a glance at annexure B, my lord, in page 19. Provisional list, your lordship got it, annexure B in page 19, my lord, wherein my name appears at serial number 42. Ink page 22 early, my lord, 42 my serial number. Dhavalgi Pallavi, dairy chemistry, SC women. There is no dispute, my lord. And my lord, name of the respondent number 2 appears at 103. Ink page 26. Serial number 103, my lord. Priyanka Kalyan, dairy chemistry, 3B, women, Kannada. Now the submission of my friend is that, my lord, they are embarking on the GO of 1995. Pardon, sir?
Whether the recruitment notification,
ಅದರಲ್ಲಿ ಏನು ಹೇಳಲ್ಲ
ಏನಿಲ್ಲ.
ಏನಿಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ವೈಸ್ ಇಲ್ಲ ಸರ್.
It does not also mention how the reservation is
Yes,
to be
yes, my
applied.
lord. That means discretion has been retained with the university itself, which will give scope for abusing this reservation policy itself.
Yes.
Your lordship may kindly ink page 36 of the affidavit with the documents filed on 29/1/2024. The entire case of the respondents, 29/1/24, my lord, revolving around this GO. It says, my lord, lordship got it, 36 ink page. ಸಂಬಂಧಿಸಿದ ಆಯ್ದ ಪ್ರಾಧಿಕಾರವು ಎಲ್ಲ ಅರ್ಹ ಅರ್ಜಿದಾರರ ಕ್ರೋಢೀಕೃತ ಯಾದಿಯನ್ನು ಅವರು ಯಾವ ಜಾತಿ ಪಂಗಡ ವರ್ಗಗಳಿಗೆ ಸೇರಿದವರು ಎನ್ನುವುದನ್ನು ಪರಿಗಣಿಸದೆ ಕೇವಲ ಅವರ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಮೊದಲನೇ ಯಾದಿ ಎಂದು ಕರೆಯಲಾಗುವುದು. Irrespective of the caste, color, whatever they belong, my lord, there should be preparation of first list. ಆ ಬಳಿಕ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ಸಾಮಾನ್ಯ ಅರ್ಹತೆ ಮೇರೆಗೆ, ಅಂದರೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮತ್ತು ಇತರ ಜಾತಿಯ ವರ್ಗಗಳಿಗೆ ಮೀಸಲಿರುವ ಹುದ್ದೆಗಳನ್ನು ಬಿಟ್ಟು ಇತರೆ ಜಾತಿಗಳು ತುಂಬಬೇಕಾದ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೇ ಯಾದಿಯಿಂದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಎರಡನೇ ಯಾದಿಯನ್ನು ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಎರಡನೇ ಯಾದಿ ಎಂದು ಹೆಸರಿಸಲಾಗುವುದು. ಮೊದಲನೇ ಯಾದಿಯ ಮೊದಲನೇ ಹೆಸರಿನಿಂದ ಪ್ರಾರಂಭಿಸಿ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. That means, my lord, first list will be inclusive of all the communities persons. Second list will be only in respect of GM, other than SC, ST and other backward classes.
Yes.
They will have to prepare the list. Third, my lord, ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ನಂತರ ಮೊದಲನೇ ಯಾದಿಯಿಂದ ಎರಡನೇ ಯಾದಿಯ ಭಾಗವನ್ನು ಹೊರತುಪಡಿಸಿ ಮೂರನೇ ಯಾದಿಯನ್ನು ಇನ್ನು ಮುಂದೆ ಈ ಯಾದಿಯನ್ನು ಮೂರನೇ ಯಾದಿ ಎಂದು ಹೆಸರಿಸಲಾಗುವುದು. ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮತ್ತು ಇತರ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಗುಂಪುಗಳಿಗೆ ಸೇರಿದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ಪ್ರತಿಯೊಂದು ವರ್ಗಕ್ಕೆ ಮೀಸಲಿರಿಸುವ ರಿಕ್ತ ಸ್ಥಾನಗಳಿಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೇ ಯಾದಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಅರ್ಹತೆಗೆ ಅನುಕ್ರಮವಾಗಿ ತಯಾರಿಸತಕ್ಕದ್ದು. Thereafter, third list says it is only in respect of reserved categories. It should be again in the order of merit.
Yes.
They will have to prepare. Now, my humble submission would be, my lord, this is the criteria, that is 3 list will have to be prepared, and as per the reservation points, my lord, that is reservation points which they have produced. ಬಂದಿದೆ. ಇಲ್ಲಿದೆ ಸರ್ ಅದು. They will have to give the appointment. Now, my lord, I will be belonging to third list. If not in first list, I will be belonging in the third list. My submission would be, my lord, if any other person, SC women, first 8 ಅಲ್ಲಿ ಯಾವುದೇ ಸೀಟಿಗೆ, even irrespective of non-reservation of post for any subject, then also I will be standing on the top. It is the reason is that, my lord, your lordship, in page 29 ಅಲ್ಲಿ, first is SC, other, 1 seat.
Yes, please.
Second, GM, other, ST, other, GM, women. Category 1, other, GM, rural, 2A, other, GM, physically handicapped. Thereafter, 9. If any other person in the SC, women has been allotted in the first 8, my lord, I may not be entitled. As per their own document, as per their own GO, as per their own list of this point-wise reservation, my lord, reservation point, I will be entitled for the said post. And very strangely, my lord, how could they convert respondent number 3, who is claiming reservation under 3B, can be converted as GM? And by converting her as GM, my lord, even one point, my lord, one person is changed reservation policy insofar as annexure A2, that is in page 29, is changed, my lord. Entire reservation will be changed. And, my lord, insofar as marks, so-called marks are concerned, my lord, your lordship may kindly have a glance on the ink page 54, my lord. For example, I am giving, my lord, ink page 54
Of?
Adhe sir, affidavit which they have filed, 29-1, my lord. 39,
Yes.
7.37,
Really, serial number?
39, my lord, serial number 39.
Rathod Kumar antide.
Yes, my lord. SC women converted to SC.
Already Rathod Kumar.
Sir. He has been appointed. Just I am trying to persuade your lordship as to how the university at their whims were selecting and appointing persons. My humble submission, my lord. Where is the provision under the law?
Yes.
To convert serial number bande sir. I will show, my lord, 2-3 persons.
That's okay.
So under these circumstances, even assuming as per their own circular, my lord, GO of 1995, at serial number 95, I am the only person belonging to SC, I am eligible.
Yes. Yes, Mr. Senior Counsel.
Yes.
Now, please tell us, for the purpose of preparing this list number 3, what is the reservation that you have followed?
My lords,
What is the
Clause-
roster reservation, roster point
yes,
that you have applied?
yes, I have this entire record notes to show what is the restore point. Clause number 29 of this notification prescribes that the relaxations and concessions for SC, STs, OBCs, PH will be applicable in accordance with reservation policy of the government of Karnataka.
Illide the clause number?
Clause 29, page number 32, my lords will see.
Of the writ petition, annexure
Of the writ
motions.
petition, it's the very annexure C, the recruitment notification.
Clause
Starts at-
29.
Yes, at number
Yes.
20, clause number 29, reservation policy of the GOK and subsequent clarifications or directives issued from time to time to this effect. The first argument was that we are doing it whimsically. That is not so. We are only saying what the government of Karnataka has said, we will have to follow it. And these are not the
Yes.
notifications of the university, they are the notifications of the state. Those notifications, my lords, will find in the statement which was referred to just now.
Along with the affidavit.
I will not read that, my lords, the very same 1995 notification once again. It only says,
Again, what is it? ಇನ್ನೊಂದ್ಸತಿ ಓದೋಣ ಏನು?
yes, page number 36. At page 35, my lords will find the total roster points. Starting from page 36 is annexure 2 to this notification dated 20th June 1995. ಸಂಬಂಧಿಸಿದ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರವು ಎಲ್ಲ ಅರ್ಹ ಅರ್ಜಿದಾರರ ಕ್ರೋಢೀಕೃತ ಯಾದಿಯನ್ನು ಅವರು ಯಾವ ಜಾತಿ ಪಂಗಡ ವರ್ಗಗಳಿಗೆ ಸೇರಿದವರೆನ್ನ ಎನ್ನುವುದನ್ನು ಪರಿಗಣಿಸದೆ ಕೇವಲ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. First is, my lords, all people who are eligible will be listed. Then second is one, ಆ ಬಳಿಕ ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ಸಾಮಾನ್ಯ ಅರ್ಹತೆಯ ಮೇರೆಗೆ ಅಂದರೆ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡ ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳಿಗಾಗಿ ಮೀಸಲಿಸುವ ಹುದ್ದೆಗಳನ್ನು ಬಿಟ್ಟು ಇತರೆ ಹುದ್ದೆಗಳು ಅರ್ಹತೆಯ ಮೇರೆಗೆ ತುಂಬಬೇಕಾದ ಹುದ್ದೆಗಳ ಸಂಖ್ಯೆಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೇ ಯಾದಿಯಿಂದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಎರಡನೇ ಯಾದಿಯನ್ನು ಮೊದಲನೇ ಯಾದಿಯ ಮೊದಲನೇ ಹೆಸರಿನಿಂದ ಪ್ರಾರಂಭಿಸಿ ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ತಯಾರಿಸತಕ್ಕದ್ದು. For example, my lords, if the first list contains all the people who are eligible, and if there are only 30 posts which I have to now fill up today, the top 30 persons in the first list will be taken and they will be appropriately given that particular post to which they belong to, which subject they belong to. For instance, my lords, if there is a person who is an SC, but who is getting into the top 30 in the first list, she will be given and that post will be appropriated for the GM post only, not an SC post, though she is an SC. So that's how, my lords, another SC person would be getting an opportunity. That's how it has been explained in Sabarwal's matter also. And thirdly, my lords, E. ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ನಂತರ ಮೊದಲನೇ ಯಾದಿಯಿಂದ ಎರಡನೇ ಯಾದಿಯ ಭಾಗವನ್ನು ಹೊರತುಪಡಿಸಿ ಮೊದಲನೇ ಯಾದಿಯನ್ನು ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮತ್ತು ಇತರೆ ಹಿಂದುಳಿದ ವರ್ಗಗಳ ಗುಂಪುಗಳಿಗೆ ಸೇರಿದ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ಪ್ರತಿಯೊಂದು ವರ್ಗಕ್ಕೆ ಮೀಸಲಿರಿಸುವ ರಿಕ್ತ ಸ್ಥಾನಗಳಿಗೆ ಸಮಾನವಾಗಿ ಮೊದಲನೇ ಯಾದಿಯಲ್ಲಿ ನಿಗದಿಪಡಿಸಿರುವ ಅರ್ಹತೆಗೆ ಅನುಕ್ರಮವಾಗಿ ತಯಾರಿಸತಕ್ಕದ್ದು. ಫೋರ್ತ್, ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ನಂತರ ಪ್ರತಿಯೊಂದು ವರ್ಗದ ಹುದ್ದೆಗಳಿಗೂ ನೇಮಕಾತಿಗಾಗಿ ಆಯ್ಕೆ ಮಾಡಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಒಂದು ಅಂತಿಮ ಯಾದಿಯನ್ನು ಎರಡನೇ ಯಾದಿ ಮತ್ತು ಮೂರನೇ ಯಾದಿಯಲ್ಲಿ ಒಳಗೊಂಡಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ಹೆಸರುಗಳನ್ನು ಅರ್ಹತೆಯ ಆಧಾರದ ಮೇಲೆ ಜೋಡಿಸಿ ತಯಾರಿಸತಕ್ಕದ್ದು. As I understand, my lords, if there are 30 posts which I want to fill up today, and if there are 50 persons who are eligible, that list will be first list will be of 50 persons. Out of that, my lords, the top 30 will be first chosen as in the second list. And whatever subject they are having eligibility towards, because of their merit, they will be appropriately given the particular post of a particular subject. Then, my lords, in the remaining 20 candidates from the first list, we will have to then find out as per the reservation, whoever, for example, if SCs, 4 SCs are to be given, the top 4 SCs in that remaining 20, those candidates will be given their respective posts. That is how, my lords, we will fill up. If there is no person belonging to a particular category, for example, SC in the remaining 20, then once we will have to wait for the next process only. This is how, my lords, I understand it. In this particular case also, my lords, there are 3 lists prepared. And so far as the petitioner in the first of the writ petition is concerned, the marks.
Give the second list and the third list.
So the one which I had submitted, it contains first, second and third list, all the 3 lists. Yes, yes. First, second and third list, all the 3 lists.
Yes.
That's the record of the university. I don't have. The record of the university. I will submit it, my lord. If your lordships want it to be put on record, I will make copies and then file it. Even I don't carry a copy. That's the record of the university only, directly given to them. I will provide a copy to my.
But ಇಲ್ಲಿ roster point ಎಲ್ಲ apply ಮಾಡಿದ್ರ ಅಂತ ನಂಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. Where have you applied the roster point?
Roster point will not be applied to the particular candidate. Roster point says how many candidates, how many posts will have to be now filled up with a particular category is what has been explained. If your lordships read the 2022 judgment of the Supreme Court, which explains what is R.K. Sabarwal, that is Manohar Parihas judgment, I will supply that also. It says ultimately the purpose of roster is to identify the total number of reservations and to give appropriate opportunity to all the candidates required.
The purpose of fixing this 100-point roster
Yes.
is that
in this recruitment process, my lords, I will have to fill up those points which are now within that recruitment.
For example, if there are less than 100 posts, suppose if there's less than 100 posts, suppose if there's only 50. So you should apply this point.
The first 50 will.
First 50 you should apply. Then the next recruitment will be from the next 51.
Yes, yes.
So that is a
So-
process. Now, whether this roster which is prescribed by the state government, whether it is applied in the present case.
That is applied, that is not even the objection of the other side, that we have not applied the roster points itself.
Hmm.
What they are saying is, the petitioner is a person who is belonging to SC category. SC is a particular category which post is reserved for, reserved for the post of assistant professor. Since I am fitting into that reservation, they should have provided me the opportunity. We are saying, obviously, we will have to provide the recruitment to 4 candidates belonging to SC, to number of candidates to belong to particular category as stated in the notification. But whether this candidate should become the first priority or not is what we are guided by the 1995.
No, the difficulty what I understand is, these are all assistant lecturers,
Yes, assistant professor.
assistant professors. The minimum qualification is a postgraduate in the concerned discipline. This is the minimum qualification. Now, if you want to select XYZ, though there is ABC, XYZ belonging to other category, you will select them.
It cannot.
Though ABC is in a better position in terms of marks, in terms of reservation, you will select XYZ because they belong to general merit. By operating list number 2, you will select XYZ instead of ABC.
Yes.
So ABC will, once they are out of the
Yes.
recruitment, they are out.
The consequence of that is out. As your lordships are saying, I can also visualize this. There will be a person, my lords, I can also make a flip side of that one. There will be a person who is from, say, JM category, who has secured only 50% of marks. There is a person who is from SC category, who has secured 60% of marks. The post is now open for general competition. Lords, the general competition, in that general competition also, the person who has got 60% of marks, higher than the general candidate who belongs to SC, he or she will be given that appropriate post. That's how it will happen.
No,
The same way, my lords, if, for example, there is a candidate who is, for example, in this case only, in the case of dairy chemistry subject, there is a candidate who is respond number 3 here, who has got around 42 or 43% of marks. There is a candidate, and that person belongs to some other category, not to SC. There is a candidate who is petitioner who belongs to SC and has got 39% of marks. Because, my lords, the candidate who is getting the higher marks than the petitioner is coming in the first list, in the second list rather, as per this rule, the meritorious list. That person will have to be given whatever discipline that person has applied for. Now, by virtue of that, the petitioner who might have got, my lords, higher marks than any other SC in the other discipline, that person will lose the employment. That's the very harsh reality.
No, in fact, given to me, I would quash the entire recruitment itself, because it gives rise to all kinds of wrangling.
Yes,
But since you're not made all of them as parties, I don't want to go into that question. The question would be, even if you assume whatever you say is correct, now if this roster point had to be applied, 3B was never there.
It is.
3B was never there.
It is not. We have not
3B,
given any reservation to 3B as such.
respond number 2.
How respond number 3 or 2, whoever it is, my lords, he is fitted as a general candidate merit. He comes in the merit list, not because of 3B.
Then why do you fit him in 3B?
We don't fit him in 3B. He applies it as he is saying that I belong to this
So
category.
therefore, don't appoint him in 3B category.
I have not appointed him in 3B category. I have
That is what he
appointed,
says.
kindly see that. I have appointed him in GM category, not in 3B, merit list.
Illi the selection list illi.
Yes, I will show that. The very list which your lordship my friend has pointed out, that itself shows, the argument is that why a 3B candidate is converted into a GM. That is the argument. That is because the government of Karnataka notification mandates that whatever category you might be belonging to, if you come into the merit list first, then that is to be treated as a general post only.
Illi the.
Yes.
Pardon?
First list, Salem 33,
Bill number?
33, second page nalli,
In the first list,
in the first list.
that conversion,
33.
34, sorry. Priyanka.
Priyanka Kalyan.
Yes.
How much has she scored?
46.97.
Ah,
She applied as a person under 3B WK. But what is given to her is GM. And because she is a woman, my lords, we have appropriated that post as GM women now.
hmm.
We are not treated as her, no reservation to that particular category.
What, how much has the petitioner scored?
39,
Earlier, serial number?
just
Nanda, sir.
39, that is, my lords. I have the list of my comparative list of dairy chemistry here. If your lordships permit. 39.97 is the petitioner and 43.47 is another respond number 3. Another third person is only 17.87. By virtue of this, my lords, the only anomaly is, which is unavoidable, that there might be a person belong to some the very same SC category, but in a different discipline, who might have got lesser marks in that discipline and lesser compared to the petitioner herein. But still, my lords, there is one person competing and having better merit in this discipline. Therefore, this person will not get it. That's the only harsh reality which a more meritorious in the SC category will be losing.
But ಇದರಲ್ಲಿ category 3B ಅಂತ ತೋರಿಸಿದ್ರೆ ಇದರಲ್ಲಿ.
ಅವ್ರು ಅಪ್ಲೈ ಮಾಡಿದ್ದು ಯಾವ category ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ ಅದು
Selection,
at the end of it, your lordships will see.
selection committee report sheet for the post of assistant professor.
How?
You don't treat it as GM. What is it?
It is treated, converted as GM on birth. That is a separate, that is only selection committee's report. But finally, that is only a comparative chart given, who only tell what are the facts that they have, that was brought before them. The provisional selection list will show that this respondent number 2, that is this is the committee, my lords, who is looking into all that.
But the final selection list 3B ಅಂತಾನೆ ತೋರಿಸಿದ್ರಲ್ಲ.
My lord, my submission, my lord, is in page 36. They will have to prepare 3 lists. It doesn't mean that my lord, the first list should be appointed first.
No, I understood.
Please.
ಈ selection list ಅಲ್ಲಿ page 16 ಬನ್ನಿ writ petition.
Writ petition 60, yes.
So she is treated as 3 GMW na?
GMW, man. 3B, GMW.
Category applied, allotted category GMW.
Yes.
But the kindly see, my lords, if this was the problem here, instead of the petitioner being an SC candidate against a 3B who is converted into GM candidate, if it was SC candidate from dairy chemistry versus another SC candidate of some other subject. My lords, the meritorious candidate, even if the petitioner is more meritorious than that candidate, she should have given way for the other candidate. That's how the harsh reality is, my lords, with regard to the notification.
Brother, this is when this gives rise to all kind of favoritism.
Favoritism is not possible now, my lords, because of the legislation. It was possible if, my lords, your lordships would say the other way around, it was possible, quite possible that I could have made somebody to fit into the merit list and say that I am choosing them.
No, for example, I mean, as I have understood, radiology department, anatomy, pathology, ಈ ತರ 4 ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದ್ರೆ radiology department will come number 1. Any department, pathology, anatomy, ಹಿಂಗ್ ಬರ್ತವೆ. Now the selection committee wants to select one person belonging to some community. He will say that SC, first I'll operate the reservation, I'll give the post of anatomy assistant lecturer, assistant professor to a person belonging to general scheduled caste. How do you operate that? Unless you say one post in anatomy will be reserved for scheduled caste, one post in so and so. Why not?
That is impermissible. If I will kindly visualize this. I will now say that radiology will have one post belonging to reserved for SC candidate only. And then once if anatomy is reserved for, say, for ST candidate, another subject, my lords, is reserved, pathology is reserved, is open for competition. Then, my lords, a person who has studied pathology, who is SC, will never get a result, will never get a posting at all.
Oh, then the same.
That's
case-
why, my lords, all these posts, all these subjects together are treated as one cadre and one post. And that's how, my lords, the best of the candidates among all those. I may apply as anatomy student, I may apply as pathology, or I may apply as radiology student. If I am coming in that merit, whatever discipline is I belong to, that will be first.
You cannot apply as anatomy, pathology, and
I cannot, my lords.
you
this
have to
is-
have a subject discipline.
There are, my lords, 3 persons who are applying under 3 different disciplines. And my lords, out of that, if I have to only choose 2, I will have to first choose the top 2 in merit. And if they unfortunately belong to that 2 subjects, for which the third candidate, or there is a third candidate who is also applying for the same, my lords, that person has to give way for the other one. That's how it operates here. I will read it once again. I will read the notification once again, how this entire thing operates. If I give reservation subject wise to all these posts, then, my lords, there is no possibility of one particular category being filled up in particular subject. That is more probable. That's why, my lords, just the judgment in the case of R.K. Sabharwal, right from that till recent, my lords, that has been followed, saying that you cannot subclassify a particular post into different disciplines and reserve that subclassification only. Vivekanand Tiwari is a judgment, my lords, where the university as a whole was treated as one unit by the Ministry of Human Resource and Development. That was not permissible, obviously.
ILR 1986 coding. ILR 1986, Karnataka 255.
30, 43, 43. There are instances in this very recruitment, my lords, where a scheduled caste at serial number 17, my lords, will see one person named Venkatgiri, I can see here, from the subject veterinary surgery and radiology, is given the post to fit in GMPH. He is scheduled caste PH, but he is treated as a general merit physically handicapped person because he has got higher merit than the other categories. Now, my lords, once this discipline is exhausted by the recruitment from the merit list, then, my lords, nobody else can compete there. Even whether that other next person is in the belonging to a category or in the open competition, that person loses the entire competition. Now, my lords, what we can give is, ultimately, your lordships, the scrutiny before your lordship should have been like this one. Whether the 4 SC candidates are given recruitment in this entire 59 posts or not. It cannot so happen at all that, my lords, each candidate who is belonging to SC should be given some post because he or she is having higher merit. That test is not possible at all. The only scrutiny will be the total number of reservations are exhausted or not. From the 59 posts here, 19 are to be, my lords, allocated to different reservations.
Your lordship, my submission of my friend, your lordship may kindly have a glance. The persons, his submission runs contrary to in page 16 and 17, my lord. Even persons who have .43.
The division bench has said reservation to be subject wise, not cadre or unit wise.
Not kidding.
And selections to be regulated on that basis, even if number of posts in particular subject are very limited or is only one.
Public. If I am not wrong, my lords, I assume, my lord, this principle has not been accepted anywhere, rather expressly.
No, this, in Vivekananda Tiwari, they have accepted it. They have accepted it. Even in Vivekananda Tiwari, which is upheld by the Supreme Court, yeah, 2000.
17. Supreme Court is 2019. Allahabad High Court is 17.
Even in the Supreme Court in 2000.
In fact, my lords, I remember one matter which I argued before your lordship sitting, heading a division bench here. Your lordship said is categorized, that pertaining to the Gulbarga Institute of Medical Sciences.
It was, ಏನ್ ಮಾಡಿತ್ತು?
Gyms ಅಲ್ಲಿ ಇದೇ ಸೇಮ್ anatomy pathology ಗೆ subject wise reservation ಕೊಟ್ಟಿದ್ದಿತ್ತು. Your lordship said if that happens, then that will run contrary to the very the scheme of reservation. I will also, I am very sure, my lord, that.
No, but what I have read and what I have understood is that there should be subject wise reservation.
If my lords, taking further, my lords, that.
ಎಲ್ಲಿದೆ ಇದಿದೆ Vivekananda Tiwariದು Supreme Court judgment ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, it is, I don't have a printout, not it is accepted in, upheld in 2019.
2019.
ಹೌದು.
ಇದೇನ್ರಿ?
Justice Indra Banerjee and ಅಷ್ಟೇ 2019.
2019 ಇದೆ ಅಂತ.
But my lords, till now, my lords, I was under the impression that the only argument, this is not the argument that it should have been subject wise. That is not their argument.
I'm just wondering whether should we because the system, if it is continued in the university, it will run counter to Article 16.
Can there be, your lordships may have that scrutiny. Is there a possibility of a favoritism in this kind of a situation? Well, let me explain, my lords. There will be one, for example, if your lordship say that not the entire assistant professor's post as one unit, but bifurcated subjects. Kindly see, my lords, the notification, how it will work in future. Annexure C says the total number of posts for the subject named veterinary anatomy. I am reading at page 28 and 29.
28, huh?
28 and 29 notification. This is a recruitment notification.
Ah.
No, there are totally 58 posts and the vertical and horizontal categories together will be around 28 or 29. Now, my lords will see, for example, veterinary anatomy, number of posts in the year 2022 are to be only 2 are to be filled up. If my lords say that this should be, now reservation should operate in this. And my lords, 100 reservation points have to operate in this.
No. See, each post or subject, veterinary, ಇವಾಗ veterinary anatomy ಎರಡಿದೆ. ಎರಡರಲ್ಲಿ ಒಂದು ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಅಥವಾ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ವುಮನ್ or maybe general merit or 3A, 3B. Similarly, if you apply that roster and if you treat each subject as for the purpose of reservation or for fixing the general merit, then there will be certainty.
I will
You'll operate the reservation. You'll also make sure that the recruitment is certain. For example, if I were to apply, I have a qualification veterinary anatomy. I belong to scheduled caste. Now, I'm sure my application will be only for veterinary, but everything is so undecided.
Now, my
ನಂಗೆ
lords,
ಸಿಗುತ್ತೋ ಇಲ್ವೋ?
how? You first, my lords, one person should fall in the merit list. Only thereafter, my lords, the certainty starts. If one person is falling short of the merit list, for example, in this particular petitioner's case, There is respondent number 2 who got higher marks than the petitioner for dairy chemistry. Now dairy chemistry, my lords will see there is only one post, that serial number 21. There is only one post. For example, if I say that this is now reserved for SC only, if the petitioner gets this SC, my lord, then for the next time, dairy chemistry cannot be reserved for anything at all.
Why can't?
How will
Why
that?
can't? See, to operate, for example, you already have a reservation in that particular department. You already have a reservation. You can open it up for general merit, that particular department.
After my lords, one post person retires.
Not retires. For example, if there's a vacancy in the Department of Anatomy, Veterinary Anatomy, there are 2 posts. Now, suppose, for example, you say one for general merit, another for scheduled caste. Now, if you want to, if the roster point is already applied and exhausted, then you have to go to the next cycle.
To exhaust that, my lords, kindly see that the total number of the cadre strength in this will not be beyond a certain.
Correct. So
number.
next ನೀವು ಎಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಆಗಿರುತ್ತೆ ಅಲ್ಲಿಂದ ನೀವು ಶುರು ಮಾಡಬೇಕು.
Subject wise ಮಾಡ್ತಾ ಹೋದ್ರೆ to exhaust that 100, it is impossible at all.
But we have to see.
That has been explained in few judgments. I will explain. Since my lord, the primary attack was not that it should have been subject wise. I did not bring those judgments. I have gone through a set of
Oh, yeah,
judgments.
then just go through it because I am sure that it should be subject wise.
Subject wise, my lord, it is a fact, my lord, and the law says that it should be subject wise. Even GO has been, UGC has issued the circular also, my lord, that it should be subject wise. The problem with me is that, my lord, the notification which has been issued by the university, I have participated in that. The technical problem with me is because I have participated and I want that it should be
Madam,
implemented.
Supreme Court confirm ಆಗಿದೆ. ಇದು ವಿವೇಕಾನಂದ ತಿವಾರಿ ತೆಗಿರಿ ಯಾವ್ದು ಸಿಕ್ತಾ?
My submission is, my lord, since I have participated, I want that the notification which has been issued by the university, it shall be complied with. Roster points they themselves have filed. And that serial number 9, I am there. If the submission of my friend is accepted, without the reservation and roster itself will go.
ಅದ್ ನೋಡಿ ಹೇಳಿ ಸ್ವಲ್ಪ.
Please.
Subject wise reservation.
In fact, my lord, it should be subject wise only. Fairly, I am
Go through it.
submitting, my lord. But the thing will be, since I have
Let
participated.
us not commit a mistake in glossing over a violation of Article 16.
It is
Let us
there,
not
my lord.
gloss
It is
over
there.
Article 16.
The technical problem is, my lord, with me. I have participated. After participating, there are some judgments, my lord. After participating, I may not question the notification.
Right.
That I leave it to your question.
That is okay. But then ಅದೇ ಹೇಳಿದ್ನಲ್ಲ.
ಆಯ್ತು.
Suppose if somebody tomorrow questions the notification itself.
Sir. That will
ground
go.
On the ground that it is violative of Article 16, there shouldn't be a judgment in this case.
Yes.
Where we uphold this
Notification. Yes, yes.
So
I
let
will-
there be a clarity on what we are doing.
Yes, my lord.
Note ಸ್ವಲ್ಪ note ಹೇಳಿ.
Apply.
Also have to look at, of course, R.K. Sabarwal. Here, which is
those.
said. Okay.
That's my record that the records are.
We can produce an extract if you can.
Yes, an extract.
Except we have John Malone.
Extract ಕೊಡ್ತೀವಿ.
Yes, ma'am. Extract.
Copy serve
Copy
ಮಾಡ್ಬಿಡಿ ಅವ್ರಿಗೊಂದು.
for-
Please furnish a copy. The learned counsel for the respondent number 3 na.
Yes, ma'am. Respond
One,
number
One university.
one, Malone, one and
Learned counsel for the respondent number 1 has placed on record
respond number 3 private.
Next to serial.
an extract of the list number 1,
1, 2, 3.
first list, second list and third list
Yes.
prepared as per the direction of this court dated so and so. Memo ಕೊಟ್ಬಿಡಿ.
Please,
Memo.
please, please.
So the same is taken on record. Please serve a copy to the other side.
Please.
ಯಾವತ್ತು ಬೇಕು, when do you want it?
Any day.
ನಿಮ್ಗೆ ಹೇಳಿ. I am ready every day, whether you will be ready every day.
I am ready.
Next week,
Any day, any convenient day which is convenient to them.
next Wednesday.
Next week.
Wednesday, ಸುಮಾರು ಕೇಸ್ಗಳು ಪೋಸ್ಟ್ ಆಗಿತ್ತು ಸರ್.
ನಾವು ಸರ್ವಿಸ್ ಮಾಡಿರೋದು ವೆನ್ಸ್ಡೇನೆ.
On that day, it may or may not reach.
It will reach.
Please, apply.
Ready ಅಷ್ಟೇ.
Please. Interim order was there.
Interim order is extended to the next date of hearing. Yes.
Great.
Along with memo, I will put in the registry, Malone.
ಕೊಟ್ಬಿಡಿ.
by serving the copy.
ಅಲ್ಲ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ, ನಾವಿಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ, ಮೆಮೊ
Yes,
ಕೊಟ್ಬಿಡಿ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ
ಈಗ
ಕೊಡಿ.
ಒಂದು
ಇಲ್ಲೇ ಕೊಡ್ರಿ. In the paper.
ಮಹೇಶ್ ಪಾಟೀಲ್.
My lord, I appear for petitioner's counsel. I appear for petitioner's counsel. Earlier, these 4 petitioners approached the Honorable High Court when they were.
ಲಿಯಾಕತ್ ಫರೀದ್ ಉಸ್ತಾದ್.
Earlier, these 4 petitioners were approached this honorable court when they were suspended during the COVID period. And as per the order of this court, my lord, page 22. Page 22, para 2, my lord. During the, and the people, their suspension was revoked and they were rejoined the duties. But however,
Please
court
read, you said para 2, then you're
Yeah.
jumping to something.
No, para 2, my lord. During the course of this proceeding, learned counsel for the petitioner has contended that the petitioners are ready and willing to cooperate in the inquiry, and that regard, the petitioners were directed to file affidavit. Learned counsel for the petitioner submits that as directed, all the 4 petitioners have filed separate affidavits stating that they would cooperate in the inquiry provided they are permitted to continue to serve by recalling the order of suspension. The learned counsel for the respondent university was requested to secure instructions from the respondent university and make submission. Learned counsel for the respondent university on instruction submits that the orders of suspension will be recalled by the university and the petitioners will be permitted to continue as faculty members. But the inquiry shall proceed against the petitioner. Learned counsel would further submit that since there is only an in-charge register, the petitioner should not be permitted to agitate that. In-charge register is not competent to issue article of charges and to direct the inquiry against the petitioner. Now what happened, my lord, after 2 long years, inquiry has not been continued. And even now, after this petition, disposal of this petition, the next pay commission has come into existence. The remaining staff members have got the salary hike and increments as per the pay commission. Because of the pendency of inquiry, these petitioners were not considered. My humble submission is to direct the respondent private university to conduct the inquiry within a stipulated time and to consider the this thing, hike in the as per the
Why are
7th
you
pay
denying
commission.
the pay scale?
Lord,
Why are you denying the pay scale?
Lord, in this case, my lord, I need some instructions from the client, my lord, still.
Instruction, the order itself is very clear. Why are you denying? ಆಯ್ತು ಎನ್ಕ್ವೈರಿ ಇದ್ರೆ ಎನ್ಕ್ವೈರಿ ಮುಗಿಸಿ. ಪೇ ಸ್ಕೇಲ್ಗೂ ಎನ್ಕ್ವೈರಿಗೆ ಏನು ಸಂಬಂಧ ಇದೆ? ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ, ಯು ಆರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟಿಂಗ್ ವರ್ಕ್ ಫ್ರಮ್ ದೆಮ್. So you pay the pay scales, whatever is prescribed. If you want to conduct the inquiry and conclude it early, do it. If you want to keep it pending.
Inquiry is there, my lord, therefore.
Fine. ಎನ್ಕ್ವೈರಿಗೂ ಪೆನ್ಷನ್ಗೂ ಅಥವಾ ಅದಕ್ಕೆ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಪೇ ಸ್ಕೇಲ್ ಹೆಂಗೆ? Pay scale, how can you deny the benefit of pay scale just because some inquiry is pending? You are extracting work for them. You have to pay equal salary for everybody who is working. Inquiry ಮಾಡಿದ್ರೆ ಬೇಗ ಮುಗಿಸಿ, ಎಷ್ಟು ದಿನದಲ್ಲಿ ಮಾಡ್ತೀರಾ?
I need
Within how many days will you conclude?
not for that.
Huh?
Any.
In the meanwhile, you give the pay scale, whatever enhanced pay scale. Pay commission, ಇದ್ರ ಪ್ರಕಾರ ನೀವು ಕೊಡಿ pay scale.
I'll have it on Monday, my lord, I will take instruction and will.
And counsel for the respondent seeks time. List on. ಯಾವತ್ತು? ಲಾಯರ್ಸ್ ಎಲ್ಲ ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕು, ನೀವು ಬೇಗ ಡಿಸ್ಪೋಸಲ್ ಬೇಕು ಅಂದ್ರೆ.
I'm not.
So if you want disposal, come ready to the court.
Please.
Rathod, Subhash Chandra.
Paper for the respondent number 6, my lord. Kindly, it may be taken on next week, my lord.
There is no representation for the petitioner. List on date could. Hema Kulkarni. Same order. Kadlur Satyanarayana.
ಇವಾಗ ರವಿ ಪಿ ಪಾಟೀಲ್ ಸರ್ ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಅವ್ರ ಹೆಸರು ರವಿ ಪಿ ಪಾಟೀಲ್ ಸರ್ಗೆ ಡೈರೆಕ್ಟ್ ನೋಟ್
WP?
ರವಿ ಪಿ ಪಾಟೀಲ್ ಸರ್ಗೆ
48.
ಅವ್ರ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದಾರೆ.
ಯಾರು?
ರವಿ ಬಿ ಪಾಟೀಲ್.
ಯಾರಿಗೆ?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
3.
ಆರ್ತಿ ಪಾಟೀಲ್ ಅಂತಿದ್ದಾರೆ. ಯಾರ್ರಿ ರವಿ ಪಾಟೀಲ್ ಕೊಡ್ರಿ, ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೊಡ್ರಿ ಇಲ್ಲಿ?
Respond number 194 madam.
Mr. Kadlur does not appear. Mr. Ravi B. Patil is directed to accept notice for respond 1 and 4.
Yes ma'am.
Office is directed to delete the name of Kadlur Satyanarayana Charya and show the name of Mr. Ravi B. Patil. Counsel for the petition is directed to serve copies of the writ petition to Mr. Ravi B. Patil. This on date put after 2 weeks.
Please.
After 2 weeks. Mahantesh Patil. Rathod Subhash Chandra Busare. Rathod Subhash Chandra. There is no representation for the petitioner and respondent number 1. List on date. All of the matters some other.
Serial number 58 will be taken next week.
My lord, serial number 53, my lord. I am Shantraju appearing for this petition, my lord.
Take whatever date you want, but please come ready on that day.
Kindly post it for the final hearing, my lord. It is only a promotion case. Next Wednesday, final hearing ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ. Next Wednesday, final hearing ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ. I'm going to appear in person and make submission. In the meanwhile, I'm requesting you to extend the interim order of stay, my lord.
All interim orders will be extended. You did not mention.
Yes,
Serial number 52.
My lord, submit 72. My lord, submit
71, my lord.
serial number.
ಸರ್ 71 ಅಂತ ಚೌಕಾಸ ಅದನ್ನು ಕೇಳಿಸ್ಕೊಂಡ
ನಾನ್ ನಿಮಗೆ ಹೇಳಿದ್ರೆ ನೀವು ನಮಗೆ
ಹೇಳ್ರಿ ಜೋರು ಕೇಳಿಸ್ತದ.
What was our serial number 53 date? What of our serial number 53 date?
ಹೆಸರು ಅಭಿಲೇರು 29 55 next week.
Serial number 53, what of sir date?
Next week. Yes.
What is the serial number 53? Date?
Serial number 66. 66 serial number.
What officer?
You idira? Number 67, V. Srinivas. Arjun. Number 70, Syed Fayazuddin.
What is the 53 date?
ಇಲ್ರಿ ನಾವ್ ಹೇಳೋ ಮಟ್ಟ ಅರ್ಥ ಮಾಡ್ಕೊಡ್ರಿ ಓನ್ಲಿ ನಮಗೆ ಬುಧವಾರ ಬರುತ್ತೆ ಸೋಮವಾರ ನೀವು
ಕೋರ್ಟ್ ಆಫೀಸರ್
ನೀವು ಬೆಳಿಗ್ಗೆ ಮುಂಜಾನೆ ಮೆನ್ಷನ್ ಮಾಡಿ ತಗೊಳ್ರಿ ನಾವು ಕೊಡಕ್ ಬರಲ್ಲ ಜಿಎಂ ಇದೆ ಜಿಎಂ 20ನೇ ತಾರೀಕು ತಗೊಳ್ಳಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್
21 ನಂಬರ್ 71
ಕೋರ್ಟ್ ಆಫೀಸರ್
tomorrow ನೋಡ್ರಿ ಮೇಡಮ್ 69 72
Yes, sir. Sir, any short date?
ಹೇಳಿ ಸರ್ ನಿಮ್ದು ವಿಸಿಎಲ್
Serial number 72, sir.
ವಿಸಿಎಲ್ ಹೇಳ್ರಿ ಯಾವ್ರು
Sir, serial number 66.
ಯಾವಾಗ
72. Sir, ನಾಳೆಗೆ ಹಾಕಿದ್ರು ಅಡ್ಡಿ ಇಲ್ಲ. ಅದು ಪರೋಲ್ ಮ್ಯಾಟರ್ ಇದೆ, ಅರ್ಜೆಂಟ್ ಇದೆ.
ನಾಳೆ ಬರಲ್ರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ
Sir, 72 21st ಇದೆ, sir.
ಬರುತ್ತೆ 20th 20ನೇ
ಸರಿ
ತಾರೀಕು
ಸರಿ ಆಯ್ತು. Sir, serial number 72 21 ಇಡ್ತೀರಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 72 21
ಹಾ.
ಹೇಳುದ್ರಿ
Serial number 53. 21 ಕೊಡಿ ಸರ್.
21 1
20
Sir, serial number
53.
ನಿಮ್ದೆಷ್ಟು ಸರ್
ಸರ್ 53.
ಹಾ
53. ಸರ್
Sir, 72 ಏನು ಕೊಟ್ಟ ಡೇಟ್?
53
ಸಾಹೇಬ್ರೆ.
ಸರ್
Sir,
21
72
ಸರ್.
ಏನು ಕೊಟ್ಟ ಡೇಟ್?
ಸರ್ 21.
ಸರ್ವಿಸ್ ಅಲ್ಲ 53 ಅಲ್ಲ
53. ಸರ್ 53 ಡೇಟ್ ಸರ್.
ಹೇಳಿದ್ರಿ 22
ಥ್ಯಾಂಕ್ ಯು.
Sir, 72 ಏನು ಕೊಟ್ಟ ಡೇಟ್?